At the Road Accident Fund, all formally at the Road Accident Fund. So welcome back to Parliament. Let's maybe start with, oh sorry, Honorable.
No, good morning, colleagues. Thank you, Chair. No, Chair, I want to register a displeasure I observed yesterday before the board come in. That one of our permanent residents here from the Hartnell group intimidated Attorney Tia yesterday after their submission and started aggressively asking them questions and answers on things they have submitted to Parliament. That practice has to come to an end. We call people here for investigation, for us to get information. They are not going to withhold information because we have people whose names are appearing within the mess that is in RAF, and that the people that come here must not say anything about them because they made themselves to be permanent residents of this committee. So anyone who comes here is not going to be intimidated by no one. Please, Chair, protect our witnesses. Thank you.
Thanks very much, Honorable Mendes. So I wasn't aware of that incident. What we will do is reach out to the witness. I will ask him to send me a written submission, and then we'll take it from there, if that's okay. Thank you very much for raising that. So let us start with the swearing in, and then I will just do an introduction to assist our witnesses with their initial opening statement or presentation, and then we will go straight to questions thereafter. Ms. Ibrahim.
Thank you, Chairperson. Good morning to yourself and everyone else present. Good morning, Dr. Mabuya, Ms. Francois, Ms. Msibi, and Mr. Nyama. You've been invited, subject to the provisions of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, to appear before the Standing Committee on Public Accounts to provide information in relation to the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or a period of imprisonment not exceeding 2 years. Chairperson, the former board members have indicated that their preference is to take an oath. I'm going to ask them to please raise their right hand and repeat after me. I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God. Thank you, Chair. The witnesses are now duly sworn in.
All right, thank you very much, Ms. Ibrahim. So by way of introduction, I'm just going to go through why we're here and some of the key issues that we want to discuss today. And I'll also address some procedural matters. So the word inquiry can get worrying. So we don't see this as a trial. This is enhanced oversight by the committee. It is not our intention to try and find anyone guilty. Hence, there is no need to bring legal representation here to these proceedings. I think the committee understands that there are long-term systemic issues at the Road Accident Fund, which have gone on for predating all of you. And throughout those years, things have gotten better, gotten worse, etc., etc. And what we are trying to understand primarily in your capacity as members of the board, is some of the thinking around some key decisions, which I will go through shortly. We have asked and received from the Road Accident Fund various documents, minutes of board meetings, etc., etc. That being so, it is still not the same as being in the discussion and understanding what the discussion was and what therefore informed the decision that was taken. There might also be instances where it appears that something is a big deal, and upon hearing the answer, it turns out to be not, right? I can remember, for an example, where we asked why management wouldn't tell us where the funds were invested, the surplus funds, which became a big issue. When we're given the answer, which was literally 15 seconds, the answer was sufficient, and the answer could have been given a year and a half ago, and it wasn't given, and the thing became a bigger issue than it needed to be. I'm using that for illustration to say the reason it's important that people share with us what information they had at their disposal, what the discussion was, and therefore what informed the decision. Then the members of the committee can have a more informed discussion around those issues together with the board. I am going to highlight some key issues. The list might not be exhaustive, but I'm going to highlight some key issues so that we also assist you in terms of how you think about your participation in the discussion. And these are not in order of importance. The first, for instance, is the decision around the disbandment of the panel of attorneys. We are not asking whether you should have done it or not. Management and boards are there to take decisions, such decisions. What we are asking is whether the decision was properly considered and implemented in light of what has since transpired. That is one example. The second example is the decisions around direct claims, because I'm sure you've seen the members of the committee unanimously. I haven't had anyone dissenting. We all want a short, efficient, frictionless process where if someone does not need to go to court, please don't go to court, settle the thing and it's done. And then we find out that there actually were several decisions to discourage the practice, which contradicts what we hear in the public domain. The public therefore needs to understand why the contradiction, what actually happened, etc. So that would be the second example. The third example, and what I'm about to say on this is really important, is around the decision to change the accounting policy. We are not interested in the technicalities of the issue. We are not here to relitigate, the different schools of thought. What we are interested in is the process of decision making, especially in light of what we have now been told. For example, we did this on the advice of PwC. PwC come here and say, absolutely not true. Right, now you ask yourself as the committee, what? We thought you guys advised them. What is this now? How was the decision taken therefore? Right, so it's just important to narrow that, so that we focus on the issues. Then there is the issue of the expenditure on labor-related matters, using lawyers to initiate, using lawyers to chair, litigating endlessly, employees winning a case all the way until the labor appeal court, and still not being reinstated, and the Road Accident Fund is spending money. Now, we also then try and understand, but why would that be the case? Did the board know? Were they okay with it? And so on and so forth. So what I'm trying to say is we recognize as the committee that you were not there every day as board members. You were non-executive board members. Notwithstanding, the board is the accounting authority at the Road Accident Fund. And I think if my recollection is correct, the executives are not members of the board, if I remember correctly, which means you are on the hook then for the ultimate decisions, notwithstanding the fact that you are not in the office on a day-to-day basis. So what I'm going to do, because I don't need to outline everything, there's been correspondence between us, is that in the same way that we did with NUMSA yesterday, because there are basically 3 terms, so we had allowed 20 minutes yesterday for 2 people, we'll allow 30 minutes. You have furnished us with a presentation and a statement. My suggestion is that you don't go page by page. You focus on the issues or any other issues that you believe are important that I may not have mentioned or the committee hasn't mentioned. And after that, we will then go through questions. The members have a copy each. What would assist is that if whoever is speaking is on a particular page, simply say to the members, I am now on page X of the statement. So that as you summarize, the member is also able to read for themselves, which then helps us with an efficient process. Thank you very much. I will then hand over to you. My suggestion is that maybe you first introduce yourselves so that the terms are also clear, because I also don't want us to mix up terms where we ask Ms. Msibi something that Ms. Francois should be answering and so on. Thank you very much. I'll hand over to you.
Thank you, Chair. Thank you, Honorable Chair. My name is Dr. Nomonde Mabuya-Moloele. I am here in my capacity as a former Deputy Chair of the Road Accident Fund. My tenure, first I was in the interim board, which was from prior to 2019. Then I was appointed full-time into the board on the 5th of December, 2019. So I have served that term. That was my first full term, and my last term was when we were dissolved. That was my tenure. Thank you, Honorable Chair.
Sorry, Chair, I didn't quite hear the dates. I think it's very important for us to be absolutely clear as to when the various people serve on the board. Sorry, you said that you joined in 2019.
2019, yes.
Until when? Sorry.
Yeah. So
Until I think it was 2020, until this board that is in place.
So for 6 years, effectively.
yes,
Yeah, thank
that's
you.
correct.
Thanks.
Good morning, Honorable Chairperson, honorable members of the committee. My name is L Francois. I joined the RAF Board on the 5th of December 2019 as an ordinary member. And then from 1st of October 2023, I became a chairperson until the 18th of July 2025. Thank you.
Good morning, Honorable Chair. Good morning, honorable members. My name is Tembelihle Nkosazana Msibi. I joined the board on the 5th of December 2019 till the 30th of September 2023. When I joined the board, I was the deputy chair, and the next year in 2020, July, I became acting chair, subsequently then became full chairperson. Thank you very much.
Good morning, Chairperson. Good morning, honorable members. Thanks for the opportunity, Chair. My name is Moses Nyama. I started serving on the Road Accident Fund, July 2018, appointed as an interim member of the board by Dr. Honorable Blade Nzimande then. I served as the chair of RMC, which is the risk committee of the board. I also sat as the member of OPSIT. Subsequent to that, effective the 5th of December 2019, I was reappointed permanently by Honorable Fikile Mbalula, then the Minister of Transport. I became the chair of OPSIT. I became the member of Audit Committee. I was also the member of RGA Committee, which is a subcommittee of the board. Furthermore, I was reappointed as the non-executive director on the 16th of September 2023 by Honorable Minister Sindise Chikunga as the Minister of Transport. I continue to serve on the OPSIT as the chair. I also continue to be the member of the audit committee. I also continue to be member of REGAL, which is Risk and Actuarial Committee. And then on the September, we lost a member or chair of audit committee resigned. I was asked by the board to temporarily step in. I served in that role for a period of 9 months. Thank you, Chair. I also wanted to just add one or two things just in terms of the affidavit of the members. I wasn't able to be part of it. I understand that they have submitted, but I decided to present myself here as a witness and answer whatever question is before me. Thanks for the opportunity, Chair.
Thank you very much. I just want to be sure so that you can follow the proceedings. You do have a copy thereof anyway, of the statement by the board chairs right now, so that you can follow the proceedings.
Unfortunately, I don't
Okay,
have, Chair.
no, let me give you mine so long because I've got electronic copies. Thank you very much. I don't know who's going to speak amongst you. Is it all three of you? So, sorry, Honorable Atkinson.
Sorry, Chair, and yeah, thank you to all four board members who are here. How many people didn't come? How many board members should actually be here today?
No, we invited the specific board members. Yes, nobody declined.
Honorable Chair, if maybe we can start with the presentation. We want to just highlight the background. That's the first part. But the second part, we will then go straight into the AGSA matter. We won't be presenting all the slides because I think you've guided us in terms of what is important. You want to understand our decision-making process, and I think that's what we'll do. So the first part, I'll allow Ms. Msibi just to outline the part that is important in terms of our guidance, the prescripts of the law, what we followed in the best interest of RAF. As soon as she's done with 2 or 3 slides, then we'll allow Moses just to talk on the AGSA matter. I will specifically speak on the issues of HR, the issues of how we made decisions, and then we'll also touch on the issue of default judgments. So we will each have a session. Thank you, Honorable Chair. I don't know, is it projecting?
Good morning, Chair. I'm just questioning if it's going to be projected or not projected.
Yes, it's supposed to be. Did you get the adapter? No?
No, we didn't get the adapter, but what we did, we sent it to Ntombi to make it easy for her to be able to present it for us.
Sorry, can we get them a laptop? Whose laptop can we use? So my apologies. So my suggestion is that all the members have got the presentation. I don't want us to be delayed any further.
Okay.
So just refer to the appropriate slide. My assistant will fetch the adapter for the Mac in the meantime. So let's get going so far. Please say which slide you are on in each instance.
Okay.
Thank you.
Okay, thank you, Chairperson. Can I go ahead? Okay, thank you. Members, I would just ask you to go to slide 3. The Chairperson has kindly given us assistance in terms of what knowledge or the basis of the sitting. So some of the slides I will not go into. I will just go to slide 3 because there were some concerns and constraints from our side as board members or former board members when we were preparing this presentation and for our appearance today. So the first one, we just want to confirm that we're not appearing in our personal capacity, but as former board members. We also just want to put on record that we do not have a power of attorney to represent former board members, nor review past decisions. And we're thankful to the chair for him pointing that out, that this is not an attempt to review past board decisions. We also want to put on record that all actions taken, decisions made, and resolutions were collective decisions of the board and the boards that we set in differently at different times, and that the decisions, of course, were based on information presented to the board at the time by the RAF executives within the scope of our fiduciary duties. And that no individual member, we also want to put this on record, that no individual member acted independently or outside the authority of the board. And during our time, there was no reported conflict of interest in the affairs of the RAF, and this, of course, is done through our annual declarations, firstly, and also our individual declarations during each board meeting. And until now, we requested, but we did not receive guiding questions so that we could prepare accordingly for this hearing. And of course, some of the issues were ventilated during this hearing. We were also hearing them for the first time as board members. Thank you, Chair. Sorry, I will skip the next slide 4, which really talks to our mandate and responsibilities, because the chair has indicated that you are all aware and conversant with our mandate and responsibilities as board members. Thank you.
Thank you, Tembi. If we can maybe please ask Moses specifically to maybe zoom into the issue of the decision-making that led to the change in the accounting policy.
Yeah, thank you, Chair. I'll probably be along, but call me out if I'm over-elaborating, but I think the details might be important here and there. But I'll take the Chair's guidance.
Yes, in fact, I also want to just assist you with further context. So, like I said, the technical issues, that debate is either in the courts or is to be settled by the experts. What we're concerned with in this is the process of decision making thereon. So you need to clear up some issues. What happened first? Did you seek advice of PwC and then took the decision or not? Because the timelines are scrambled for the committee. Certain meetings took place before others. So what would assist the committee is to say, we started here with this process. This is the process that the board followed, and eventually we took a decision and implemented. If you just follow the timeline and the key decision-making points and what you considered, you will be assisting the committee in that way.
Okay, Chair. Thanks for that clarity. I appreciate it. Maybe, Chair, as a quick background, I think what really triggered the change in the accounting policy was part of the 4-key mandate that was given by then the executive authority to say that investigate this liability. Let's understand what is causing it to balloon. I think it started ballooning somewhere around 2012, 2013. At that point in time, the board at that point set up a working committee that was made of some of the chairs of the subcommittee of the board, as well as the executive management to do the investigation. Ultimately, that process was underpinned or was led by management. Management engaged various impacted parties, ASB and so forth. They then brought a proposal to the audit committee why they are changing the accounting policy. To the best of my recollection, they also sought an independent opinion of theirs, why it makes sense to do so. From the board's point of view as well, I remember our opinion might have came from the PwC. Obviously, I'm scratching my recollection, but I remember very well that it served at the audit committee at that point in time. It wasn't an easy decision because of the impact, the changes in the liability. That's why we had to sort the opinion. We had to ask a lot of questions around the ASB, the view of ASB and so forth. We did get correspondence around the letters that were returned and the responses from those parties. And that was the information before the board or rather the audit committee. It was then taken to the board, and the board made the final decision. But I think to conclude, Chair, I don't think it was a very simple decision. I think even within the audit committee and the working committee, there was quite a lot of debate around the timing of the recognition and so forth, because it did have an impact on the liability. There was an issue around the early adoption, because at that point in time, Ipsos 42, yeah, it was still new. But that would be the process or the governance around it, Chair. And obviously, as board members, we rely on a couple of things. We rely on the information that you get provided by management. We rely on the assurance provider. In this case, if I recall as well, to the best of my memory, the internal audits also opine on that. But I think to the best of our ability, that's the information we received, that's the independent verification we did, and we derive at the decision. I don't know if that's enough, Chair.
No, thank you. I don't want to intrude onto your time. Could you just address some specific issues that arose in the discussion? Because what became clear is that there was an opinion sought from a company called Morale. They were instructed to withdraw it. Then PwC was engaged. At the time, the RFQ closed on the date of the submissions or the day before. The audit committee met and made a decision. Now, PwC have not yet made a submission to the board, and the decision is being made the next day. That's the timeline that has now become apparent. That says to us, if you are going to claim that you took advice from PwC, you can't take a decision on the date they submit their RFQ or 2 days before, after they submit their RFQ. The decision must be taken later. I just want to give you an opportunity to address those kinks, because that timeline between February the 13th all the way to 28th May and what documents served before the audit committee and the board is absolutely critical. I just want to give you an opportunity then to deal with that if you are able, and then your colleagues can move on.
Yeah, I'll try to be brief, Chair. It's been old. I remember some of the stuff, some of them I don't remember. What I do remember from an audit committee point of view, I was a member of the committee at that point in time. We did look at the PwC report. I can't remember whether it was a final report or whether it was a draft report. But when the board made the final decision, they said with a final report. To the large extent, I remember some of the playback from management saying PwC has consulted with their international expert from Belgium or whenever, I can't recall. That's some of the assurance that they were trying to give to the committee. And just to provide clarity, at an audit committee, if a draft report served there, it would have been a conditional recommendation to the board subject to having the final report. That's how we would have probably, the audit committee shaped that recommendation. But I remember very well that the board had the final report from PwC. Yeah, I think the former chair wants to clarify. Thanks, Chair.
Thank you, Mr. Nyama. My recollection, Chair, and of course I haven't been there for years, is that the accounting policy was served at the board, and during that first discussion where we were asked to make a decision, the board requested an independent assurance. We asked management, of course, also through the chair of audit, to then seek independent assurance. So if you look at the minutes, it served at a particular time, and then 3 months later, if I'm not mistaken, when then the PwC report had gone through the audit committee and then came to the board, and that's when we then as a board made the decision. Thank you.
The time is yours. Just keep going unless I ask a question. So you don't need to put up your hand.
Okay, all right. Chair, so maybe just to refer the committee members, the slide that we sort of address. It's slide number 15, just to assist in terms of the matters that we are, in terms of the AG matter. Think also more importantly, the board was not prepared to change the accounting policy without the required assurance. The first matter was that the entity itself has got the powers to determine what is the appropriate policy. We had received this classification from National Treasury, IMF, that classified the Road Accident Fund as a social benefit fund. And also part of the people who signed off on that report was the National Treasury, or the South African Reserve Bank, and Stats SA. So that was a very heavy document. The classification, just by way of history, had not changed. It predates us. It's just that we then got another affirmation that we are actually a social benefit fund. Now, at entity level, and I am referring to the specific slide, slide 15, that we were then requested to apply GRAP reporting framework, and that if we are going to be a social benefit fund, what could be appropriate for us is IPSAS 42 transaction level, and that's what we needed to verify. Can we use the standard or not? Our assurance bodies, and I go to the next slide. The next slide talks through the assurance bodies that the board applied before making that final decision. We then started with management helping us understand what is happening, why do they have to make this change in decision making. Internal audit was also part of that. We engaged external independent experts in the form of PwC. We then also asked, we sought legal advice. At the time, there was a legal firm that we asked, which gave us a full understanding of what the mandate is around changing an accounting policy, the prescripts of the PFMA, and specifically section 55(1) and all that. We wanted to get assurance specifically around that. Having satisfied ourselves around all the reports, that's really when we then said we want to change the accounting policy. So I just wanted to beef up that. That is on slide 15 and slide 16 on our presentation.
And Chair and committee members, I'd like to add to that at various stages of our terms, we were requested to withdraw the matter from court. I think that was also, it also at some stage came from this committee, directly or indirectly. And Chair and members, I'd like to give you assurance that every time that came, and it was clear from the first minister who actually asked the board, and he said to us, consider, settling the matter out of court and finding a solution that will, an amicable solution. And every time that happened, we will go back and ask the chair of the audit committee and the audit committee to run that process with the CEO, the CFO, to go back and engage with the AGSA, ASB, and all the other affected parties, even the OAG, Office of the Accountant General, to really try, even though the matter was already in court, because the challenge was that we knew that the issue was still on the table. And so we needed to get all the affected parties to come and craft a way forward, because up until to date, South Africa doesn't have an accounting standard for accounting for social benefit claims. So we wanted that dispute to be agreed out of court. And continuing with those engagements, the organization and the Auditor General, they couldn't find each other. And we got to a stage where we also did additional risk assessment. We asked management to do a deep dive in terms of what would be the impact on the sustainability and the financial effects on the organization. And that was all done, and I believe that the board secretary have shared that information. So we really discharge our duties to ensure that every decision we take in this regard was in the best interest of the organization. And we did extensively review the matter and assess whatever potential risk, both legal financial, as well as in terms of the accounting framework that was in place. And also at those stages, we went back to getting additional legal advisors because we wanted to understand also what would be the impact of withdrawing the matter, given the fact that the original dispute still remains. Thank you, Chair.
Yeah, just wanted to also help the members. The issue around the risk assessment that allowed us to do a deep dive, having received all the advice, the independent expert, that's also on slide 17, so that we then basically indicate, what that risk assessment, it did indicate the fact that the consequences are dire in terms of if we just didn't do anything about this matter. So we have covered that specifically under slide 17. So that covers on our side the AGSA matter. With your permission, Chair, I don't know if I should move to other matters. Okay, thanks, Chair. Sorry, Tembi. Sorry, Chair. Tembi has another point.
Thank you, Chairperson. I'm now moving, let me move to direct claims. When we arrived at the RAF, there was a unit responsible for seeking direct claims from the public. There was a discussion during our strategy session around this issue. And I must point out to the members directly that there was no, the board was not against direct claims. It was the process that we're worried about and the legality thereof. So the concern was around the RAF itself seeking claimants for direct claims. Because then, for example, when we did not respond timeously when they submitted the claim, then there would be a need for an issue of summons. And the question, the legal question that arose within the board was, in that particular instance, when it is the RAF itself that has gone and sought this direct claim, can the RAF itself issue a summons against itself? So that was the legal issue that the board was worried about. And that's why the decision was made that the RAF itself does not have the power and should not go and seek claimants on direct claims. But people can come and submit direct claims themselves. Thank you. I don't know if I've completed it. Thank you.
Specifically, just to add, one of the reasons around how to become closer to the claimant, and the claimant is usually an injured person, a patient who's distressed, who's not necessarily able to have all his faculties in order, was the issue also of supporting our decision with making claimants to have direct access to the fund, and the introduction of that call center became very critical in making sure that we become closer to our claimant. So I just wanted to also just support that. It was one of the enhancing mechanisms to make sure that the claimants are able to talk for themselves in a state where they can verify matters, whether they have put a direct claim themselves or through representation. But at least there was a mechanism to verify where the status of the claim is, and then have peace of mind that there's a reference number, we are tracking their claim, and we are intending to finalize within a certain timeline. Thank you.
Yeah, so Chair, if I may add, it's been a long time as well, if I recall. I think the question that was also posed is that what is the effectiveness of the road, RAF on the road? That's how they used to reach out to the direct claimants. And there wasn't a clear value for money assessment there. Prior to that, there used to be a target in the APP where it would encourage the driving of direct claimants. And I think post that strategy session, one of the things that we changed at that point in time as the board was some of these targets. I think we did away with it. It wasn't to say stop it, if I recall very well. It was just really saying this is not the best way to spend the money. That's just my recollection. Thank you.
All right, so can I just ask you to address a specific issue on this? I just want to maybe ask a question that might be on members' minds that might not realize. So we've been told that the offices, the satellite offices at the hospitals and in regional areas, advertisements, gazebos, and so on, that were telling people how they can claim directly were withdrawn, including ads that had already been paid for. I just want some clarity, so I'm giving you an opportunity to amplify all of you. Maybe you're thinking, because I can accept not soliciting the claimants. Where I need you to clarify for the committee is what is wrong with simply having an office that someone may then walk into, because the offices were closed and the people were moved. So can you just tell us whether you had a discussion around those specifics? Because what was implemented was the things were closed and the people were moved, relocated completely. And the only way that people could was to travel and go to certain main offices, go to main lane, or, call the call center. Can you please just address that?
Thank you, Chairperson. From my recollection, we did not discuss the implementation thereof. And so we did not, at any point, maybe my co-board members, former board members can assist me here, but we did not get into the specifics in terms of how that was to be implemented. So I was not aware in terms of how the decision was actually implemented. Thank you.
Okay. Chair, from my side, there was delegation that the board had issued to the office of the CEO, and some of the things amongst them was some of what you are bringing to our attention. I do remember the key important thing for us was that whatever happens, let's get closer to the claimant, and that's the part I remember clearly in my mind, that the call center specifically was aimed at enhancing closeness, but the issue of how it was executed, to my recollection, I don't remember us discussing it. We just made sure that the delegation he carried must make sure that the system is in place, the structures are in place, how he did it, that was within his delegation, and specifically for the board, that was not ventilated, if I can just, that's my recollection.
Okay, I don't want to eat into your time on the other issues. The members can hear what you are saying. They will engage on follow-up. So please, because you're covering a number of issues. I also have questions. I won't ask them for now. I was just giving you an opportunity to fill in the gap.
Okay. Chair, the next item was an issue of maybe people's issues. I think, sorry. Oh, okay. She will do the panel of attorneys later. Let me just deal with the people's issues. I wanted to highlight on slide number 18, we talk about some of the work that PwC didn't only give us an opinion on the AG matter, they also did restructuring for the organization, the audit skills and all that sort of thing, because we wanted to know whether we were actually supporting our strategy correctly. So the strategy, the skill set, the systems, the shared values, if that would work. So that's part of the work that they did. And we have policies at RAF, which the board overseas. We have category A policies, we have category B policies. Just by way of explanation, a category A policy would need that policy to be approved by the board, and category B is within delegation of management. So that's the two big difference in terms of that. So in terms of some of the problems with people being suspended and people, being paid without necessarily appearing or maybe attending CCMA, that whole delegation was within management. So the board wouldn't necessarily be involved with suspensions of employees. The disciplinary process were protected. They took a long time. There were also 182 suspensions between 2020 and 2024, and that is reflected on slide number 22. And some of the issues were also reported to SCOPA at the time when we were coming. REMCO was the subcommittee of the board that was tasked in dealing with all ER matters so that we get appraised in terms of why is it taking so long to conclude on most of the letters. So the quarterly CEO reports or quarterly reports that we had were mainly dealing with giving us an update on where matters are, and that would just be the oversight that would play. Where we had questions, we engaged robustly to make sure that things move speedily. So that's the one part around how we ultimately ended up incurring costs and matters being not finalized because of prolonged suspensions kind of thing. So that's the one part. Then the other matter on the issues of, so that's the one part I wanted to charge. The rest I won't say. I'll just maybe allow Tembi to say something on the panel of attorneys because that was a key decision that involved even the board.
Okay, thank you, Dr. Mabuya. I'll just ask first Moses to go first on the panel of attorneys because it's served in their committee first, and then I'll come to the board. Thank you.
Okay, thanks for the opportunity again, Chair, honorable members. Yeah, Chair, I think this also was one of the most complex and difficult decisions to make. At that point in time, I remember around 2019, if my memory serves me well, or somewhere thereabout, RAF used to go through around a process, we call it a day zero, which means that money hits your bank account, attachments are more than the money, and you can't function. Then from a strategic point of view, also from the executive authority at that point in time, the part of the mandate or the objectives was reduce your operating cost, including the legal cost. There was an assessment on that aspect, and if I recall, management demonstrated that they can save a certain amount of money. I think it was something like 20 or 25% per annum for the next 4 to 5 years, so that they create capacity to pay claimants. And during that phase, the tender went out to get a panel of attorneys, because the one that was in place, I think it was expiring somewhere in Feb 2020, if again I recall. I remember the COO at that point in time shared a high-level transition plan. We gave it an input from OPSIT point of view, but we were clear that this plan requires more working. And obviously, we must just make sure that at the end of the day, from an execution point of view, the claimant shouldn't suffer. I remember there was a 6 months extension of that panel, the existing panel of attorney at that point. One of the critical decisions as well around not appointing the panel of attorney, because the tender was out, there was an assessment from SCM and so forth. There was a cost. I think the printing cost was around 1.3 billion. Management says that actually to continue with this, to do the handing of the paper, there is a cost where they need to do copies on the file, hand them over. 1.3 billion at that point in time, I think it was a factor which was quite a lot of money just to exchange papers. But I think at the heart of it, it was to align to the strategic direction, also the APP in that regard, because I think the RAF has always, and at that point in time, was in a worse dire financial situation. The whole thing served at OPSIT, I remember very well as well. It was also taken to board. But if I recalled the way it actually happens, I think they let the contract expire and not renew it and not appoint the new panel. But there were discussion around using the state attorney and so forth, that transition. Obviously, that was more of an operational matter, but there was an element of a plan. To what extent that plan was adequate from an execution point of view, I think one can always have questions, but the financial implication was taken into account. The mandate from the executive authority was taken into account. That was also aligned with the APP. So those would be my recollection, Chair, in terms of how the whole thing was handled. But I do remember the first few quarters. It was quite a very painful time in terms of the feedback we were receiving at an offsite in terms of how the process is going, Chair. I don't know if I've covered it to your satisfactory, Chair.
Chair, if I can add, the panel, the actual contract had expired. There was an attempt, then we then said, now that it has expired, there must be another RQF process that must be followed. We must look for another. But the interim was really an issue and it was a challenge. The fallback plan at the time that was brought to our attention was that we have an internal corporate panel of attorneys, which was an internal. I think at the point in time, if my recollection was correct, was 43 corporate panels that we could use interim whilst they are working on securing the memorandum of agreement with the state attorney's office. So in view of that, we then agreed on the fact that there is no gap. Claimants are not left stranded. The corporate panel of attorneys would step in as a stopgap measure until the tender process itself is finalized. The tender, unfortunately, was cancelled. I can't remember what were the reasons, but at the time when that was cancelled, then they had signed a memorandum of agreement with the Office of the State Attorney, which they were meant to then kick in. The delay in implementing what management had put in is that we did not receive the files timelessly from the outsourced panel of attorneys. That did create chaos. That much we want to, because we didn't have our own files, they were sitting elsewhere. Claimants needed to be defended, and then there was this chaos that we don't have the files. So that part took, if I'm not wrong, 6 to 9 months when the state attorney model kicked in, and that really created problems because we solely relied on the corporate panel of attorneys that we had, and the state attorney model did delay and it created problems for the organizations. Thanks.
Thank you, Chair. Dr. Nomonde has covered most of my points. But what I also then want to say that because of the challenges that we experienced with not having the files, because then we did not know when matters were set down for the claimants, and we could not defend. There was then an agreement, and this is per report of executives, that they would ask the panel of attorneys to make available their staff, basically to go to the courts, and when a matter is raised, which is an RAF matter, because we would not have known, because we don't have the file, they would then stand up and defend it. So that was also another way of mitigating the challenge that we had with not having the files within the RAF. Thank you.
So I'm also looking at the time. I just want to give you because the members have been part of the conversations throughout, and I want to go to them. You still have the benefit of both your statement and your presentation, and if there is a question that is somewhere in the presentation, just take the members to slide X or to page X. I just want to give you one final opportunity to just amplify something out of this panel of attorneys issue. So again, the members of the committee recognize that management and the board can consider various issues and take such decisions. That's not what we're quibbling with. What I'd like you to address the committee, I'd like to request that you address the committee on, is fine. You see a certain pattern. There is a worry about the fund running out of money, so becoming completely illiquid, not being able to operate. That's fine. What you have not addressed is whether at any stage the implementation plan was presented, was there active monitoring, were you able to over time to say, hey, you know, we didn't foresee this, maybe do X, Y, Z so that we don't have this problem. So can you just address us on the implementation plan, the monitoring thereof, etc., and then I'll hand over to the members to engage with you.
Thank you, Chair. Chair, let me just highlight the monitoring aspect. What the board would do is that once we've taken a decision, we will obviously, in terms of the due delegation, expect management to implement, because implementation falls within them. But we expected management to come back to us to give us updates, particularly if there were challenges. But the main key monitoring was the fact that all these decisions were linked to our performance APP, annual plan, and also linked to the overall turnaround strategy, because what we started with was the 5-year strategic turnaround plan. So every year we made sure that that plan spoke to the annual performance plan, and then brought down to quarterly monitoring and reviews. So we expected management, whenever they had problems with the decision that were taken by the board, to come back and give to us. But we reconciled that with the quarterly performance. So during our term, we were given assurances that the quarterly performance was still on track, and management was dealing with emerging risk issues operationally, and they were giving us comfort that those risks are being managed and the challenges are being managed, you know, within acceptable levels, that there was no major impact on the performance. So the board had to rely on the first level of assurances from management. Plus also internal audit, they also gave us independent assurance in terms of challenges that would crop up outside the knowledge of the board. But around these matters, there were no specific reports that raised a red flag that needed our immediate intervention. We were given the assurance that there were problems, but we're managing them within acceptable levels. But the monitoring tools on a quarterly basis gave us the assurances that we're still on track in terms of meeting our APP targets, and whatever challenges management were on board, managing them effectively. Thank you, Chair. And I think, Tembi, do you want to do default judgment?
No, I see, Mr. Nyama wanted to, then just deal with the default judgments, and then we'll hand over to the members, if that's okay, because the issues will come up in discussion.
Yeah, thank you, Chair. I just wanted to add, from the oversight, your OPSIT would then consider all the reports that management provide from an operational point of view, registration, productivity, and then we will report into the board. I think initially we must all be honest that it wasn't a smooth riding. I think there was a transition, and I recall very well some of the challenges that we observed. All these things happened when COVID started hitting, and I think it just exaggerated the issue around it. But to sit here before this committee and say it was all smooth, Chair, I think we will be misleading you. I don't think it was easy, but we were given the assurance that let's ride the wave, it will get better with time. Thank you, Chair.
Sorry, and I just wanted to also add that at each and every legal committee meeting, there would be a discussion, and I mean, the minutes would bear us out of the committees around this particular issue, and also suggestions from committee members in terms of how some of the challenges can be addressed. So it was a live matter. It was a complex matter even for us in terms of some of the challenges that were coming up as we moved forward with this plan. Thank you.
No, thank you. So can I make a suggestion? Can I go to the members? I've noted the default judgment issue in the committee's construction of the conversation so far. It does link to the panel of attorneys issue. You've given us a sense of how you are overseeing it. You will get an opportunity when the members begin to engage with you on the various matters, and you can still, we don't stop you when you're talking. So you will still be able to address the matters. I'm just looking at the time because we've gone way past the 30 minutes. Because I wanted to give you the opportunity. So can we give the members an opportunity to engage with you and then continue to address the matters as we go? I'm going to start with you, Honorable. Why am I'm wanting to allocate somebody's name, somebody else, Honorable Matiwan. I nearly said Matoile because I know it's Kumani Matoile. Honorable Matiwan, over to you. So we'll do as yesterday. There'll be a second round of any outstanding. So it's 20 minutes per member. And then once all the members have asked, we'll then come back for another round, a shorter round, but each of the members get a second bite. Similarly, if you want to bank some of your time, we banked it well yesterday. We can give it back to you later. Thank you.
No, thank you, Chair. I think I'll still need to observe. I'll come back later.
Honorable Mende.
Thank you very much, Chair. We have put my colleague on a very awkward position. I should have been sitting on that side. He would understand it in due course. No, thank you very much, Chair, and good morning once more to the colleagues and good morning to the former board members. Now, I have a few clarities that I would like to get from you. Well, let's start with the panel of attorneys. And we need to clear these things so that when we make recommendations, we do not include you as people who are part of a wrong decision. There is a sentiment that strongly comes up every time. And unfortunately, I know, especially Ms. Msibi and Dr. Mabuya. I think we've been together for quite some time. You have explained this, but I need you to clarify it in the simplest term, that you were part and parcel of the decision to not renew, it's not terminate, it's not renew the term of the panel of attorneys without a plan. You did that without a plan. Is that correct?
You want to start? Yeah. Honorable Mente, the expiration of the panel of attorneys happened around 2019. That was brought to our attention, and I think that is why we allowed a tender process to go on, because at the point in time, there was an issue of we needed to have a plan. Management did reassure us that a stopgap measure is going to be our internal corporate panel of attorneys, which we had, whilst they are still busy with the tender. We allowed that because it sounded like a reasonable stopgap measure. Where things went wrong in now we're talking 2019, if we can just put the timelines in context. That was 2019, December, January kind of period when some of these decisions were being made. The stopgap measure of the internal corporate panel of attorneys was what we were comfortable with. The second issue that management brought to our attention was that they were going to secure the services of the state attorney model. What hit us hard, honorable member, is that COVID was then declared level 5 in March or February. Remember, we only came in December, January, there are these decisions that we have to make, COVID hits. We all had to work away from home. But what we did was to make sure that we remained accountable, we don't hide beyond COVID. So that in itself even if we thought we had an effective plan, we worked 6 months, February up to end of June, if I'm not wrong, without necessarily having the full benefit of actively monitoring, except for the reports we were getting because we were on lockdown level 5. That we did to protect lives. RAF at that stage had about 2,800 employees. Through our own intervention and that level 5, 685 of them were actually got sick from COVID. We lost 6 of our staff to that. So that period, honorable member, was not an easy period for everybody. Our monitoring was monitored, was basically limited by this extra majoro effect of this fact that now there was COVID, and then we are having this situation where we are also implementing a system that is supposed to help us save on litigation costs. Thank you, Chair.
Thank you very much. I'm clear. Now, I'm not hearing that for the first time. I want, for the benefit and the purpose of this inquiry, that to be on record once more, because we need to debunk a lot of myths. You are Dr. Mabuya. Allow me, Chair, to give an opportunity to the board members for the satisfaction of decision-making and also debunking the myth of deployment, that we deploy cadres who have no clue, nothing whatsoever of what they are doing. So I'm going to give you a benefit and an opportunity to also state your qualifications and experience in the work that you are doing in RAF, and that you were not just thrown into RAF because you have 10 people or you have proximity to certain powerful people. Can I give you that opportunity? Because I want to link a lot of things to the decisions that you have taken.
Okay.
Thank you.
Thank you, Honorable Mentor. Allow me, Chair, to state my background. I am a qualified occupational medicine specialist. But in addition, I'm also a medical legal expert. Some of the work I have done before I joined the board of RAF, I was on the HPCSA RAF tribunal team that helped to implement the regulations when the amendments were made in 2008. 2008, there was a big amendment of the Road Accident Fund. And at the time, there was no standard that was objective in assessing what is fair, what is not fair in terms of the amount of money we pay. So people were getting this amount and that amount, and the judge would give this because there was no standardized way of doing things. My skills as an occupational medicine practitioner became very handy in that in this workplace, when we make judgments for insurance companies, when we declare somebody unfit to work, we used a standard called the AMA Guide. The AMA Guide is an American Medical Association guide. It's been in existence in the US for 54 years. So when RAF adopted that particular standard, they invited a professor or some doctor from Australia to come and tell us about the AMA Guide. And it was almost like a new and then, and I'm talking era 2008 when the RAF amendments were there. At that point in time, he came, shared the experience of Australia and how this is being used and why it's 54 years, tried and tested. The US market, being a very litigious environment, that AMA Guide was agreed to as something that we could work. Specifically when he presented, I volunteered to present the South African experience because in my workplace, I was already exposed to the AMA Guide. To an extent that I trained a lot of RAF claim handlers, OTs, nurses, to understand the process of how do you then come to a 30% guide. We had to train them to know how to reject a claim logically using the AMA Guide, and that helped because there was this new standard adopted by Parliament, then the training became an issue. So that was the first experience I brought into RAF. The second experience, I teach at the University of Pretoria. I teach postgraduate students. Specifically, my passion is that I love to be diverse. I'm teaching around how to be inclusive, diverse, and allow disabled employees to be part of the workplace. Let's not see them as receptionists. Let's give them meaningful work because the Constitution protects their right. That is the work I do with the University of Pretoria for the past 20 years. I do this work pro bono, and my fees, I give them to a student who wants to study this. That's the second experience I'm bringing. But thirdly, the narrative test, when the amendments were being done, the narrative test was brought to us because of the Australian laws. The narrative test is not a South African invention. It's something that was used in Australia, but in addition, there was a grouping that felt the AMA guide was too medical in its approach. It did not necessarily encompass the environment where the victims are. And I'm talking, if you are hit by a car accident, you could be living in the outskirts of South Africa, there could be no clinic, you may need to cross a river before you get access to care. Even if you get access to a clinic, it doesn't mean you'll get the right care. So the narrative test, the group that was lobbying for it, brought that to say, let's bring the social aspects, economic aspects of the people that we are looking after to make it complete. Now, what is important about that particular input, at the time when the amendments were done in 2008, we were on edition 5 of the AMA Guide. It pushed the international community to then immediately accelerate that to AMA Guide edition 6, to then include the socio-economic factors of the people we are talking about. Hence, when the professor from Australia came and presented that, then I volunteered to say, the South African experience, it is such that if you are a patient and you're injured, you go to a public sector, the chances of and you have a fracture, the chances of you getting care, day one, x-ray, operation, and that are very low. If you compare us with Canada, Ontario, which uses the same, their standard of accepting liability is much lower than us, probably at about 50% versus where we are. So that's really where the issue of saying, as much as it's an international American guide, let's look at the reality of South Africans. You go to a casualty unit, and when you get there, you do an x-ray. That's likely what is going to happen. They were likely to stabilize you. The possibility of you seeing an orthopedic surgeon on the same day is not the same as the US and is not the same as Canada. So that's the reality check I brought to say we cannot then take a claim liability to be a stringent amount. We needed to reduce that. We moderated that to say, let's at least lower it at 30%, but in addition, let's incorporate the narrative test. The narrative text talks to other things. It talks to, if you are in a car accident and you happen to be pregnant, you are a lady, you lose your pregnancy, then you must be compensated. It was a reasonable measure because it's something that is not covered in the AMA Guide. Number two, if maybe you suffer permanent mental disorders because of that, we need to take that into consideration in terms of the narrative test. If you suffer disfigurement in terms of maybe you were a model, your face is disfigured, is whatever, what do? Your earning capacity as a model is now tempered with by the accident. So we needed to incorporate that into the narrative test. So that's really the experience specifically I brought into RAF. And I then helped to craft the narrative test to suit the South African situation. Thank you, Chair. I was one of the co-authors. Just one thing. Sorry, so my colleagues are also helping me to just remember some of the most important things. Critical, the RAF 4 form was adopted by Parliament. So one of the things when we trained doctors was the fact that you can't change anything in that form. You have to feel that because it's a form governed by an act of Parliament. And the reality of the matter is there were deficiencies in the legislation. And then that's part of why we recommended reforms or amendments into the legislation, because with benefit of hindsight, we then realized that there are gaps in the legislation which have been left for too long, and we then recommended the amendments. Lastly, on the RAPS side. RAPS, because I was also part of people who were being consulted when the previous administration was pushing RAPS. There were road shows that were done. Was clear in that engagement? It was vehemently opposed by the legal sector because it brought completely new things. As much as it's a benefit that is defined benefits in terms of this, the issue is we were now compensating even anybody who's drunk. We were not necessarily holding people to be accountable. So the RAPS bill actually did have its time. The reality of the matter is it didn't serve it was actually thrown out. So even now, we are not so sure why we as a board, we had specifically asked for specific amendments based on the experience we had. That was withdrawn. We were then basically instructed, or we got a letter to say we are going back to RAPS bill without any formal engagement as experts who've helped to formulate policy in this country. I think the least that we expected was just to be engaged. We understand what are the pros and cons of it, and that was part of the problems. Thanks, Honorable Mente.
Thank you very much. I allowed you to be that lengthy because I want to dispel the myth that you don't know what you're doing. Because that has been a dominating sentiment out there that everyone who's a draft have no clue. Now we need to make a decision as Parliament as to what should we do as a committee. Hence, I try to put you at the center of your decisions. You were not clueless. You are actually part and parcel of the people who dealt and drafted some of the laws that are governing RAF today. I will not ask the other members. I'm sure all of us, we do have their qualifications. But I want to also deal with the RAPS bill and the amendments you sought in the RAF bill versus the pushback. Can you take us through what is it that you wanted to resolve by the amendments? What are these specific amendments? And what was the pushback?
Chair, I'll allow my other colleague while I find my notes, Tembi.
Thanks. I'll just say, basically, the overall arcing sentiment around the RAF bill is to ensure the sustainability of the RAF financially and also to serve the people that it is meant to serve. So that is the overall. I'll ask Moses on my left to just go into the amendments. He remembers them more than me right now. Thank you.
Thank you, Chair. Through you, Chair. Thanks, Honorable Mentenkuna. So I'll just highlight probably the most critical part. Obviously, the dispensation as it is, it's not sustainable. I think it requires what one would call unlimited funding to be able to sustain it, which is probably not possible. Some of the things that were suggested in that bill was really that today when someone get an injury, let's take a loss of earning as example. You were earning whatever you were earning per annum. You are losing that revenue in future. Currently what is happening is an actuary will work out the present value of your future cash flow. If that number is 10 million, we need to fund it now. We're saying that that wasn't sustainable. That person prior to injury, they were earning whatever amount, 100,000 million a year. Why don't you give them the yearly or the monthly installment so that with same resources, you can be able to pay as many clients as possible? In the amendment, also the issue that we raised was the issue of the foreign payments, to say that if you were to look at the payout to foreigners versus what they would have probably contributed from a levy point of view, it probably doesn't make sense. If you look at the global practice, when you visit any country, you are required to have your own insurance. So that was another one. Some of them was to introduce the capping on the payment, because currently on the medical piece you can get an unlimited injury. The other one, the view was that capping is important because it will also contain the liability. If you have a Moses who's an actuary, maybe he earns more. Is it really fair to pay him so much out of RAF? The chances are he probably have a good job somewhere, he has insurance, he should be able to cater himself. So those are some of the thinking behind some of the amendments. There was other stuff as well from administrative point of view to say that how can we make this easy to administer in such a way that you don't necessarily always need a lawyer. Of course, there are claims that are complex enough, you need a lawyer, but there are claims that are straightforward. If there's a funeral cost, do we really need a lawyer to litigate around that? Someone has died. So there was quite a lot of work that went into there. If I recall, we even did the impact analysis from the financial point of view, which actually demonstrated that you could get to a position where with the current fuel levy, you'll build additional reserve or capital, so that in future you might not need the same level of fuel levy that you're getting to fund the benefits. But it also creates an opportunity for someone that if you give someone a monthly income, they recover, they go back to work, you really need to, you don't have to continue paying them. So there was quite a lot of things that we strongly believe that they could have helped in terms of making the RAF dispensation or the act as it is sustainable. But I think if you need the details, we could probably ask the Secretariat to share that with you, Honorable Mentor. Thank you.
And what was the pushback?
Sorry, may I just say, so your 20 minutes is up, but ask one more question. Thanks.
Okay. Oh, I just wanted to add one of the key introductions with the amendments. We wanted to standardize our services. We introduced the medical tariffs bill. RAF, part of its sustainability issues is that it's not getting the fuel levy regularly, but also the medical side of the business. People are charging us the various amounts, and that was not sustainable. So we introduced the medical tariffs bill as part of the amendments to standardize. If you have a fracture and it costs 2,000, whether you're in Durban or in Cape Town, that amount currently in the medical aid scheme, that's how it's working. There are prescribed benefits, you charge according to that. So the medical tariffs bill was a huge game changer for us to standardize what doctors cost us, because we're spending a lot of money on that. So I do want to mention that. Secondly, we have other systems that work in this country. The compensation fund. Employers contribute into a fund, and essentially those benefits are defined in terms of what they will pay for, what they will not pay for. And there's a specific requirement in terms of documentation. You need to supply your evidence, your document, how the injury on duty happened, and that sort of thing. We did not necessarily have that. We were just taking everything as per the prescription. There's about 60 days that is allowed by the Act for lodgement, and if we are not satisfied, we might have to wait for another 120 days. That process leads to a 5-year-long, protracted litigation process that could be shortened, because the reality of the mandate of RAF is to pay compensation to injured people. Now we are now bogged with claims that are not necessarily fully compliant to what we need to pay. So that's just some of the things, Honorable Mente, we're hoping to achieve with the amendments.
There was a question there, the pushback to the RAPS bill, when you called for the public input when the executive. But then additional to that, so that I don't come back, I may note this. Did you get a sense that the CEO was also working against the progress that you were having an idea with you? That's the second thing. Then the third one is, you mentioned that you had files that were not returned by the panel of attorneys, which made a space of work extremely difficult in terms of knowing who's going to court when. How long did that period last? What was the reason for the files not being returned? Were they all returned eventually? Thank you, Chair.
Thank you, Honorable Mente. In terms of pushback, let me start by saying we had full support from the minister. Of course, we had agreed this in terms of the strategy and the APP. We submitted our suggested amendments to the department end of March 2021. And there was constant follow-up, but we were not getting any feedback. So in terms of any work done, whether there was movement in terms of having public consultations around it or anything, nothing was done. We finally had undertakings by the Minister Chikunga, in 2023, beginning of 2023, because we consistently raised this both through the CEO and his office, through officials and through the ministry as well when we wrote that there would be movement and it would be prepared and taken to Parliament. Unfortunately, at that point, it was going to be late for the 6th administration in terms of Parliament to consider it. So when I left, that's where the process was. But there was an undertaking from the minister, that Minister Chikunga, that it's supported. She had brought her officials there, and there was, I would say, a timeline because it was in discussions in terms of what would happen next. Thereafter, I then was out of the RAF, so I will ask Ms. Francois to deal with that. In terms of the files, our understanding in terms of why they did not return the files, the panel of attorneys, is that they were fighting us on the decision. They took us to court. We had numerous court cases and filed at different times by the various attorneys. So they then did not return our files. Unfortunately, at this point in time, I can't remember the number of files, but it was quite substantial. Over time, over a period of year, we started receiving some, but it was minimal. When we then had the return of the highest number was when we finally succeeded at the Supreme Court of Appeals around the panel of attorneys issue, when the court ruled that it actually is not an administrative law issue, it is a contractual issue. The RAF has the right to change its operating model, and furthermore that the cases would benefit those panel of attorneys and not bring new members to the panel. So they were basically fighting for their own sustenance in terms of the tender changing. So that's when we started then getting the bulk of our files back, but that was over a year. Thank you.
Thank you, Honorable Mente. I just want to add, in terms of the challenges with the RAF Amendment Bill, that after Minister Chikunga led the Department of Transport, we raised the concerns around the delay in terms of pushing this bill to go through the process. And I think she took the matter to, the bill went to Parliament, and the department was supposed to start taking it through the public commentary. And then after she left, again, we went into another phase where nothing came. There were no feedback from the Department of Transport in terms of progress, and we kept on writing letters to the ministry asking. The reason why we kept reminding the department was because the 5-year turnaround strategy to stabilize the RAF was underpinned by the expectation that the RAF Amendment Bill will be enacted into law, because remember, the unsustainability of the funding model was mainly because we were paying lump sums, and obviously because we were underfunded, paying claimants basically in annuities was going to relieve the fund and really finances and enable the organization to sustain itself going forward. So that bill was going to enable that and all the other reforms that came with it. So we were surprised then in the current administration towards April, May of 2025. The timing, just excuse me, we will just check, but early within 2025, when we receive an instruction, when we were finalizing our annual review of our strategic plan, that the RAF amendment bill has been withdrawn, and now they're reintroducing the RAPS bill without engaging with the organization, the board, management, and as Dr. Mabuya said, the experts that put together and have done thorough assessments of the organization, take into consideration its sustainability going forward. Thank you.
Just my last point. The RAPS bill also predates Minister Kichunkunga. I mean, Honorable Dipuo Peters was also part of that period when this thing started. And I think the bill was introduced in 2014. Public comments went on all until May 2014. So that was during Minister Dipuo's time. So engagement was very thorough and engaged, and people were registering the no-fault system. What are the implications? And I think there's a whole write-up and research on that sort of thing with the pros and cons of the RAPS bill. The reality of the matter, the work was done, but it never went through Parliament, and it was thrown out. Hence, our surprise when it was reintroduced without re-engaging, because there was a full process that started in 2014 up to a certain, I can't remember, 2019 when the next administration came, that it had not necessarily been well received, both in the legal fraternity. APREF even made statements around why they didn't support it. So there was a whole lot of engagement, ordinary people, key stakeholders, why that happened. So that's the one part I wanted to highlight, that it actually predates even Minister Chikunga. The last part, there was an SLA between the previous outsourced panel of attorneys and RAF. And management was tasked in enforcing that SLA. The SLA was very clear. When we terminate, bring back our files. They were not happy to do that. What didn't work in our favor is the COVID period. Because when we then wanted to enforce the SLA, we were also under COVID, level 5, and essentially it became difficult to then hunt people wherever we could hunt them because, you know, there were no cars, we were restricted, and all sorts of things. So I just want to mention that part. Thank you.
All right. Thank you very much. May I hand over to you, Honorable Atkinson?
Thanks very much, Chair. Yeah, no, thanks to Dr. Mboya for giving us her medical background. It was very interesting. The question I'd like to ask is who on the board actually has legal qualifications? Qualifications in law, legal qualifications. Who are your lawyers on the board?
During our time, I've studied law, I haven't practiced law. So that is a limitation. However, I have worked in the Department of Transport from the first administration towards the first administration. And I was head of legal services. And during that time, we were busy with the separation and creation of the agencies. So my work was supervising that whole process and engaging Parliament. At that time, PICOT was chaired by the Honorable Ms. Delil. And so we had constant engagements in terms of setting up SAMSA, CAA, CBRTA, all those entities. Thereafter, I was asked to lead the international relations because of my experience around that area. I set up that division within the department, but then later on I went back. I'm just going to skip the Department of Public Enterprises to head the Department of Roads and Transport in Mpumalanga. So in terms of understanding legislation, etc., and working, let me say, within the sector, I understand it, but I have never practiced. There was at the beginning of our term, Advocate Oma, sorry, her name has just escaped me. She had
Omar Rasitaba.
Yes, thank you. Yes, Rasitaba. She was a practitioner. There was also Dr. Piense, who had also worked at the department and was also on the board of the RAF during the 5th of December to the 2019 to 2023 September. Thank you.
All right, well, thank you for that. So maybe you help.
Sorry, member, there was also Advocate Njeza, Ntuthu Njeza, in the board that, current board that was disbanded. Thank you.
Okay, well, with all those people on the board, with all those legal minds there, maybe you can just answer a question for me. If I decide I don't like paying tax and I stop paying tax, would I be breaking the law? If I decided I didn't like the idea of the South African tax system and that I just decided that I'm going to stop paying tax, would I be breaking the law?
So can I just offer guidance? So could the members also say who you're directing the question at, unless you want all of them
Just
to?
in
Okay,
general, in
no,
general.
that's fine.
Yeah. Sorry?
Sorry, from the face of it, you would be breaking the law.
Okay.
That-
So how would it be different then with the road accident fund, with not liking the fact that you're a social insurance scheme, even though the court has ruled that you're a social insurance scheme, even though you've lost cases in court, that you then continue not to follow what has been legally mandated by the court? Because no one has actually given anyone any legal basis to actually change from a social insurance to social benefit fund. You actually have had opinions from people, but at the end of the day, you have no legal basis to change the actual accounting policies or the way the fund is run. So what I'm saying is that you believed it was wrong, so you decided to go one way, and the courts decided another way. So how is that different from me deciding just not to pay tax, just to make my own law in essence?
Thank you. My understanding is that the case is still in the courts, and we do have a right of appeal. So unless we now cannot appeal, that would be a different scenario. And of course, even in that particular instance, we did not just say we don't like the rulings of the courts. We have sat down with legal advisors, people who are in practice, to say basically, and I think even Parliament does this when it receives a ruling, that it would then sit with their legal team to not review, what's the word, sorry, it's escaping my mind, but to go through and understand the court's ruling and see where it feels that there could have been a misunderstanding and appeal where it feels it is necessary. So at the present moment, my understanding, and of course I haven't been in the board for a number of years, is that the matter is still within the court system. It hasn't been, it has not been removed in terms of appealing. Thank you.
Okay. So again, further about the legal experience on the board, are you aware that you're actually taking the wrong entity to court? That the Auditor General of South Africa actually has no ability to be able to change your accounting principles, that actually lies with the Accounting Standards Board? And in fact, the AGSA even told us when he came here that you guys are suing the wrong people, basically. So again, it goes back to the legal experience on the board, how you could actually be suing the wrong entity in government.
Thank you, Honorable Atkinson. I think what I want to clarify is the fact that we were not necessarily a board that was hostile or recalcitrant. We did get advice, firstly from the minister, advising us to consider alternative methods. But I think what is not coming through is that we also have a regulator that gives us guidance. If we are functioning within a regulated environment, what the regulator says matters. And I'll give you an example. The report that I started with, the Prudential Authority is seen in many ways as the key regulator in regulating financial or insurance-like institutions. It was their document that gave us guidance that we are a social benefit fund. We are not an insurance. We don't have a license as RAF that we are an insurance. My understanding is insurance companies in this country have a license that the regulator regularly checks if your money, you have enough buffer to service your claimants, kind of thing. RAF does not have that. We are regulated by the RAF Act. And the Act does allow the board to appeal the right to engage and find a way of making sure that this technical matter is ventilated, because in our legal advice, there were 17 grounds. There was not one ground. There were 17 grounds why we needed to appeal. Hence, we are saying we engaged thoroughly in exercising our fiduciary duty. So we were not recalcitrant for the sake of being it. But the reality of the matter is the legal advice supported the fact that let's appeal, we have a right to appeal, and this is a technical matter. Let the courts engage. And one of the presentations we did go the alternative route after the advice. AG was there. Office of the Accountant General specifically mediated. We did try. ASB, we were aware. They are the standard setters. So that is not something we had here for the first time. We've always been aware of that. But the reality of the matter, the regulator had pronounced on who we are. We are not the only social benefit. Even UIF, I think it's also a social benefit fund kind of thing. So those kind of things are important. If you're working in a regulated environment, you work according to your regulator's guidelines. And we were submitting quarterly documents to the Prudential Authority. We never had a situation where somebody told us that no, the regulator would say no, do this. So I think it's important to also bring that there is a regulation. In everybody who's been here, the regulator or the people who gave us the classification have not been called. Only NT came, AGSA came, and I can't remember who else, but the people who gave us the classification is Prudential Authority, it's Stats SA, is the IMF, and National Treasury. Those are the people who gave us the classification, and those are the people who govern us, who regulate us.
Then they need to go to court to change the law, because the law in RAF versus AGSA, the courts say that the Road Accident Fund is a social insurance fund. And the second question I want to ask you is, if you're not an insurance fund, then why do you buy reinsurance? Because the Road Accident Fund does reinsure, basically. So how many social benefit funds actually reinsure?
Yeah, thanks, through you, Chair. Thanks, Chair. Thanks,
So
Honorable.
can I stop the clock? So Honorable Atkinson, I'm just going to share a view. The time is yours. What's probably going to be helpful for our work, as I set out in the beginning, is that we interrogate the process of decision making, because the technical issues literally take us to a dead end. You understand? They take us to a dead end because the matter has been to court twice. For example, the SCA has turned down the ask to hear it twice, right? I'm not sure where we get. There are issues here pertaining to the process of decision making. We had a whole raft of witnesses here. I just want to place that on the table. If you want to continue the debate, sure, but I don't know if it assists us in terms of the issues we were ventilating here for the last few weeks. Thanks.
That's fine. I'll leave it at that. Just apart from the fact that the minister has actually has written a letter. She wrote it, I think, to the final CEO. tell him, to instruct him?
I think those are some of the factors that the board has to take into account. I don't think it was a straightforward linear decision. It was really a compromise between what is important at a particular point in time. Thank you, Honourable Member.
So in a previous iteration of the Road Accident Fund, about 20 years ago, you had a situation where you had a settlement hub, basically, and the Road Accident Fund made offers to lawyers or to individuals based on a menu. Okay, so if you lost a leg, or as to the extent of your injury or whatever, and it was kind of like a known list that people went through, and offers were made on that basis to members of the public. I believe, I'm told by people who worked there before, that if you ended up going to court, you were called in by your superior to please explain, okay, because it was not a usual thing for a RAF claim at that time to go to court, okay. Did you ever possibly think about the fact that that might be the most cost-beneficial system at RAF? Is not so much your panel of attorneys, but actually having a legally qualified settlement hub who could make offers based on a transparent set of costs and payouts and that sort of thing. Because in essence, what you really should have been doing was to avoid matters going to court at all. And that appears not ever to have been in this, because you speak about a plan B and the fact that they were going to use the state attorneys who were completely not ready for this, and have served to be absolutely not a help at all. What, in essence, we should have looked at here in RAF and as a board was how do we stop matters even getting to court in the first place? That surely would be the most cost-effective solution.
If I may, Chair, through you. Yeah, thanks, Honourable Atkinson. I think you are making a very valid point, and I want to revisit what Dr. Mabuya said earlier in terms of resolving these issues, that there is quite a lot of proposal in terms of changing the amendment into the department. Even today, they are still sitting to resolve this. One of the issues that we actually identify and put a proposal to address exactly what you're talking about is to introduce what we call a actuarial standard formula, to say that when someone get injured, all you need to do is to punch the type of the benefit, the ICD code, and then the model will spit the benefit. If you gazette that, regulate that, there is no dispute around the court. But we've always accepted that some cases are exceptional. They could require the court. But probably 80 to 90%, they could have been dealt with the actuarial standard formula. Even today, that formula, to my recollection, before we got dissolved, it is actually with the department. I don't know where it is, but it was actually speaking to exactly what you are saying, to say standardize the benefit, update it, make them based on the demographies of the country, and so forth and so forth. Thank you.
Yeah, thanks very much.
Yes, I just wanted to add, Chair. Honourable Atkinson, if I can also mention the issue around the board taking leadership in making sure that we resolve matters before they go to court. It's a matter we actually took to heart. Our very first strategy session was with an independent professor from UNISA. I can't remember his name. He actually came and did a study and showed us in that strategy session that most of our cases are actually settled at the door of the court. So in reality, nobody gets in and settles. So matters are settled at the doorstep of the court. So that was a very insightful study we got independently from this particular professor from UNISA on that matter. But what the management then did, because we had to then craft a strategy that supports how do we settle before allowing it to go to. They also introduced what is called block settlements. Block settlements was exactly addressing the issue. Why don't we do this so that we avoid clogging the courts? So there are meaningful interventions that they tried, and the block settlements actually worked. We actually saw the reviews of how the legal fraternity was happy with the block settlements that we had actually introduced. There were also settlement hubs that were created at the RAF where teams were created to make sure that at the point of origination of the claim, who is in charge of this part of the process, and that helped in expediting us settling claims before they go to court. Thank you.
Sorry, if I may add through you, Chair, Honorable Atkinson. Yeah. So the other, and I'm not trying to play blame games, the other key aspect, if we are to really ask ourselves, what is causing people to go to court? Moses is injured, there is a plaintiff, and there is a RAF on the other side. The fact that the two are arriving at a fundamentally different benefit, it tells you that there is an open interpretation in terms of the legislation, because you have an educational psychologist, you have an industrial psychologist, both working for the two teams, access to same information. You have two actuaries. They derive a fundamentally different benefit, but they have, so for me, that was one of the most mind-boggling things that I was like, how on earth can professionals have a huge interpretation of the dispensation? Because really people are fighting at court because they are not agreeing on quantum. I don't think it's a merit issue. I think merit is easier to get to. It's really the quantum. And I think for me, that's where the crux of the problem is. Thank you, Honorable Member.
So one more question.
Yeah, thanks. And that's, I think, why I said it needs to be a transparent menu of what's paid out, and almost in the law, so people know what they're likely to get and are less likely to go to court. Yeah, my final question is around the person of the CEO, okay. We had the head of NUMSA here yesterday, and he referred to the period that Mr. Litswalo was the CEO as a reign of terror, okay. We've had numerous employees coming here before the board, or before this inquiry, giving quite horrific accounts of what has happened to them, and suspensions and bullying, and just actually quite appalling stuff. And I mean, Doctor, you spoke about wanting to create diversity and seeing people get ahead. I mean, it's actually quite heartbreaking what has happened to a number of people. In fact, they mentioned, I think, a lady from the Durban office yesterday who went through a terrible time there. And I mean, Matta's been impressed, and she provided an affidavit here and said that on a number of occasions she wanted to kill herself because of how she was treated at RAF. Okay. You know, we read in the Sunday Times about the CEO and his 2 million rand BMW and his 120,000 rand a month for security and all that sort of stuff. I mean, he just appeared to be a person completely out of control, and he ran it like a North Korean dictator, basically. What responsibility did you have on acting on behalf of the employees of RAF, seeing to it that they were respected and treated properly within the bounds of labour law? Because from what we've heard from NUMSA as well, that there was, that the CEO didn't necessarily always stick to labour law. I mean, there's a whole list of stuff. In fact, if you look at the evidence from yesterday, it really does make your hair stand on end. But you were the board, and he was the CEO. What responsibility did you have, and do you have, to the employees of RAF to rein them in and dealt with them?
Thank you, Honorable Atkinson, for that specific question. Our role as a board was to exercise fairness, due diligence, oversight, and make sure that the leader that we have appointed acts in accordance to the code of conduct of the organization, the culture, promotes the culture, and also transforms the organization into an entity that will probably push us to be world-class in the event that we had an underfunded mandate. So the reality of the matter, how we dealt with it, we had surveys regularly. Remember, I mentioned that PwC, they only didn't tell us about the IPSA standard. They did the organizational restructuring. They did a full survey. Some of their people did a survey for us to check the pulse of the organization. Those kind of things, that's our proxy as a board to understand what is happening on the ground, because we are not allowed to be there hopping office to office. Are you happy? That's not our role. So the surveys actually indicated that the change management process, some people took well to it, some people didn't take well. But what was key about the surveys we did, the participation rate was very high. I think one survey showed 60% participation. That can be shared with, just as evidence of that whole process. When you come in as a CEO, obviously you have certain strategic objectives to meet. Your personality must show through it. We are all different. I could come across as a strong person. She could come across as a soft person. So sometimes we show our personalities in the way we lead. But we as a board, we wanted the surveys to give us a sense of where things are. We never did door to door. That was not our role. The surveys were a good dipstick to give us a sense of the pulse of the organization. So I'm not saying people who came here lied or what, but I'm saying as a board, that is really where our mandate is, as oversight. Let's check what's happening here. And some of the things did lead to suspensions. I think I did mention a figure in slide number, where we're outlining the discipline. RAF is an organization full of collusion, malfeasance, people, doing all sorts of things. If you are a CEO stepping into those shoes, it's not an easy organization. That I must put up front. In reality, we needed a strong personality to make sure that they guide the organization through that difficult time. Now, you can be firm, transformative, and lead without being abusive, kind of thing. So everybody leads differently. So it's difficult for us to say, this was wrong, this was right. What we gave as a mandate was, this is an organization riddled with problems for more than 30 years. Some people have been working there for 30 years, colluding. You are coming in, we are giving you a transformative mandate. How do you do it? Your leadership style comes into it. Sometimes you have to be harsh, sometimes you have to be soft, but as a board, we used surveys to check the pulse of the organization.
Thank you very much for that answer. At the beginning of your answer, you mentioned the fact that it was important for you that the CEO embodied the values of the organization, was ethical, and was someone that you could trust. Do you feel that you could, Mr. Letswalo?
Honorable Atkinsons, if I can mention, I was in the committee that appointed the CEO. Firstly, he was seconded to us from the Department of Transport because of his depth in knowledge of the transport sector. He came through secondment, but then we went through a full recruitment process. We were there at the point in time, in terms of the candidates that we had, he was the best candidate in terms of the information that we had. I had no doubt that he would be the right person with the depth and knowledge and networks within. I think he was a financial person for the department for 17 years. And his depth and understanding of the RAF Act was the most outstanding thing in that interview. We felt with his understanding of the RAF Act, this is probably the right person. So I was part of a decision that appointed him and recommended his name to the minister.
And sorry, through you, Chair, I think part of that process included integrity assessments of all the candidates, and the results were acceptable as part of the psychometric assessments. So there was no indicators when he was appointed that we were going to experience any problems. But as Dr. Mabuya is saying, the CEO is delegated with the day-to-day operational running of the organization. The board could not, intervene unnecessarily unless there were issues which we monitored as and when it was required.
Thank you very much. I just have some questions of clarity because the comments are now becoming too long in the distance. So earlier on when you were talking, there were two instances when you said you did not get into the details of the implementation. Do you recall that? I want us to examine that a little bit, and I'll ask some specific questions. Let's start with the panel of attorneys. And I just want to be clear. The facts show that the term of that panel had expired. It was not terminated. there was an extension to the bid validity period of 6 months, I think, and actually think someone was suspended as a consequence. But there was an extension. So let's get something clear. So that is not where I'm coming from. The Road Accident Fund, in my view, is at liberty to source its legal services in the best way it sees fit. That's not my quibble. I want us to be clear. I am now going to get into the area of fiduciary responsibility and your understanding of how far it extends. Were you shown a project plan of the process? That included the number of matters before court, the number of matters going to court, and how the handovers would work, and who would oversee that process. Were you shown anything like that? If not, did you ask for it?
I think that that was, and we were getting reports on that there's a lot of engagement from claimants and issues were being resolved. So we were getting responses in terms of that process, that it was assisting with the physical location where people can access directly.
No, I'm not answered. I think you might be misunderstanding my question. They were offices. Let's call them satellite offices. Those satellite offices were shut down. So the reason I asked at the beginning of this segment of our conversation whether your issue was solicitation or the walk-in infrastructure. Right. So I am clear what you guys were trying to solve. We've agreed with it. I have no problem with the call center at all. That's not what I'm questioning. I am saying someone, and everybody has mentioned Nongoma or some place like that. There used to be a facility at Hospital A where I can go and knock on the door and say, please help me. Those we know, we're not speculating, they were shut down. Was it something you understood would be done as a result of your decision?
Yeah, so Chair, from where we are, I think that there might have probably been a misinterpretation of the intention. I mean, the reality of the matter, there were 6 walk-in centers at some stage. There was RAF on the bus, and then we also came to then moderate how things should be done. So there was no instruction from the board to shut down centers. At least let me put that on record. There is no instruction like that. We then adopted an omni-channel communication strategy. That included the call center. That included RAF, workshops. Every weekend, RAF is in a different region, communicating with claimants how to, to check their claimants. There's an email centralized point where basically claimants can talk to us. So I think, let me put that, we never gave an instruction like that. But the reality is we wanted to widen, increase access, and there are benefits of adopting the omni-channel strategy approach in terms of communicating with the claimants.
Okay, so I've worked with omni-channel. Let's dig into that word. Right, so what does omni-channel mean in practice?
You allow your customers to communicate with you in various ways. They can call, they can write a text, they can send a text, they can send an email, you can have social media presence, and you can also have face-to-face workshops. So it's really allowing diverse methods of communicating to make sure that you are directly in line with your claimant. When we declared that, I think it was the previous year, the year of the claimant, that is really what was pushing what we then needed to diversify how we reach the claimant.
Okay, so omni-channel depends on your definition of a channel, of your understanding of what your sales channels are. So I've got a background in sales and marketing. So let us take a store, PEP stores. So when you've got an omni-channel strategy, it means you can walk into a store and buy. You can buy online, right? You can buy in maybe 3 or 4 other ways. That's omni-channel. You are limiting in your answer your omni-channel to the communication rather than the administrative process. You get me? And so it demonstrates to me that even in your understanding, you appear to be under the impression that the physical channel, which is to talk to a warm body, because I only speak Sepedi, my English isn't good, and I don't have airtime, and I don't know the number. 1, 2, the former marketing manager of the Road Accident Fund, Ms. Hlamimate, was with us. The Road Accident Fund even cancelled advertising. They took gazebos and they threw them away. They were put in a store. Stationery, everything. Now, let's examine your omni-channel thing. So if your omni-channel, let's go with your argument. If your omni-channel is to say you can, for instance, WhatsApp us, but you've cancelled the advertising that tell me what the WhatsApp number is, how does that work? On your definition.
So, Chair, if I can just specifically mention that. The idea was never to close down the face-to-face. Face-to-face remained very critical, especially dealing with injured persons. Hence, my first point was, we've never given an instruction that people cannot come. I think the issue of language is key. We can't stop the 6 centers because people talk Zulu, talk whatever language. So that's part of widening our access to communication. So the WhatsApp part is just part of increasing how we must do it. The administration side is something we also thought through. So we never, ever gave an instruction that this must be cancelled, there was delegation that was offered to say, let us then look at how best can we increase access of claimants to our services. That was really the overall arching principle.
Okay, that much is clear. Let's now talk to the omni-channel, the communication part of it. So marketing material was removed and adverts were cancelled, even though they were already paid for. To inform people of the channels you are talking about. So there was an active effort to prevent people from knowing about this omni-channel that you're talking about. Would you say those kind of decisions were in line with your expectation?
No, Chair. No, Chair. I wouldn't say that is not what we expected.
The final question, I'll hand over to Honorable Isaac. The final question I then have is, so I've gone through your annual reports, all of them since 2019. So at peak, your direct claims were 35,200 and some odd. I think that was 2020 or somewhere thereabouts. Ms. Francois and Dr. Mabuya, you were there last year. Do you know how many direct claims there were at the Road Accident Fund last year? From 35,000. Okay, let me assist. This is not an exam. I thought you would have an idea. So 23, 24, there were 2,500 and some odd. 24, 25, they were just over 3,000. Fallen off the cliff. Off the cliff. The annual reports, the successive annual reports are read and signed off by all of you. Am I correct? The board collectively. So you saw these direct claims falling off the cliff. Did you ask, what's going on here?
Chair, there was a lot of interventions at the time. The direct claims, there was a process to actually increase it, and also the issues were that we didn't have sufficient funds for starters, but there was the costing factor, because when you're paying claimants, there's underlying cost in terms of the cost of the administrators. And also we have changed the model from outsourcing to insourcing. So the insourcing cost started to have a bearing in terms of how much would go into the direct claims. At the time, it was just that time where there was transition. But afterwards, then we started seeing some improvements. But there were other factors that were affecting the values of the direct claims at the time.
Okay, Ms. Francois, you do realize you haven't answered me. So I asked, so seeing that you were at 35,000 per annum at some point, and I think they amounted to about 15% of finalized claims, to 2,300. It was actually during your tenure when we started talking to one another in Parliament. My question is, did you ask, how are we falling off the cliff like this? That was my question.
We did, and we were given different reasons for it.
Can you please share those with the committee and whether you were happy with them?
Chair, the reasons we were given was that they were going through a transition. Remember that at the time they were enforcing the minimum requirements, the RAF1 form. And what we noted at the time was that most of the claims did not meet the minimum requirements. So there was a process to try and assist claimants in meeting those requirements. So that transition had a lot of challenges that would impact on the numbers, and also obviously the amount of monies that we had at the time, because we did not get an annual increase in our fuel levy. But we understood that there were issues at the time that were interfering with getting momentum on increasing the direct claims. But also, just the minimum requirements was a biggest challenge, because there was a time when only about, 3 to 5% met the minimum requirements. So we were under the impression that management are educating the claimants and actually engaging with them directly, so that they can actually bring in the information that will make them compliant, so that number would increase.
All right, no, thank you. I'll allow some of the members to take up this issue of the requirements, because it's also been a big point of discussion during the inquiry. Honorable Isaac.
Thank you, Chairperson. Good morning. We're in the afternoon already.
That's what happens when you fall asleep, Honorable Isaac. You wake up and you think it's morning. Good morning.
Thank you, Chair. Members from the previous representatives of the Road Accident Fund Board. Lots has been said, and indeed we're in an interesting discussion. We're talking to individuals that seem to be somewhat highly qualified, and of course, I've looked at quickly at some of your resumes, and obviously there seems to be, some awesome qualifications there, which is great. Now, it would be expected, of course, of individuals of your caliber and quality to be obviously be in a better position than others in terms of making qualified decisions. Now, I've just scribbled some notes and listened. Just for the benefit of South Africans that might be listening in or watching, please tell us, what were your salaries on a monthly basis? What were you earning? What was your monthly income as members of the board? So if somebody could just give us that figure, then I would continue.
I'll be quick through you, Chair. Thanks, Honorable Isaac. I'll speak to myself. I remember very well I was getting around 62,500. I was the chair of subcommittee. It was a retainer. Thanks.
Okay.
Sorry, Chair, I'll just have to look at it. I mean, this was till 2023. I don't want to give you the wrong figure. So I'll come back to you just in a minute. I just want to give the right figure rather than saying around. Thank you.
So you cannot recall, what is your salary?
At that point, it was, I think, around 82,000, but I want to make sure that I'm speaking, because I didn't expect the question, so I didn't prepare. And I haven't been in the board since 2023. So it's about 3 years now that I haven't.
Thank you, Ms. Msibi. I'll wait for the number.
Chair, yes, she's right. It was about 82,000 for chairpersons. And it wasn't a salary, it was a retainer on a monthly basis. So plus minus that range is correct.
Chair, I was deputy chair. My figure was about 65,000. It was a retainer, and part of the enforcement of the APP, you needed to at least spend 20% of your time on RAF matters per month. That was part of the compact.
Okay. Well, thank you for that. I'm just trying to educate myself and broader South Africans out there. Were you being paid any bonuses?
No.
Were you paid any bonuses?
No, we're not employees, so we're not paid any bonuses. We're not employees, so we're not paid bonuses.
Right.
Chair, if I can confirm, we were on a retainer only. So whether, in terms of other acts, the Companies Act would be expected to meet 4 times a year, and you get paid for that. So because we were on a retainer, we didn't basically submit an invoice for each meeting. It was just a monthly retainer. So that's really straight. Whether we had 4 meetings, 10 meetings, it didn't matter. We didn't pay, we didn't get any bonuses, we didn't get any incentives, we only received a retainer.
You had no perks whatsoever as members of the board?
No, the only...
Not at all?
No. The people who have a package is that the resourcing policy talks to employees, not board members. Board members is clear. We are appointed by the minister, and she even writes what exactly are we entitled to. And that's it. We get nothing more, nothing less.
No, that's good enough, ma'am. I just wanted to get that basic numbers so that, people that might be watching and listening are somewhat educated and understand the dynamics. Because you're very highly qualified individuals, so obviously you work for a retainer, you don't get any bonuses, you don't get any perks, you're members of the board. So, we need to understand how this works. Because, I've read here that historically, the boards, the members of the board sign off on major strategies, like what has been raised by colleagues, the issue of the attorney panel termination. You would make those decisions, you would sign off on those terminations, members of the board. The 820 or 830 odd million Bokomoso project. You remember that one very well, don't you? You're members of the board. You would sign off on those kind of projects. Okay. So, if you're members as members of the board, obviously you did question this. These matters came across at your board meetings. Decisions had to be taken. You had to sign off on these matters. Surely you might have been in a position to foresee some of the failures of these projects or decisions, or what was put in front of you. What do you think then? Why? Let me just cut to the chase. Why were you then removed as board members if you were doing such a great job for the Road Accident Fund? Why did the minister just decide to fire you guys? Or, well, maybe I shouldn't use the word fire, but just to get rid of you guys, because it says here, the board was dissolved.
Sure.
Suggesting that you failed to course correct, that you shared the blame equitably. The issue on, forgive me, Chairperson, through you, the issue on the suspension of employees that were sitting at home being paid salaries, being suspended. Surely as the board you were then aware of this matter? The matter must have come up for discussion at your board meetings. I don't know how long did the board meetings last. Did they last 5-6 hours? Did they last 2 hours? Did you do 3 a month at 60, 80 grand a month? I'm not sure of these things. I wasn't there. I'm trying to educate myself. But the point is this. You must have questioned as the board, these people that are suspended, that are being paid full salaries. What is the scenario? What is the situation? Or do you say that the buck stops with somebody else, the CEO, but you are the board? You take a collective decision in the running of the Road Accident Fund, which is a state-owned company. So, those were just some of the remarks I wanted to make, and then I'm going to again, just move a little quicker. The issue of when the RAF 1, RAF, the RAF 1 form was introduced, you were all well aware of that, right? You knew all about it. But when the court pronounced against, notwithstanding court decisions, pronouncing it as unlawful. So the court pronounced that it is unlawful. You were members of the board. You sanctioned it. You must have, as members of the board, heard and had discussions with the Special Investigation Unit. You were also informed, and SIU revealed certain information to you, members of the board. Must be, can only be. The fact that you were told about the default judgments had increased ridiculously. I use the word again. The default judgments had increased ridiculously. You as the board were there. You had to obviously express yourselves on it. But you are qualified, quality individuals that were inevitably fired by the minister. For what? Why? There's the issue, Chairperson, again, forgive me, through you. It says the total amount of default judgments issued against the Road Accident Fund for cost and fees until mid-23 amounted to 4.8 billion, not million, 4.8 billion. You were there. You oversaw these decisions. You talked about the AGSA's report. You looked at the financial statements. You resolved, according to your minutes, that the financial statements be signed off. There was the issue of the accounting policy. The minutes are here. This change is allegedly in contravention of the Accounting Standards Board, and that was pointed out. Claims liability was discussed. Again, you oversaw that, where they wrote of 300 billion rand to avoid appearing insolvent. You were there. You sanctioned it. Because you're qualified, you know what you're doing. And forgive me, there's the issue where the Road Accident Fund was reportedly dissatisfied with the outcome of the Morar Incorporated opinion. And we had a huge presentation last year, colleagues will remember, from Morar, and were advised, Morar Incorporated, to retract their advice. Morar Incorporated formally withdrew the technical opinion on 13 April, following a meeting held with the Road Accident Fund executives. This was discussed at the board meeting. So, Chairperson, I don't want to labor on. There was the organizational structure review. I suppose other colleagues will comment on that. There was the labor relations matters. To what extent were you up to date with the labor relations matters? Or was it just being handled by the CEO, etc.?
Sorry, Honorable Isaac, I just want to assist them because you're going through a number of issues.
Yes,
so
yes.
Could we just give them an opportunity to deal with the matters in turn? Because I worry that we might get lost in the weeds. Thanks.
I understand. Okay, sure. So I'll
maybe they must deal with the issues raised so far. And you're also welcome to ask questions of clarity if that's necessary.
I understand totally. Thank you, Chair.
So Chair, I'm going to start with the issue of being disbanded and the reasons behind them. Honorable Member, I think we need to understand that the relationship between the accounting authority and the accounting executive is very strategic and very important in ensuring that the environment is conducive for the board to exercise its fiduciary duties effectively. Because the accounting executive is basically the shareholder, playing a shareholder responsibility in the organization. So I think it's very important to understand that in the sixth administration, the board had very clear support from the accounting executive. I mean, when we were appointed in 2019, the then Minister of Transport met with the full board. He gave us a very clear mandate in terms of what were the burning platform issues at the organization at the time. And he made them clear, and they are presented in the first, I think, 3 slides. And we also gave some references in terms of what he stated to us, and also that was included in those annual reports. So he gave us a mandate to turn around the organization. It was very clear. And he was part of the crafting of the 5-year strategic plan to ensure that what he put on the board performance agreement was in line with that 5-year turnaround strategy. So there was very close alignment and engagement in terms of expectations, you know, from the executive authority to the accounting executive. So we were basically working closely with the shareholder. And at the time, we had in our board a representative from the Department of Transport in the form, which is required by the RAF Act. It's supposed to be the DG of the department, and he was part of that board. So we were very close in terms of the dynamics of what was happening in the department and the expectations, and they, as part of the board structure, they will give us guidance in terms of whatever we were doing, and because they were part of also the decision making of the board. So that worked very well for the board, and then that's when we started implementing the strategy, and we had the same support with the Minister, Honorable Minister Chikung as well. She also sat with the board, gave us expectations, and directed us whenever we needed direction. And we had, at the time, it wasn't the DG, we had a DG representative, again from the Department of Transport, sitting as part of, a board member, a non-independent member. So again, that flow of decision-making, the support and guidance was very clear, and also to ensure that what we were implementing was in line with the 5-year strategy. The APP, remember the APP is approved by the minister, and as well as some of these things, they get presented in various parliamentary subcommittees. So, and whenever we present to subcommittees, we had to be accompanied by the honorable ministers. So that relationship was very important. But we didn't see that in the 7th administration. I mean, from the time the 7th administration, Minister Chrissy started, up until she dissolved the board, she never had a meeting with the board to actually craft her expectations like we had with the other ministers, and also deal with very pertinent issues, because we're turning around the organization. There were issues about the legislation, and obviously she had different thoughts and directive, but which is acceptable because she was a different shareholder and she had different views. But that was very critical to have the ministry sitting with the board in terms of clearing the expectations, clearing the strategic direction. If there were changes in the strategic directions and the legislation that is a pillar of this organization, that did not happen. So it was clear from the onset that something was off, Honorable Chair. But then what happened was we used to get a litany of instructing letters coming from the ministry offices, which was unusual and unprecedented, given the fact that the board is an independent structure and obviously providing oversight, but also the minister played a different role in terms of the different level of oversight. But for us getting instructing letters, that brought and created a hostile environment that led to, unsettled environment for us as the board. And we were not able to execute our mandate independently and objectively as we were supposed to. But then we had the the Deputy Minister of Transport as well, who was delegated to take responsibility for oversight of RAF is one of the transport entities. So we're getting letters from the ministry, the minister herself, sometimes we'll get them from the Deputy Minister of Transport. So the environment was extremely unhealthy, and we did not understand from the time she was appointed. But we never had proper engagements with her. Even the Deputy Minister, the way he would engage with the board, he will give us, use very hostile language, which was really destabilizing for us as a board. And when around June 2025, when she sent us a letter of asking us why she would not dissolve us. She wrote one letter to all individual board members. But what happened was that we know that every board member responded differently, because remember that a board is a collective and we are appointed in terms of our technical knowledge and experience, and also we are expected to execute our fiduciary duties independently. So, and we also played different roles, like you've seen some of the members sitting on various subcommittees of the board. So they responded differently. But the last letter to disband the board was also a one letter with very, explanations reasons that did not make sense in the bigger scheme of things. So we don't know. To answer that question, we don't know why we were disbanded. But also I think historically, at the RAF, this is not the first board that was disbanded, by the way. But yeah, I think that question should be brought before the accounting executive as to the reasons. But I'll allow members to get into the other issues.
Honorable Esak, if I can mention, in any organization, especially this, how the RAF Act is structured, the tone is set from the top. In our case, the tone is set from the executive authority. My colleague has demonstrated the support we got from Minister Mbalula, the support we got from Minister Chikunga. The same didn't prevail in this particular, it was after the 29th of May elections. We, as the people, myself, Moses, Tembi was already gone. We've never met the minister as a board. The executives, I don't know for the executives, but as for the board, if I meet her in the corridor, she won't know who I am. That's just to demonstrate where the hostility came in. What happened, we get a litany of letters. More than 12, 15 letters instructing us, interfering in our decision-making process. So that was a hostile environment. The first time, as a board, we met the executive authority was an AGM with the deputy minister. Very hostile AGM, giving us marching orders, and in a way that we didn't even ask questions. We were all shocked, and that was our first interaction. Now, that was completely unprecedented, because previous ministers set the tone, gave us strategic direction, told us what they expect in terms of the APP. That's what we expected, because we are skilled professionals ourselves. So, but critical, Section 10A in the RAF Act says a DG representative of the ministry must be appointed to the board. We had it with Minister Mbalula, we had it with Minister Chikunga. This particular minister, 12 months, no DG representative. Section 10B of the same act says the board skill sets must be diverse and it must enrich the discussion. We are allowed not to agree with one another. We sat with board vacancies for 12 months. We never had anybody with HR skills, if I can mention that specifically, that stood out. We have a bargaining unit. We have a huge dynamic unionized environment. Here we are as a board, not even heading a HR skill. The next person that was key for us was an ICT skill. It did come, it came in late, but I'm just demonstrating the relationship between the executive authority and the accounting authority is key in driving the organization in the right direction. Then we were dissolved. We were not necessarily surprised because we were used to letters. We were used to letters. I don't want to go to details. Some of those letters were interfering with our accounting decisions. So in a nutshell, I don't have an answer for you, but I'm painting the picture. We felt abused. That's exactly how we felt, but we had to live with the order of the day. So that's one part. I want to mention the second part of the issue of the suspensions, the HR matters. I think you mentioned that specifically. So RAF has got a resourcing policy where it clearly defines how do we recruit people and that sort of thing. So we normally follow that with executives, especially the CEO, the board would convene, recommend 3 names, the minister would appoint. So that we normally follow to the latter. There's no issue. Then on the issue of employees, the employees, there is a whole lot of labor-related policies, but critical, there's also a performance and reward policy that we use to make sure that we are aligned with the APP. Now, when employees get employed, they go through an induction process as per our conduct, but also in addition, the manager who oversees those employees must sit with them and go through KPIs with them. That's part of our normal policy process. They are also expected to do 6 monthly reviews on their performance. That's part of what is really happening. Then once the APP is done, there is now another process to allow alignment in terms of what the business unity has set for itself if it's aligned to the APP. Now, the reality of RAF, that is guidelines, policies approved by the board, and we are all aligned on that. You then get into a hostile environment where you are changing and moving the organization from its old habits into a new vision, new mission. You're trying to inculcate new values into the organizations. Then there's, a backlash or maybe hostility around what you are trying to do. That process of trying to move people into, this is a new dawn for RAF, led to disciplinary actions. A lot of employees really went through that, and that we were getting reports through REMCO of what exactly is happening, deficiencies in the process, deficiencies in even managers who were not necessarily capable of managing difficult cases. That we got ongoing results on that, but we needed to follow the labor relations law. We needed to follow the basic conditions of employment. So, as hard as it could have been, you can't then put the organization at risk by saying, let's get rid of these people, let's not pay them. You still have to follow the process because we are governed by labor laws of the country. So I just wanted to bring that specifically. Thanks, Chair.
Through you, Chair. Thanks, Honorable Isaac. I want to just touch on 2 things. I think the disbandment or being fired, and I mean, obviously this is a personal issue. It's a sensitive issue depending on the person. I think for me, I've served probably for the longest or as long as anyone there, under Honorable Dr. Bladen Zimande, Honorable Fikile Mbalula Chugunga as well. I think by March, I've already made my assessment that the moment we complete our audit, I'll tender my resignation. Unfortunately, that was surpassed by the event. And I think it's just when you want to have an impact on an organization and you don't get the level of support or airtime that you need to be able to be effective. As a professional, at some point, you need to reach a point where you decide whether Do you get stuck or do you move on? So yeah, that's my answer, but I wouldn't ventilate the issues. And then I think you mentioned a pertinent issue around the default judgment. I think we were tracking that quite closely. And when one looked at it from a materiality point of view, obviously we can't underplay the 4.8 billion that you have mentioned over a period of time. But when you look at the number of the default judgments based on the audited report internally and also as verified by the AGSA, it was that number was around 3 to 5% of the litigated matter. From where we're sitting, it sounded not material, but it remained a concern. And then the question was posed to management to say what is happening in this regard. I think they gave comfort around the process to say that, I think they called it a resentment process, where there was a default judgment, they are not happy with the settlement, they'll go back to the court again. But I think the other facts was that the court doesn't rubber stamp this thing. Even if something is a default judgment, the court would have still applied its mind. It's not like it's a wasteful expenditure, and I think there was an assessment to that effect as well by the AGSA back and forth with management to give comfort that there is no fruitless and wasteful expenditure. But to give you comfort, yes, it was an issue. Was it material? No, it was not material. Was there control in place to improve this? Yes, there was control in place to improve this. Thank you, Honorable Member.
All right, thank you very much. Honorable Esak, you are on 30 minutes. So, no, no, it's a new day. It's a new day today. Let me ask honorable members. So lunch is from 1 to 2. Do you want to break now, or do you want to take one more member and then break? Let's break now. Okay, so the time is, I can't see these days. So it's 10:01. So can we be back at 2? Please. 50 minutes, 54 minutes. It's 6 minutes past. Thank you. The canteen is around this way. So you go out, turn right, and go straight down. You can also have lunch there. It's your tax. Or you want us to continue after midnight, Honorable Beasley? No. Okay. You looked unhappy when I said we need to finish before midnight. So it's going to be Honorable Skosana and then Honorable Beasley and so on. Okay, thank you very much. I just wanted to capture something. It was said, and I should have paid better attention, but I didn't. When I was asking about the panel of attorneys, one of you said your understanding was that the discontinuation wouldn't be sudden. So in other words, if there was a matter that was running, it would then conclude, but then no new work would be given. Did I capture that correctly? I just want to be sure, because it takes time for us to get the transcript.
Yeah, thank you, Chair. I think what I was trying to bring there to your attention is that there was a documentation, and it was also categorizing matters at different stage. To say that there were matters on trial already. You would expect that the lawyer will just run it off, but there would be matters that perhaps they are relatively new. It's better to hand over. But like I've said, that document is March 2020. I haven't read through it. I just discovered in my archive.
Okay, no, thank you very much. I just want to, so my understanding is that a service provider whose contract has terminated cannot continue working because your contract has, I'm not saying it's been terminated, I'm saying it's terminated in that the term has come to an end, right? Otherwise, you're going to keep billing without a contract. Do you understand that? And then the Auditor General will say it's unauthorized expenditure. You hear what I'm saying?
I see where you're going, Chair.
So, and therefore, my expectation therefore would be that those law firms that had matters in court would continue until those matters are concluded, but not be given any new work.
Honorable Chair, I don't want to guess. What I'm saying is that on that document, I saw there was a page where they are showing categories of different matters, the volume. Whether the intention is to have a strategy for running off each of them and how management was going to do that, I haven't refreshed my memory on that document. But the fact that there was a thinking in categorizing of those matters, it gives one impression that perhaps there was a thought-through process. But I don't want to, I haven't even seen the contract, how it's structured to say whether a lawyer can run off the matter if it's at a certain stage despite contract expired. I don't know those details. But the impression I got is that that document seems to, it's not adequate, but it seems to have some thinking around it. But we can share it with you, Chair.
No, sure. Also, you were not the only board member, so so maybe your colleagues' recollection might help. I'm going to look to them to see if you have any recollection, and I appreciate it 6 years ago.
Yeah. So, Chair, because also, remember when we had panel of attorneys was one set of experts, we also had medical panel kind of things. So, inadvertently, if you are in the middle of concluding a matter, it doesn't make sense to suddenly return a file. We need to allow you to finish, but then bring back the file so that we don't allow you to take new work. So what you are doing is based on the old contract, because that would be disruption unnecessarily. So that would work for the attorney, that would work also for the medical. But the second thing I wanted to mention, I've just shared with Ntombi, one of the things we had forgotten. Remember you asked about a project plan. We couldn't remember whether we had it or not. I've shared with her the plan, the panel of attorney plan, and the discussions we had as a committee saying management must give us comfort of the new operating model, the capacity they are having in handling incoming files. And there was also a handover file that was, so we've shared that because we had completely forgotten about that plan to say, how do we mitigate? And mainly because it happened during COVID time. That was also very important. So we just found it, fortunately, and we've shared it with Dombi.
No, thank you very much for that. So I'll ask her when she comes in that she just emails it to the members. What we were told eventuated in any event is that, let me start here. So what you are sharing as your expectation is entirely reasonable. That if there is a matter that is ongoing, it makes no sense to take it off, give it to someone who must start from scratch and delay the entire process and the claimants and so on. That makes sense to me. However, that's not what happened. That's the difficulty the committee has had. And that's why it's important for me, for us to separate whoever may have a grievance about not having been extended. Nobody is entitled to a government contract in South Africa. There is no such entitlement in law. So I have no time for those people. What I have difficulty with is what actually happened, which is that, notwithstanding the fight between, part of the fight between the attorneys and the road accident, that the matters were actually ongoing. And we had Mr. Philip from the Road Accident Fund. We've seen memoranda from the Road Accident Fund, where internal memoranda to management, not to you as the board, right? Where they are grappling now with the mess that they are dealing with, because some of the files are here. Some of those files are now with claims handlers. The claims handlers are not attorneys. They are now expected to also appear in court. Some of the internal attorneys are expected to be in 3 courtrooms at the same time. And it's impossible for anyone to do that, right? Physically not possible. Apart from the fact that Mr. Philip also said to the committee that typically for each case, at least for each person who's going to stand in court, there are about 3 people that support them. There'll be a less experienced attorney, there'll be a paralegal, at least 2, typically 3. The Road Accident Fund had no such capacity, still does not. You understand? Which has happened throughout your respective tenures. And my contention is that at some point, because later on we will then deal with how that ballooned the cost per clay, the legal cost per clay. So what I want to know before I hand over to Honorable Skosana is why it is, even if in COVID time there were issues, why was this matter still not resolved at the beginning of 2025, where it was clear that the people that you have need help? I can also read you emails as part of our submission from the practitioners themselves inside the RAF who say, I can't cope. And Mr. Philip said each person has up to 4,000 court cases each. So I just want to know, did at any point in 2023, 2024, when COVID is long gone, have a conversation about how is that project going? How is it affecting our operations? How is it costing us as the Road Accident Fund? If you settle me on that, I'm good. Because we agree that if your contract is not extended, you actually have no right to continue working because your contract has not been extended. So we know that didn't happen.
Honorable Chair, I think we hear you. We hear you, and I think it's correct that even you'll see on the email you're going to receive, most of the structural matters were ventilated specifically around that. But what the main issue is, we then had benefit of hindsight with what didn't work and what worked. Then what did we do then to try and remedy the situation? So I'm not going to answer that, but I just want to say, I hear exactly your point. You say, as a board, we were getting quarterly quarterly reports from the CEO's office and the executive team. Suffice it to say, maybe the colleagues saw it differently, but I do know most of those items served at two different committees. They served at opposite. They also served at the Regal, which was a legal kind of committee which had legal expertise, because it was best suited for them to look at what the impact of the decision. In one of the questions we even asked, what is the impact of this decision? And we then asked Regal to apply its mind around this decision. Is it working? Can we revise this decision? So let me pause there, Chair, because it's along what you're asking.
All right, I'll just make a comment. The sense I am getting, and this is my conclusion, is that sometimes you would ask the questions that you would ask. You wouldn't follow up as assertively as a board needs to, especially when there is a high risk involved. You understand? Because if a decision is taken in 2020, by 2024, nobody has said, guys, no. We can't continue like this. We need to have a plan, let's say a hybrid plan, where we've now had, even with hindsight, we've now had the benefit of this experience. We can see that it's taking long to get internal capacity. And therefore, let's have a combination, attorneys and internal. As we increase the internal, we reduce the attorneys, right? That would be sensible. That conversation then does not take place. And that, in my view, is a shortcoming. And like I said, I'm not fighting for attorneys here. Let's leave the propaganda and the rhetoric on Twitter out, right? And just deal with these matters in a sensible way as we can. And my sense is that you could have been more assertive. We've also had the benefit of the minutes of the board, and we're going to go traverse some of them. It feels like you generally took management's word, assurances. We can deal with some issues later, including the accounting policy change. That management would say something, you would raise a concern and never get back to it. That's my sense. Honorable Skosan.
No, thank you very much, Chair. And good afternoon to everyone. No, we welcome the presentation that we received from former board members of RAF. Just a couple of questions from my side. Before you were dissolved last year, you placed the former CEO on a special leave, and subsequent to that, you suspended him. So I just want to find out if the behavior that led to you taking a decision to suspend him, was it for the first time seeing that behavior from him? Prior to that, was he doing his work as expected? Was his behavior up to scratch? Or maybe it has been long time coming, but then just you were not brave enough to take that decision to suspend him? Thanks.
Thank you for that question, Honorable Skosana. To answer the question directly, it was the first time that he directly defied the board. So that was an act of defiance because we had an invite from a parliamentary committee that we actually had to do our accountability to, and we have been reporting to this committee. And then all of a sudden, because of a particular matter that in a way affected him directly, then he was openly defiant. So it was the first time that he was openly defiant to the board. I mean, I think Dr. Mabuya has very cleared the fact that he was a very hard person, basically, and strict when he was handling matters within the organization. But we needed somebody who is a turnaround, you know, specialist when it comes to leading a complex organization like RAF. But I think I've said this before, that there's a difference between performance and misconduct, because we had challenges around performance, but the organization he was leading was performing in terms of the committed APP plan and also the overall strategy that was approved. But he was difficult, but it was the first time that he defied us as a board. So we had to act accordingly.
Okay, no, thank you very much. NUMSA, they described him as a bully. So I just want to check that prior to that incident, were you not at any stage get bullied by him as the board?
Chair, if I can, so Honorable Skosana, thank you for the question. Let me mention that when we are part of a board, we all have diverse personalities, different expertise, different experiences of how to govern organizations. He was a strong personality. That much I must confirm. I don't think anybody can deny that. Very strong personality. We needed to be firm ourselves. I mean, we had a mandate to carry in the prescripts of the RAF Act. So, bullying tactics vary from where you are. But at C-suite, you can't be above the organization. On the day, for instance, we decided to suspend him. I even articulated those words. You can't be above RAF. RAF has been there before you were here or after. So I think it's just a matter of what do you see at risk. We all have different personalities, even the four of us here. But once I start acting as if the organization is above me, we have to remind you that no, you are an employee. You are not necessarily RAF. So I would say, whether bully or not, it was still within our mandate to call him to order. And that's what we did.
Okay, no, thank you very much. Now, coming to the issue of the mass suspension that took place at RAF, I think the NUMSA says that they raised these challenges with you as the board. I think after there was disagreement between them and the executive management, particularly the CEO. But now they are saying the response that they received from you as the board, it was that you can't get involved because it is the responsibility of the executive management. You said if you are involvement, that will be an interference. So I just want to check that, because my understanding is that part of your responsibility is to play an oversight role to the executive management to make sure that they do their work. So if workers, organized labor, a union that represents the majority of workers, says we are unable to find each other, ourselves and the executive management, my expectation is that obviously you can't come up with resolutions on your own, but you have to engage the executive management, say these are the issues of mass suspension, what is happening here, try and get the answers and advise the executive management to engage with the union so that they can resolve that matter. But to say to them, no, we can't interfere, we can't get into that matter, that's the space of the executive management, it will amount to interference. I see that as dismissive. So what is your comment about that?
Chair, I'm just trying to think about this meeting where NUMSA brought things to us. I don't have a recollection, but I'll allow my colleagues to sort of bring that. I don't remember that. It could have happened. I'm not saying it didn't happen. I just don't have a recollection of that specific meeting where they engaged us as a board and we dismissed them. So I'm not sure if maybe they can give us timeline, maybe that will help us. But let me allow other board members to rethink, because I don't remember that at all. Yeah.
Chair, I also don't remember when NUMSA approached us as a board.
Yeah, through you, Chair. Thanks, Honorable Skosana. Same as here, since the 7 years I've been there, I don't recall being in a meeting with the bargaining council, to my recollection. Thanks.
Okay.
Thanks. I equally also don't remember. And I can't even recall a letter if they probably wrote to the board. I can't remember, so we'd have to look into that. Thanks.
Okay. No, let's pass that one. Now, coming to the issue of IPSAS 42.
Honorable Skosana, can I stop your clock?
Oh, okay.
Because I do want to just ask something in relation to the line of questioning that you are leaving. So I've stopped the clock. Can I do that? So, I do want to ask as a follow-up, because I think the interventions of the board sometimes are important. So last year, I received, myself and Honorable Beasley, received a complaint from a former, now reinstated Road Accident Fund employee, and I wrote a letter through the Secretariat to you, Ms. Francois, as chair. You might recall. And that employee had been dismissed for putting up her hand to ask a question in a meeting with the CEO in Durban. She then applied, she then went to the CCMA, and the CCMA said she should be reinstated. The Road Accident Fund said they won't reinstate her. She went to the Labour Court. The Labour Court ruled in her favor and even overturned, so basically she had a clean sweep at the Labour Court, where the Labour Court said even on some of the issues the CCMA agreed with the employer on, they were wrong. So they must reinstate you. And the Road Accident Fund did not reinstate her. They instead appealed to the Labour Appeal Court. The Labour Appeal Court found against the Road Accident Fund. The Road Accident Fund then ignored the Labour Appeal Court ruling. It was at that point that, Ms. Francois, I wrote to you. I never heard back from you on the matter. And I remember in that note, I said, I know you don't deal with these matters day to day. You are a non-executive. But I think state entities must comply with the courts. She then went to apply for an enforcement order, which is additional expense. And they ignored it. When I spoke to her, the day I spoke to her, she said she had been contemplating taking her life that day. She is back at work now. They are refusing to give her work. She sits in the canteen. It's been months. That's what NUMSA is referring to. I have the same experience of the board not coming back to me. And I'd like you to address this issue because it's important. You will also, in the annual report that you just oversaw, for the financial year that Ms. Francois, you were chair, the Road Accident Fund has a wellness section there. The worst problem by far is mental health. You would have noticed that, due to workplace issues and so on, upon reading the report. So NUMSA is not making this up. So we then had a gentleman called Mr. Litswalo, I think it's Mutsuding, his name, I might be getting it wrong, but he was in ER. And he shared with the committee that the chief executive basically made each appeal decision and would insist that they appeal, even if the court rules in favor of the employee. So let us go back, especially Ms. Mabuya, and I do want to ask you, Ms. Francois, to speak to this issue, because we are also human beings. We want state entities to show, especially in the context of the values of the Road Accident Fund, we want them to behave properly. We want them to comply with the rule of law. So we've taken evidence under oath where we were told that the only person at the Road Accident Fund who decides whether a matter is going to be appealed or not is the chief executive. And that's who Honorable Skosana was asking about. And I'm giving you a real case. So let me start with you, Ms. Francois. What did you do about that issue after I forwarded it to you? Because I actually never had the benefit of a response from you, number one. Number two, Ms. Mabuya, I would like you, with the benefit of what I've just shared with you, to then go back to the question that Honorable Atkinson was asking earlier about your expectation of somebody who is a leader. Because personally, I have difficulty with somebody who does not want to comply with courts.
Thank you, Chair, for that question. I must say that I received a couple of letters talking about HR matters suspend. I think about, plus minus two, I can't state. But in every situation, I will speak to the CEO. We had bi-weekly meetings with him. Sometimes he wouldn't be available, but I would write to him. There would be a letter coming from myself, asking him questions and asking him to give me assurances that the matter is being dealt with within the labor law prescript in this country, and is also not compromising individuals. And he will respond to me and he says, the matter is being dealt with within the laws, and also he will take the matter back to the REMCO committee and bring it back to the board. So there was never a time where I receive a letter and it didn't have a response. If it didn't come directly to the person, because when it comes to operational matters like HR matters, I would write to the CEO, raising my expectations, raising questions, and most of the time he'll respond, and then he will give me assurances that the matter is still, it's either at CCMA or labor courts, but he will give us feedback in terms of what was happening regarding that matter. Because again, we had to allow him to ventilate the processes within the prescripts of the law. But Chair, I don't remember not responding to any letter coming from yourself. If I did, I don't know. I'm sorry about that. I don't remember.
Look, let's not personalize it, so forget me. The point is, I'm giving you a case study now.
Yes.
There is a labor appeal court ruling.
Yes.
It's simply not being complied with.
Yes.
We're a country of the rule of law.
Yes.
Right. So that's the one thing. The second thing is that you have people under suspension for 5 years. The Road Accident Fund policy says these matters must be concluded within 90 days, I think it is, right? 5 years is a lot. Somebody is sitting at home. That's why we had people breaking down and crying in committee. So I do think you owe Honorable Skosana actually a proper answer, right? In respect of why it is that under your watch, it's not just about what NUMSA said. Why is it under your watch? People were on suspension for 5 years. Lots of people. And then rulings of the courts were ignored.
Thanks, Chair. I think it's a valid question. If I can just bring some of my recollection. I started by saying we have policies which are completely overseen by the board, and we have category B policies that go through the executive team. The reality of the matter, quarterly reports that were presented at REMCO covered ER matters, which is mostly these cases we are speaking about, They covered labor court matters, and we also zoomed into why these matters are not being resolved, because we were concerned equally. Right, you would act for 5 years. If you are acting, the labor laws don't agree to that. If you can act for 3 or 6 months, we might as well promote you or go through a recruitment process and place you there, because acting for 5 years, you're almost demonstrating competence of what you are doing. So these particular matters were ventilated at the RAMCO continuously. The issue of the numbers, the biggest gap, and I did mention that, we had vacancies on the board, and one of the key vacancies, in my view, was that we didn't have an HR expert on the board. We then had to make sure that we deal with these matters irrespective of that lack of vacancy. And specifically myself, my interest was always on the wellness side, the mental. From COVID side, we saw, I shared the numbers earlier on and the number of people we lost. But what is real? There was something else happening, simmering, even if it didn't come in the form of a report. There was clear evidence that our ER managers were not competent. They couldn't handle these matters. And we were asking the CEO, is there any way we can get new people who can handle these matters? Because there was just a lot of time wasted on handling ER, court cases, these kind of things. Now, the fact that court decisions were defied, that particular matter never emerged in terms of the quarterly reports. What we were aware of clearly was that our ER managers were definitely not up to scratch. And hence, we then said, you are sitting with all these hearings, we are wasting time, but people are getting acting allowances. I think it was even quantified at a certain stage. Why are we doing this when we should be focusing on paying claims? And if somebody can act for 5 years, why don't you promote this? Because we are also violating labor laws. Those were the typical discussions we were having when we realized that something else is happening. We are not getting a report giving us exactly that they are defying court rules, whatever. But these matters are never resolved. And we keep getting the same answer over and over again. It did create a frustration, Chair. It did, because honestly, you just sit on the organizational design. You see everybody, most people are knowledge workers at RAF. So some of the minimum qualification is actually there. But on the ER side of things, that was the biggest gap. It's not the only one. Even on the ICT side, it was a big gap, because when we implemented digitization, that was clearly highlighted. So I'm saying not everything came clearly to board. It came in other formats. We could still dig in and see the gaps that this does not add up. But we didn't get a report that I have now, as in my report. Remember, we get a CEO's report every time. I have defied that we didn't get, but we could just tell indirectly that something else in the ER department is happening, and the wellness reports, very true, were clear. They were showing mental issues to a level that was not manageable. And we even asked, do we still have the same service provider? Have we changed service providers? What has happened? And it was clear the service provider was also there, to an extent that even the executives were working late hours. I said, this is not normal. Work-life balance doesn't allow to this. These people, when do they stay with their families? There were no consultants helping them on some of the decisions. So, as I'm saying, those were indirect measures we could tell, but we didn't get a report that talked directly to that.
No, thank you very much, Doctor. Can we therefore say that the executive management was misleading you on some of the things, particularly matters that relate to the ER?
Chair, I would say yes.
All right. So how do you feel as former members of the board when you are listening to painful stories that were ventilated in this committee? I assume that you were following this inquiry. I think we have had a number of people, others, they cried in this committee, more especially in relation to ER matters, how they were suspended, how they were fired, processes not being followed and all that. How do you feel, I mean, as people who were playing oversight role to the executive management, and all these things are attributed to the executive management in general, but to the former CEO in particular. But there's people who were there playing an oversight role. When you sit and watch TV and you hear all these painful stories, how do you feel about that?
Honorable Skosana, I didn't follow everything, but I did follow some of them. Let me also just make that disclaimer up front. But wellness matters are matters that are close to my heart, purely from my profession and some of the work that I do. So I didn't feel proud. Firstly, I heard most of the things for the first time during the witness testimonies, things I've never heard before. And I had my own affirmations that probably this is why sometimes we're battling to get a report on this matter, because we didn't know this tip. So I had some of them here for the first time. It didn't make me feel proud. I won't say here, it didn't, because I felt, had that matter been addressed adequately when we were questioning ER deficiency matters and what is happening there, we could have dealt with it directly. So it also meant that even if we were using surveys, some of them were adequate, were accurate, some were not accurate. So really, the long and short of it, it's not something to be proud of.
Okay. Yeah, coming to the issue of IPSAS 42 and the HGSA and the court case and that, I hear today Ms. Francois, I think you are saying that every time when the matter of alternate dispute mechanism was raised, either by us as parliament or by the minister or any other key role player, you would always take steps and initiatives to meet with other key stakeholders like your HGSA, your ASB and stuff like that. However, when I remember very well, the last time we were deliberating on this matter, when we were still the chair of the board, somewhere last year, I think you as the board, you were united with the executive management on the fact that the issue of litigation is the only way to go. At that particular time, we were not as flexible as you are today, because today I hear that you are flexible to say we did engage that, but I think on that day you came out as people who are defending the position of litigation, to say we've got rights in terms of the law, in terms of what, we were explaining all these things. So I don't know why they changed now, because now you sound flexible, like people who were willing to look at other alternative mechanism of resolving the matter. Whereas on that day, when we were here with the executive management, I think you were clear to say, no, no, it's within your right, and then explaining all these things in relation to IPSAS 42. Can I get your comment?
Through you, Chair. Honourable Member, I think let me just explain how the matter started. I mean, that will actually answer the question. Initially, I think that this matter was asked by one of the members in terms of whether taking the Auditor General to court was the right, person to take in regard to this matter. I think we need to understand that the first time this matter came up was after the change of the accounting policy. For the first time, RAF financials, the Auditor General wanted to disclaim the organization. And the first process that we initiated, I think we've stated that, was we created some sort of a panel with all the assurance providers, including the Auditor General, ASB, Office of the Accountant General, and all the affected parties, to just try and just to take the process through the intergovernmental mediation process to try and find ways of clearing the matter, because at that point in time, it was still a very new technical matter. And then the RAF and management, we thought that the matter could be resolved at that point in time. So the mediation process continued up to a point where the AG decided that she has to issue the report without following the mediation process completely. And so when that happened, that's when, after the board have gone through the process of seeking advice, legal advice, technical advice from the various professional bodies that we've stated, the first court action was to request an interdict on the Auditor General report based on the opinion to actually disclaim the RAF financials. In fact, the audit opinion. So the first issue was an incorrect, according to alleged incorrect legal opinion. So that's why basically it wasn't about the audit reports and the audit opinion based on the change in the accounting policy. So at this stage, after the mediation, internal mediation process have failed, RAF had no other process to fall under, because at that point in time, we even look at the courts as, you know, some sort of an independent mediator to give us direction in terms of how that matter could be resolved. But unfortunately, the matter continued. We didn't get the interdict, and then it went to the 17th grounds, where now the RAF had to explain why they were not happy with the decision. So, but the point that you're raising was, when the various ministries asked us to consider other alternate mechanisms, we basically continued to engage. I did state that, to engage the various parties to try and find an amicable solution, irrespective of the fact that the matter was still in court. So there's no change in terms of stance or position. We were continuing, we're trying to resolve the matter out of court, but because the matter was already in court, given the fact that the original dispute was the audit opinion, because if you look at, you know, I'm not supposed to be getting into the intricacies of this matter.
Okay, no, you have made your point.
Have
So-
I? All right.
Yeah, because we've got a challenge of time. Now, coming to the issue of vetting of executives, I was reading your own statement here on number 41 that deals with the vetting of executives. So when you read 41.3, it says the board consistently monitored and requested updates from the executive on the submission of required documentation to the state security agency and other regulatory bodies. Executives represented in writing that all necessary documentation had been submitted. However, it was later confirmed shortly before the dissolution of the board that the CEO had not submitted certain minimum required documents. I will end there and then go to 4.1.4, where we are saying the board undertook all reasonable steps to ensure proper vetting and management of executive positions in accordance with Section 11 of the RAF Act. So this statement that says the board took all reasonable steps, I'm not convinced that you took all reasonable steps, because when you read 4.1.3, it would look like you only rely on what the executive management was saying. You got maybe written submission from the executive management, but without supporting documents where they show you the emails that they've written to the SSA with all the attachments and the response maybe from the SSA. Because I think if you had received such things, what had transpired wouldn't have transpired. So it would look like you were only relying on what the CEO or whoever on behalf of the executive management was briefing you to say, maybe that briefing, it was done in writing, that they would write, they would make a written presentation, but there were no supporting documents to show that indeed there is a communication between them and SSA, and that the documents of those particular members of the executive were indeed submitted. So in fact, you did not have proof that those people information were submitted for vetting. any comment on that? Because I'm surprised when you say you took reasonable steps. I mean, if you only rely on the briefing from the executive management, you can't call those reasonable steps, because there's nothing beyond what they said that you did to actually satisfy yourself that indeed all members of the executive management are vetted, or their information has been submitted to the relevant authority for vetting processes.
Thank you, Chair. Chair, let me start by emphasizing the role of the board in terms of oversight. That the role of the board most of the time starts and ends in the boardroom, and it's based on trust. And there's 3 levels, I think, 3 levels of assurance that we receive as board members or any oversight subcommittee. The first one is management accessions, which is the reports that comes from management that goes to the board. And that's the first level, because management are the ones who implement, all the strategies, and they run the day-to-day business. And the second level would be independent internal auditors, because there's this thing called combined assurance. So we basically got and received those assurances from management themselves, and then internal auditors. They didn't raise issues around, any issues around vetting. When the CEO raised those matters and said that the processes, and in fact, they were blaming, management were blaming SSA to say that SSA has a backlog, with all the entities and departments. And those statements were made in this committee as well, a number of times. Because again, just like you, as a committee, you play an oversight role, we also relied on the reports that the executives will bring to us at the board, and we had no reasons not to trust them, up to a point where we had to ask for evidence. Auditors actually go through the evidence, and then they come back to us. That's why when we looked at their reports and nothing was raised, there was no red flag or reasons for us to question what the CEO and the executives were presenting to us, because it was really going to create an unnecessary hostile environment, as if we don't trust what management is bringing to us. And then the third level would be the Auditor General. Over those the 5 years, we never really received any report talking to the vetting of executives as well. So that's those 3 lines internally that the board receives various assurances, independent, directly from management, internal audit independence. Even though they're inside the organ, they still have that independent mental state, as well as the Auditor General. So we had no reasons to believe that what the CEO and management were giving us was incorrect. But when we got reports now from outside making those specific allegations, then we took the next step to say, I wrote specifically to the SSA asking for the status of the CEO, the vetting of the CEO, as well as the executives of the RAF. And I think that letter was shared with the subcommittee. And then that's when we realized that although all the information for the rest of the executives was submitted to SSA, there was a clear confirmation that the CEO had not submitted the minimum information. And we also need to understand that there's PAIA and POPIA issues around personal information, because SSA deals with individual directly up until the time that I had to raise as the head of the institution to ask for the progress. That's why we said reasonable steps. We've taken reasonable steps when we became aware that there's something wrong in terms of the assertions that we were given or the reports by the CEO. Thank you.
Okay, thank you very much. Now, coming to the issue of SCO security, I think you wrote about it in your sworn statement that even prior, even his predecessors, they were given such security, and that the security benefit was at 480,000, which also Mr. Msiza, I think one of the officials responsible for such, I think it did indicate that there's a fringe benefit of 480,000 for the security of the CEO. However, I think there was a company that was appointed at an amount of 660,000 instead of 480,000, meaning there was an extra 150,000. And I think, judging by what we have written here, it looks like you were not involved in that particular process. Because I think earlier here you are indicating that since the earlier CEOs, the predecessors to Mr. Collins Litswalo, they were given this fringe benefit of 480,000. As the board, you took a decision that he should also benefit from such a benefit, of which is fair. However, when there was a decision to add 150,000 on the 480, it looks like as the board, you were not involved because you are not talking about it here. Just want to check with you whether you were not involved or you were involved. If you were not involved, when did you hear about it? Did you only hear about it when it was ventilated in this inquiry, or you heard it before that? And then if you heard it before, what did you do about it?
Okay, thank you, Honourable Member. The first thing to note about the security issue is that the security policy is a Category B policy. So there's two categories: A, which falls under the responsibility of the board. Category B falls under the responsibility of the CEO. When we came into office, and I'm talking about the 5th of December 2019, that policy had been changed into a Category B policy the previous year in October 2018. So it fell within the ambit of the CEO. However, matters pertaining to the CEO had to come to the board. So that's why then the matter of the CEO's security came to the board. Yes, one other predecessor had security, Mr. Modise. We approved, as part of his contract, the security up to the amount of 480, with a 10% annual increment. Okay, but because it's a Category B policy, it then goes back into the management system in terms of handling it and implementing it. Now it's not for the CEO to implement his own, but for the COO. Until, I would say, the time I left in 2023, we had not had any request for adjusting that amount. So in our view, it was being implemented at 480, and each year would then increase by 10%. And that, in terms of when did we become aware, I think I will give over to Ms. Francois in terms of when it became apparent that this may be, it's being abused and there's been a change without the matter being brought before the board for discussion and change if necessary. Thank you.
Thank you, Chair. Just to continue, Honourable Skhosana. Yes, Msibi is correct. The first board, the previous board, actually approved a security amount of 480,000 per annum with a 10% escalation year on year. After going through the process, there was a process where we got a risk assessment, a threat assessment that was done. SEPS was involved, and the security manager was running this process because, as stated, that it was a Category B matter, meaning that it fell within the ambit of the executive to implement. But because the CEO reported to the board, the actual ballpark was actually decided after going through the engagements and applying our minds as well as looking at the quantum after we had the reports that there were real threats in line with the internal security policy. So that was the agreed amount. That was the amount that was approved by the board with a 10% escalation. Since then, the matter never came to our board until we were disbanded. But it only came towards the end when he was suspended. Letters not coming to the board. I started getting whistleblowers reports talking about this matter, that the CEO has got extra security detail that we were not aware of. That's when, I think the letter came from the public protector. That's when then I brought the matter before the board, and I remember we called the CFO because the CEO was on suspension. So the board actually called the CFO and the executives then to come and explain to us. And we also reported the matter to the suspension investigating attorneys, because obviously it was a matter that we needed, that needed further investigation, and it came to our attention it was affecting the CEO. So we reported to that, we added in the scope of the investigation, and I'm aware that they investigated and they were calling affected parties to come and explain. So we were expecting, when we were disbanded, we were expecting reports to tell us what actually happened, how did he get the extra amounts, but we had a sense that the decision were made internally through that a category B policy, but they never brought those changes to the board. So technically, the extra expenditure was not approved by the board.
I'm going to be a bad guy, Honorable Skosana. You are 10 minutes off.
Yeah, just a last question.
Last one.
Yeah. Let me just correct that amount. It increased from 480 to 630, not 660. Yeah, yeah, because there was an extra 150,000. Now the last question is with regards to the fact that throughout your let me say your last year in office after the appointment of the new minister, Minister Chrissy, that you never met with him. With her, I mean, which I also find it strange to say there has never been a meeting, even a meet and greet kind of a meeting, because even if she delegated that responsibility to the deputy minister to oversee RAF, but I think there should have been at least one meeting where she meet you and then you introduce yourselves and then she outlines her expectation. So I also find it strange that there has never been a meeting between yourself and the minister. But I just want to find out as to which steps did you take to try and reach out to her. Because I understand that before coming to this department, she was in another department. Maybe where she was, they were doing things differently. Maybe just to say to her, we want to meet with you and just to understand what is your vision and also share with you what we think can assist us as an entity. What is it that you did on your side to try and reach out to her?
So, Chair, do you want me to? Yeah. Honorable Skosana, you are right. The chair, through the chair and the company secretary, there are letters that were sort of communicated to say we need to know, meet you, greet and meet, so that we can be aligned. That was really what was open to us in terms of that. But I do want to add something. We didn't meet the minister, but there are other entities in the Ministry of Transport. We would see the minister meeting with AXA, with whoever and whatever. So we didn't understand why we were not necessarily in that group. Because, you know, she's got a whole entity. But she didn't meet us, but we could see newspapers on the TV, meeting this and that. So that became a worry for us. What is happening? Why is RAF not getting the right attention from the minister? And the chair then acted on that things. So I just wanted to bring that because that was a strange phenomenon.
So, Chair, I just want to add that I'm sure the letters were shared by the board secretary because I was writing them in conjunction with the board secretary. In fact, every letter that went back to the Minister of Transport whichever matters that she was raising, I would end up with requesting a formal meeting with herself so we can deal with strategic matters. Thank you, Chair.
No, thank you. The minister will be here next week, so we've made a note to ask her. Sorry, Honorable Matuan?
Just a request, Chair. Can we get copies of the correspondence from the board to the minister and the deputy minister, and the correspondence from the minister and the deputy minister to the board? Thank you.
Okay, so my statement has the letters at the back. Have the members not been finished with the same?
No,
Sorry, Chair, I don't think it's all the letters. Those letters were sent by the board secretary. I remember that he sent them with the lot of documentation.
Yeah,
So the board
anyway, so
secretary
we
will-
have the, by the way, so in our file, we have, in fact, not just this minister, even the previous ministers we've got. I will just ask the colleagues from Secretariat just to tell you which folder they're in. Otherwise, we've had them since last year, September.
No, there was a mention, Chair, which is, I think it's a serious allegation, which we need to take upon the minister when they come this side. So there
No,
was-
no,
there
the matter of their letters to the,
No, the 15 letters from the minister. They said there were some 15 or so letters from the minister, which some of them they interpreted as political interference.
no, I'm referring to those letters. We have them. We've had them from day one. I am just going to ask the colleagues to just say which folder of our pack they are in. Yeah, that's what I was saying. So what I was asking is that I don't think we have the board's letters to the minister. That's what I'm saying. So we can ask Secretariat at the RAF to send us those letters. We've got the minister's letters. I don't recall, I may be mistaken, but we need to get your letters as well.
Chair, you're correct. And that's why I said every letter that was coming from the ministry, even from this committee, myself and the board secretary, we responded to all of them. So he will be able to share all.
Okay, no, thank you. Okay, but I'll ask the colleagues to just say which folder they're in. Thank you. I just wanted to ask a quick question. You remember, Ms. Francois, the first time we met, I think Dr. Mabuya, you were there, we're discussing this vetting matter. You remember we had a bit of an exchange and I asked the chief executive if he was vetted and he said yes. Do you remember that? So it wasn't true. Okay. Okay.
Thanks for raising that, because there was a time where we also told that he was vetted in the previous organization. That was the other statement that we used to get in the boardroom. But you also got that in this committee. Thank you.
All right. Thank you, Honorable Beasley.
Thank you, Chair. So I've listened to your guys' presentation today. I've read your statement in full. And in paragraph 30, you say the board achieved measurable improvements in the governance and oversight of the fund. During our tenure, we strengthened governance structures, enhanced the effectiveness of board committees, and implemented actions aimed at addressing the Auditor General's findings. In my opinion, this board has overseen the total collapse of the RAF. And it's not only me who thinks that. The governance has been deplorable. And it's not only me. The SIU did a presentation here, and I quote, the SIU advocate Mtombi, who is now head of the NPA. He said the investigation identified systemic governance deficiencies in the Road Accident Fund, which contributed significantly to maladministration, financial instability, and operational efficiencies. These failures reflect a breakdown in both strategic leadership and corporate governance structures. The governance failures created an enabling environment for maladministration, weak internal controls, and escalating financial risk. These systemic deficiencies compromise the fund's ability to deliver, this is important, effectively on its mandate to compensate road accident funds. So the SIU is saying poor governance has led to the RAF not able to achieve the RAF. And then he goes on to say, talks about board oversight weakness. The board did not adequately exercise its fiduciary duties of care, skill, and diligence. It's not me saying that, it's Advocate Mtombi and his department. And then we go on to the Auditor General. And this is a key. Everybody waxes lyrically about your performance, but your performance targets are absolutely nonsense because the RAF performance has, as of the last 5 years, fluctuated between 78 and 91% in terms of achievement of targets in the annual performance plan. This is the Auditor General. Whilst the reported performance achievement is high, the targets that were not achieved were key to the mandate of the RAF. For example, RAF has consistently struggled to achieve the target for percentage reduction of 3-year-old claims during the last 5 years. The non-achievement is due to a large number of historic claims that were not processed due to inadequate information required to finalize the claims. Again, I highlight, the underachievement of key targets has had a negative ripple effect on the lived experiences of the claimants. That's the mandate of the RAF. And now we look at some of the key statistics that have been given to us. In 2020, annual number of claims registered was 303,000. In 2024, it dropped to 79,000. That's a 75% reduction under your board governance. Claim finalized dropped from 258,000 to 80,000 in 2024, a 70% reduction under your guys' governance. Direct claims, which has a big impact because this addresses the poorest of the poor who can't afford lawyers. 2020, 33,000 claims were registered. In 2024, 2,800, a whopping 93% decrease. Then we all wax lyrically about how we're saving legal costs. Your legal cost per claim has gone from, in 2020, from 41,000 in 2024 to 110,000. A 264% increase. I fully support Minister Creasy's dismissing of your board, and I will take it a step further, and I think you should be held for dereliction of duty as directors because the RAF has collapsed under your leadership. If you'd just like to give a brief comment, that's just if you want to.
Thank you, Honourable Chair, and thanks, Honourable Bisley. I just wanted to confirm something first. I'm assuming that you're referring to page 35 of 208, Annual Report 2023-2024.
It was information that we were given in this hearing, yeah.
Okay. Chair, I think the information Honourable Member is referring to, I'm reconciling to to this report, the annual report for 2023-2024. I think it's on page 33 of that report. I think we can unpack if the chair gives us the opportunity to do that.
No, you're free to respond. I think that the conclusion in substance was also in a presentation done to us by the Auditor General in presenting the audit outcomes of the Road Accident Fund for that financial year. Of course, it should be reflected in what is in the actual annual report itself. So please feel free to deal with the matter as you see fit.
Yeah, thanks, Chair. I wanted to reconcile the documents so that there's disconnect. But I think if we go into that report and look at it page by page, I do agree that the total number of claims, 2018, there were somewhere around 311 odd thousand. If you go and break them down, there's basically 5 products in RAF. There is a loss of earning, loss of support, general damage, funeral, and medical aid. If you go for each of this year, you analyze the volume by each of this product, you will see that loss of earning is consistent. In fact, it was on 17,787. We pushed it to around 20,000 and a bit. It only dropped to 19,000 and a half. That's the biggest product on RAF, loss of support. So we don't see the drop there. You go to loss of support is coming down ever slightly. It's not the biggest contributor of the claims. You look at general damage, the second biggest, 19,700. It has actually increased to 22,391. Funeral, 8,600, 2018, it dropped to 3,000. The part that actually changes the picture, Chair, is on your medical. There, what my observation has been is there was a view that there are a lot of claims that are claiming on the medical aspect, and those particular claimants had medical aid. I think that's where there was an intervention. You saw a drop. On the funeral, I think the reason you're seeing a drop there, post-COVID, the mobility on the road was quite low. Severity of accidents actually have toned down. I think loss of life has decreased. That's why you see the funeral dropping. But if you look at this picture and bring the aspect of medical component, which is also not a big product, you will actually see that from a productivity point of view, there has been consistency on loss of earning, there's been consistently on general damage, there's been consistently on loss of support. The funeral can be explained. The medical aids, I've already explained, or the medical component, why it dropped from 174 to 55. If you sum up all these columns, it reconciles to the numbers that the honorable member is talking about. Then, Chair, if we then go to the cost, the legal cost, again, my observation, I think historically we were administering quite a lot of claims. Claimants or lawyers were getting away with them. Once we've introduced the requirements, the claims that were actually being accepted, I think they were complex claims. That's why you see the average cost of legal fees being up. But in the greater scheme of things, Chair, that's how I interpret these numbers. But I think we all have different methodology of interpreting the numbers. Thank you, Chair.
Okay, thank you, Chair. And then in terms of actual specific questions, what I find quite fascinating, and I'm going to spend a bit of time here, just in the change in accounting policy. You said you got a technical opinion from Mora auditing firm opinion. Do you know that they disagreed with the change of opinion and they actually were asked to withdraw it because they disagreed? You might question, I've got the report right here, I can read it for you if you want.
Sorry, Chair, through you. If I may, honorable member.
Yeah?
So we can revisit my statement, Chair. I've never made any reference to Mora. I've made a reference to PwC and the former chairpersons. They have confirmed.
Can I assist so that we have the conversation in the correct context? So, so you served on the audit committee, but just remember that the board is a corporate body. It's a collective, right? So this really is not about you personally. Let's just remember that. What Honorable Beasley is referring to is something that's actually in the board minutes from the time, right? From, I think it was the 28th of the board minutes of the 28th of, you might not have them to hand, but we were favored with the board minutes of the 28th of May 2021. And so Honorable Beasley is not referring to you, and I think he should just make it clear that it's the minutes say, not you, the minutes say from that meeting, and then you are, so let me just read what the minute says. He will read what Mora says, and hopefully, let me stop the clock, and hopefully then it will assist. The RAF has applied approved accounting standards within an approved accounting framework, which is GRAP. The audit committee has provided comfort to the board in terms of the financial position, financial presentation, reliability of financial statements, and their fair representation. Full stop. This was done by relying upon independent assurance from both Mora Incorporated and PwC. So, Mr. Nyama, it's not you as an individual saying this, it's simply contained in the board minutes, and I think what would have assisted is for Honorable Beasley to put it that way so that your colleagues can also chip in if they need to, not just you. Thank you. Over to you, Honorable.
I apologize, I was looking at you, I should be moving my head a bit, you know, so, yeah, so in terms of the Mora report, its conclusion, there we recommend that the RAF continues to apply IFRS 4. It's quite clear, quite clear. It was withdrawn. Are you guys aware of this report? And remember, you're under oath.
Yeah, Chair, I'll be direct in answering. From the best of my recollection, the report, the independent report that was placed before the board was the PwC. I remember very well the reference of an international expert in the public sector from Belgium. It might well be that the Mora exists, but I don't have a recollection of going through that report. Thank you, Chair.
Okay, I mean, it's surprising that it's got into your minutes, but nobody knows of this report. And then in terms of PwC, this is an important issue. They testified under oath that they never gave an opinion in terms of actual changing the accounting policy. So either they are telling mistruths or your statement is a mistruth. They never gave an assurance of a changing in accounting policy. They gave technical advice in the implementation of the new policy, but not an opinion on the actual change of the accounting policy. So your statement presented to us here and what you're saying in this committee is contradicting to what they say.
Chair, if maybe I can just mention, I wasn't in the audit committee, but I was in the board. My recollection, the reports that were presented to us around the accounting standard was definitely the PwC report. That much I want to confirm. The report that was presented to us was also, we had a separate meeting completely as a board with the legal team to give us information on what grounds is this a contentious issue after that classification that I mentioned to. So, to my recollection, I do want to confirm with Moses, a Mora report. I don't know anything about a Mora report. I know about those two. I know the legal team that we took, and I know about the PwC. And part of our fiduciary duties under 15.3 is that we need to act with care and diligence. And that's why we asked for independent advice outside what we thought we knew. Secondly, we needed to demonstrate we had no direct conflict in this matter. That's part of acting with due care and diligence. And number 3 also is seeking expert advice and making sure that when you make a decision, you've applied yourself. So those are the two reports I, as a board member, I'm aware of because they would be ventilated at the audit committee, then come to the board.
Okay, but I put it to you, PW said they never gave an opinion on changing the accounting policy. So are you saying that they've misled us under oath? They gave a technical advice on how to implement it, but not an opinion on the actual change of the accounting policy.
Chair, my recollection of them, they actually brought us some expert from Belgium who was supposed to be extremely knowledgeable around the landscape on IPSAS and social benefit funds and shared a World Health report on social benefit thing. So this was really, remember, we are not experts in this. We are now relying on this international Belgian expert that PwC flew in. So I don't know
with
what
all
they
due
told-
respect, you're not answering the question.
No, I'm not saying
no, you're not
they're
answering the
lying, but
question. The
that's what they
question,
said to
they
us.
didn't give an opinion. Are you saying that they misled us in this house? They never gave an opinion. They may have brought in experts that said how you can actually implement it, but they never gave an opinion that it was okay to change accounting policies.
So can I assist, because Honorable Bisland, I'll stop your clock, because we have the benefit of having heard everybody. Will you allow me to provide the colleagues with some specifics, because then I think you will understand where the line of questioning is coming from, and I can see a danger in speaking past each other, potentially. The short version of this is, the Road Accident Fund first approached Mora Incorporated. you will see, Dr. Mabuya, if you look, because I gave you a copy, if you look at section 4, which is possibly the last page, if you look at section 4 of the Mora report, right, you will see that they then reach a conclusion. It's the second last page and the last page. It says overall conclusion. So I'm just giving the history so that we can all catch up with one another, and then you can then take your issue up with Honorable Beasley. Right? So I will do some recollection. So the Road Accident Fund in February of 2021 approaches Mora Incorporated through the Chief Audit Executive and the then acting CFO, I think it was. They obtained this opinion. This opinion basically asks, Mora is advising on whether the Road Accident Fund should implement a new accounting policy in terms of IPSAS 42. They then reach those conclusions in number 4 there, can you see? Right, and the conclusion says, there is uncertainty in the recognition of social benefits in the SA public environment. Further legal opinion should be obtained to distinguish between an insurance contract and social benefits. The ASB is currently in the process of developing an appropriate standard for accounting for social benefits, which is projected to only be finalized in 2023. And finally, RAF has adopted IFRS 4 as the accounting policy since 2014-15, and no major issues were identified by the external auditors. Therefore, we recommend that the RAF continues to apply IFRS 44 until the ASB has finalized the standards for social benefits. Now, this is, you guys are nowhere near this. You are non-executives. The Road Accident Fund receives this, and they decide no ways. They instruct these guys to withdraw this opinion. That happens on the 12th of April. Right? That happens on the 12th of April. And in the meeting is Ms. Mabusela, who was then the CFO, is Ms. Bernice Potgieter, and it's Ms. M. Mahato, the audit manager. Right? So they then instruct them to withdraw it. The reason is we did not ask you for your opinion. We want to do this over here. You guys are giving the wrong answer, right? In fact, we are not going to pay you for doing the wrong thing. And so this is withdrawn. The reason Honorable Beasley is surprised it makes it into the minutes, because all along we were operating on the basis that this was withdrawn and never made it to the board, right? So when you look at the minutes of the board, it's now new. You think something. But we decided earlier on that matters of the board will ask when the board, gets here, which is why you are now getting asked about it. So that is the one set around Mora. Then there is a new RFQ, which is requested, which then introduces PwC. Right. Again, the board, to the best of our knowledge, is not involved in this over here. Now PwC are given a specific instruction, which is we have decided to implement IPSAS 42. Show us the best way to apply it. Right, we want to apply it this way, provide the assurance. Now, we have PwC in the room. We have Ms. Mabusela in the room, who was the CFO. We have Ms. Bernice Potgieter. They all agree that this is what PwC were indeed asked to do. Not to advise you as the board on what the best decision to take is, but on how to implement a decision already taken. We then find this interesting as the committee, because we go like, okay, only the board can change this kind of policy, right? So if someone is to take a decision already taken to the board, there's got to be a board decision somewhere, right? We then ask for the minutes of the audit committee, of the Road Accident Fund. The audit committee of the Road Accident Fund actually meets on, so when did so the audit committee meets on the 23rd of April 2021, right? So Mora has been withdrawn 10 days before, on the 13th, right? There is now, between the 13th and the 23rd, there is no opinion that exists, right? Technically, because this document sent to us by whistleblower does not exist at that point. 23rd April, the audit committee meets. We've got those minutes as well. The members have got those minutes. We've canvassed them. This report is not referred to in that meeting at all. The audit committee makes a provisional decision at the time. Mr. Nyama, you may recall, provisional decision, which is kind of understandable because PwC only respond to the RFQ on the 28th of April, which is 5 days later. Right. PwC then submit on the 28th of April. So you know what the 28th of April is? It is the same day that the board, it is a month before the board meets on the 28th of May to consider the decision. Right. So this is the difficulty that we've had. So you get this background, right? So when I said in my introduction, we are not dealing with the technicalities of who's got the better idea and so on. We are looking at the sequence of governance processes. Things are not adding up. Because at the time the Audit and Risk Committee meets, PwC have not provided anything to the Audit and Risk Committee at all, right? Nonetheless, the Audit and Risk Committee approves the decision, the recommendation, provisional. Now, one of the things we want to know from you, what were you approving on that day? Because this technical opinion did not exist, 1. 2, framing is important. Our understanding from Ms. Mabusela under oath, from Ms. Potgieter under oath, from PwC under oath before this committee is that they were not helping you decide what the best option is. It had already been taken. And now we want to know where and when was this decision taken. That's where Honorable Beasley is coming from. So I'm going to shut up now. I have caught you up to why he's asking in the manner that he is, and hand back over to him. Honorable Beasley, please continue.
Yeah, thank you, Chair. Thank you for stepping in there because we're definitely... So can you respond to that, what has just been raised?
Before the chair of the audit former chair of the audit committee responds, it's very clear that some of the representations made by management were misleading to the board. Because I remember some of the opinions mentioned in there, because we will get a submission from management to tell us what they've done and when they're requesting a decision. And sometimes we'll ask for specific reports. And I remember we asked for additional reports. We got the reports from PwC we saw, and we got a report from, I think, Malaji on the legal side. But the report would say, we've done this, we've consulted these experts, because management had to engage directly with the experts and then come back and put it in a report that will justify that they have extensively asked for advice, and this was the advice intended. I think maybe we should just look at what was presented to the board, the submission itself, up to the minutes. But it is very clear that we were not getting honest representations by management at the time. But I'll allow the CEO, the former chair of the audit committee, because these matters went to the audit committee, as you
Chair,
said.
if I can just add in, we got a submission from PwC here, and I just want to receive that the PwC project team did not provide any advice or recommendations or make any final management decisions on whether RAF should adopt IPSIS 42. So they clearly didn't give an opinion that you can actually adopt it. So if you can also address that, because you keep on referring to the opinion that PwC gave, they never gave an opinion.
Yeah, thank you, Chair. I'll just touch on two things. I think you mentioned that the audit committee, obviously I was in the chair, but I was the member at that point in time. I think the reason why the audit committee didn't ask management to provide an independent review, the audit committee at that point in time, and I don't know now, it didn't have the capacity or the mandate to seek opinion. That's why there was a provisional to say that this must go to the board. However, the board, it would be wise for the board to actually get an independent review around this one. But again, to my recollection, Chair, we're not expecting the accounting policies and stuff like that. If I recall very well, the PwC report was really to say that, can we do this, can we not do this?
Sorry, can I just say, and sorry, Honorable Beasley, I've stopped your clock. So one of the things one of our members, he's an auditor. He's not here today. He's on oversight with another committee. He is an auditor by profession. The chief audit executive, I just want to make sure that we are on the same page, reports to the audit and risk committee. So they don't report to the executive. This opinion here, right, which Dr. Mabuya has, was requested by the chief audit executive. Do you know who instructed the chief audit executive to withdraw it? It was the CFO. So Honorable Maduna took umbrage at management instructing the chief audit executive to repudiate a document they have commissioned, because only your colleagues on the audit and risk committee can make that decision. And we went back and forth, and Ms. Mabusela did not appear to be aware at some point that this is not allowed. So I need you to understand the sentiment of some members of the committee around this issue in that context, because it potentially points to severe governance failures. Because at the time that you as the audit committee meet, I'm assuming that management never told you that they'd obtained an opinion, they didn't like it, they instructed the chief audit executive, who reports to you as the audit committee, to withdraw it. And on this version that I have, there's even a withdrawal letter. You never got to know that, did you?
I can confirm, Chair, no.
Isn't that dishonesty on the part of management? That omission?
Yeah. Chair, it is dishonesty, because honestly, it should have served at audit committee. Even the decision to withdraw should have come from the audit committee.
That is the understanding that the committee has, right? That the chief audit executive reports to the audit and risk committee, and if anything is to be basically turned down, the audit and risk committee will make that decision and provide reasons to the board. Right, so Honorable Beasley.
Thank you. Sorry, Chair, through you, if I may just comment. So, obviously, there are a couple of time periods here, Chair, and I want to just leave something. I think that's the situation. Just from a governance point of view, what the audit committee we used to do, whether I was a chair or not, we used to have what we call closed sessions, especially with the chief internal audit, to also allow any ventilation that they are not comfortable to ventilate in front of management. I recall very well that when I was the interim chair of the audit, I even met the chief internal auditor, just the one-on-one. I think it's also part of the regulations that we have to do, to also say that, is there any discomfort that you have, that you are not comfortable to open up, but you can open up to me and I draft. I just want to close the loop around the issue of governance. I think you can't force people to open up, but I think we have tried where we can. Thank you, Chair.
Yeah, so I disagree with that, because something as fundamental as changing the accounting policy, which is so fundamental, you've written off 300 billion rands worth of liabilities. Surely as a board you asked to see these reports. And I'm going to request that you send the report of PwC where they recommend you can change accounting policy. I'm looking at everybody, sorry, because they say they didn't. So somebody's lying under oath, and we need to get to the bottom of that, because if PwC is lying under oath, I'm going to lay a charge. And if you guys are laying under oath, I'm going to lay a charge, because we must get the truth. They said they never gave an opinion on the change of accounting policy. You guys are saying you did, and you saw the report. I'd like to see the report, please. Okay, you can discuss it just now. And just moving on then, I can tell you the reason why you haven't gone back to the old accounting policy, because it's estimated there's a 500 billion unrecorded liabilities now. That is massive. It is so massive, and it'll make you guys look silly as a board. Absolutely silly. So that's why you've done it. You haven't done it for any greater reason. The reality, if you applied the right accounting policies, that would be at a 500 billion rand loss. And to say you've done it because of good governance, you haven't done it because it will actually make you look completely going to, and the implications for our country of having a 500 billion unrecorded liability is massive. It's not just the RAF, it's massive for a country from a macro point of view. Then just moving on in terms of suspensions, you know, we got a breakdown of suspensions. There's 35 people on suspension with as long as 5 years. Total cost to date is 48 million. How can the board allow that? How can the board allow that? 5 years. We talk about being compassionate heart. 5 years people have been sitting at home. And the trauma it has. And there's no ways you can say, oh, we got a report. If somebody's been on suspended for 5 years, it's simply not acceptable. Not only is it costing the RAF millions, but it's also having a huge impact on people. How can the board allow somebody to be suspended for 5 years?
Honorable Beasley, you are correct. I think that's some of the quarterly reports we were interrogating ourselves as part of the REMCO process to say the ER process in this organization leaves much to be desired.
But what did you do about it?
So what we were questioning is, if people are suspended, how come we are not concluding on these matters, and such that people are at home for 5 years, getting full pay, and then sort of it's a wasteful expenditure of sorts. So that is part of the interrogation that we were going through. But another indirect indicator that things were not necessarily going well there is the fact that we were losing cases. I mean, we were losing cases, and we then said, what is wrong? Can't we revisit the skill set we have on the ER? If people, it cannot be that 300 people all steal or whatever. There must be a fundamental cultural problem, systemic problem that is creating problems. We did get quarterly reports, Honorable Beasley, telling us that we are following the law, the labor relations law. It takes long, it takes that. But I mean, that is something that was always under our watch. We've never ignored that part, because it was something that didn't sit well with REMCO. It was something that didn't sit well with the board. But the reality of the matter is, if you get reports that say this is what is happening, we even ask for the financial impact of the decision. That is how much we felt this matter was not real for us. And it's something we couldn't sort of leave it aside. The reality of the matter, answers were given, and we did see the gaps, that something is not adding up. And the fact that they were even not respecting the pronouncements of the court, that's something that we were not even aware of. So that is just the reality of the limitation of being in London. We never went to specifically ask for specific, but we were asking a dipstick response. Why are we having what we are having?
So it's great.
Last one.
No,
ask it, yeah.
When you say my time up.
Yeah, I've been stopping the clock. You can ask. Don't worry, you can ask, but I'm just saying it's your last one. You're already over, but ask.
Okay, I won't hold with the point, but there's a difference between interrogating a report and actually doing something about it. You just looked at a report, you did nothing. Somebody suspended for 5 years, that's not labor practice, that's wrong, it's immoral, it's inhumane, and you interrogated the report. I would have called the guys in and say, what's going on here? And then just the one thing that really has got to me is the bonuses that you awarded to the CEO. He got awarded a 40% bonus on top of a 7 million rand salary, where the rest of the staff got 12. And as I've indicated earlier, there were your performance targets, the Auditor General says you missed the key ones. The SRU said it's a disgrace what's actually going, well, not a disgrace, I'm putting words. He's saying there's just lack of governance there. The key statistics have gone backwards, yet he got a 40% salary increase, the highest on a 7 million rand salary. And then, whilst I'm on it, the other thing that's really got to me is the staff award function of 3 million. Were you guys at the board? Did you attend the staff award function that cost 3 million?
3.9 million.
So if, Chair, I can just start with the issue of bonus payments. Specifically, we do set predetermined objectives with the team and the executive team. The board, through these strategic objectives, also allows for the organization to meet certain targets that are aligned to the APP. The APP targets, it's not necessarily a function of the board only. AG also confirms if we say these APP targets have been met or they have not been met. So that's really another external assurer of the work that we reward. So the performance policy and rewards policy talks to those processes. Now, the amount, it is all in the contract. I mean, the contract talks to, well, at what threshold do we release a bonus? We give every employee annual salary increase to be in line with CPIX. Bonuses are a discretion mostly of the board and depending on how the organization has performed. And that never happens without a fully approved report that is also confirmed by the Auditor General's report. So the release is always related to meeting the predetermined objectives that were set. So the quantums, it's not thumbsuck. There is a formula that is used. The release amount happens when the organization meets a certain part. But in addition, the CEO's amount is regulated in his contract. So if the objectives are met and everything is fine, we simply approve what needs to go out. We do moderate, and also the CEO specifically moderates. We don't moderate. He moderates because every employee meets with their manager. They go through KPIs that are set for the year. Every 6 months, they then do a performance review. Scores are then brought there. Business heads are then allowed to engage and moderate those scores to check alignment to the APP process. So I'm just defining the process. The amount is really predetermined in terms of what was first agreed on. So that is really what I want to mention. The policy allows that. There's nothing illegal in doing that. You follow what is in the policy. You follow your contractual obligations. And in reality, the quantum amounts are related to what we have in the policy and in what has been agreed on.
Sorry, Honorable Chair, if I may add. Chair, and I'm saying this with greater respect, it's a bit confusing because, Chair, the APP targets, they are proposed by the board or management. The board agree with them. They go through the departmental process, DOT, and then we get feedback as well there. My understanding is that they are taken to Parliament, and that becomes a measure of failure or success. It's unfortunate and probably disappointing that at the end of it, we say that they were not useful or whatever the words we are using. But unfortunately, that's the government process. That's what we followed. But yeah, I just wanted to comment on that, Chair. Thanks.
Okay, so Mr. Nyama, let me just assist in this way. So the members of the committee, and I've seen it in other committees as well, the only time they have a huge fight with the Auditor General is when an entity has had a clean audit and they are not happy with the level of service delivery. Have you seen those interactions where we've had those discussions here in the committee? Right. So when the Public Audit Act was amended, I think it is, so one of the things that the Auditor General now makes an assessment of is an assessment against legislation. Now, I'm an MP, so I'm speaking against myself in saying that the fact that members of parliament have failed to do a check between the APP and the legislation does not mean the legislation has been complied with. So the Auditor General is not restricted from looking at the legislation nonetheless and say, what does the law instruct you to do? And so we've now looked at your APP, and your APP has missed two things which are critical in the legislation. So you might say you've achieved 95%, but members are busy looking at news reports and so on, and they're upset that how can you say these people have received a clean audit? When we see, you've had those discussions. So that's the context, that's my reading of what the Auditor General is saying. They're not fighting with the APPs, they've compared with there's a section that says audit against compliance with applicable legislation, and on that basis they then make a conclusion that even your APPs were not adequate. And they leave it to us as members of parliament to ask these questions and not just leave it to the AG. So I don't think you should feel too cut up about it. Perhaps in your work, because I feel you'll be a board member in other lots of other places as well. It's just something to check when management brings these APPs to say, but are we complying with legislation, or does this just sound impressive, but it doesn't quite do it? So that is there. That's it. I hope that helps.
Yeah, thank you very much. It does help quite a lot. Thank you.
Thanks. So I wanted to just share something with you and just ask for a quick comment from just one of you. You know, Ms. Mabusela was here. You know, she was a chief financial officer. She did not know who sets accounting standards in South Africa, in the public sector. She had no idea. Took us 2 days, including me speaking to her on the record about implications for her as a chief, as a chartered accountant. She had no idea that it's the job of the Accounting Standards Board to set basically GRAP for the public sector. She had no idea. Which is why I want to know, how was she appointed? A chief financial officer is a prescribed officer. It's a critical role. Ms. Mabusela had no idea. And the concern is, she was the one driving this change, but she did not even know what the ASB does. She genuinely thought it's optional. We can send you the transcript. She thought if the ASB says something won't work, you can ignore them. The members were there. I'm not making this up. So I just want to know, how was such a person appointed to oversee 48 to 50 billion rand? How did it happen? Were you part of it? Who appointed her?
Yeah. Chair, I will just go back, and I'm trying to think, who is she? I don't have a picture.
So let me assist, because we've been dealing with this matter. So
Yes,
there was Victor Songelwa
Yes, I
as
remember.
acting
CFO.
CFO.
Yes.
Mr. Letswalo told him, because he is agreeing with these guys, he doesn't want, okay, let me not put it like that. They were disagreeing on the accounting policy change. Let me put it like that. Mr. Songelwa felt that these guys are correct, and management disagreed. So he then relieved him of his responsibilities and appointed Ms. Mabusela. So we then invited Ms. Mabusela to come and speak before the committee under oath. That is when she told us that she does not know who sets the accounting policy framework for the public sector. She didn't know. We started the day before, we eventually settled the matter 24 hours later. I had to beg her numerous times. She had no idea. So I do want to ask, how does something like this happen? Did you approve this decision to appoint her? Was there any sort of interview and anything like that?
So, Chair, Miss Mabusela, I can tell you now. I don't know who she is, but I think she was probably within the delegation. That was within the delegation of the CEO, because I know Victor very well, and I know the issues around what happened with Victor. But Mabusela probably was appointed acting. We, as a board, did not necessarily appoint her. That those are some of the senior executives that are there. Victor was the person who was acting. That we are 100%, we are aware of him. And I don't think any board member sitting here will say they know nothing about Victor. But when that particular fallout happened, the delegation obviously kicked in, and I think that's really what happened. I don't personally remember who she is, I must be honest.
Mr. Nyama, you may, they're not speaking for all of you. So at the risk of all of you appearing like you don't know who she is, I must give you an opportunity to say something.
Hey, Chair, you're putting us under a lot of pressure because we need to remember 5 years, 6 years ago. In all honesty, Chair, I think I do remember Ms. Mabusela. I think she was one of the people that were brought as a cohort of specialists. And then at some point, she acted as a chief financial officer. To my recollection, I don't think she lasted long at the entity. But having said that, whether it's a gap, and I don't know, I mean, Chair, it's yourself who said that part of your work is trying to assist the RAF. I think one of the things that bothered me a bit or boggled my mind is the appointment of executives, substantive executives, sit with the board. But on the acting at the executive level, that process was slightly different. I couldn't understand it. I think it was within the ambit of the CEO. Whether that is a gap or not, I think those are stuff.
No, thank you. That's very helpful, Mr. Nyama, because part of what we have to do is to make recommendations, right? So, Ms. Mabusela, you are correct. She didn't last long. The only significant thing to do was to instruct the chief audit executive to withdraw this thing. She then resigned on the 1st of May because she says that the chief executive had been unhappy in the manner in which he shut it down in a board meeting, and then sent an email. I mean, there was a fallout, right, regarding the manner in which she got spoken to. So this meeting of the 28th actually happens 2 days before she actually leaves the road accident fund. What's clear, and we've canvassed this, and you must tell us if there's a gap, there were lots of people who came in as specialists. The people who were permanent in the roles, who were in the areas where the people were specialists, were suspended or left, and then these people were appointed in an acting capacity. Ms. Mabusela was one. I must tell you, it is staggering for any board to not know, don't even remember somebody who was a chief financial officer. You would agree, ne? It's staggering. I've never heard it. Anyway, right? But at the road accident fund, it happens. Right? And this person does not even know who sets the framework that governs the decisions that you as a board take on the 28th of May. Including in the minutes a report that you never read, which is the moral report. So we just have to understand some of the serious failures then, because it can't be that the board of the road accident fund just sees someone walking in as CFO one day and they have no idea where they come from or their level of competence is, because that's what we ended up with. So, Honorable Nilme. Sorry, let me ask. We can walk in and out. You can't. I am worried about whether you don't want to take a bathroom break. If you want to continue, we can finish sooner, but I don't want to be unkind. You would like some 10 minutes, ne? Yeah, I am thinking you've been sitting here. We're walking in and out. Can we take a 10-minute break, members? Thanks.
Good afternoon. It's this time of the afternoon, they call it the sort of gravy train type of area where we all start to feel a little bit sluggish. Chairperson, thank you. Having listened for the past few weeks and listening here today, I must actually say I have serious concerns regarding the posture of the former Road Accident Fund Board members. The evidence before this committee points to a pattern of non-compliance with legislative prescripts, disregard for lawful oversight, and a troubling attitude towards accountability. The board repeatedly sought to shield itself from scrutiny by invoking the RAF Act and characterizing the ministerial oversight as interference. This position reflects a fundamental misunderstanding or deliberate misrepresentation of governance in a constitutional democracy where public entities are accountable to Parliament through the executive authority. The board's approach was not only disrespectful to the minister, but also to yourself for not responding to a letter that you had written to the chairperson, whereby one would have expected a reply to say, "Thank you, we have received your letter and we are busy dealing with it." But also inconsistent with the principles of cooperative governance, transparency, and responsiveness required by the PFMA and reinforced by SCOPA standards. Oversight is not interference. It is a constitutional obligation designed to safeguard public funds and protect the interests of citizens. I'm coming back to this oversight, which is what one would expect from the board. And Chairperson, I'm going to focus on the board-approved limits versus actual expenditure. I'm going to go back to the area. The board approved a fringe benefit limit, which my colleague, Honourable Skosana, spoke about. That's 480,000 per annum for close protection. One would want to know, how did the expenditure escalate from 1.8 million to 23 million over 3 years without board intervention? So I want to come back into it to be specific. At what point was the board formally informed that expenditure had materially exceeded the approved limit, and where is this recorded? Because you see, the PFMA compliance is that the board has a fiduciary duties under Section 50 of the PFMA when allowing spending that was clearly irregular and unauthorized. So why did the board fail to prevent what appears to be fruitless and wasteful expenditure in terms of Section 51 of the PFMA? And that's the one question. So I'll clump the questions. The next question, also dealing with that, is the monthly security services were costing approximately 150,000. The procurement of an armored BMW X5 was valued at approximately 4.6 million. Were Treasury approved deviations sought and approved for these procurements? If so, please provide documentation. And who authorized the deviations, and did the board ratify them as required? So I'll stop there for those few questions. Thank you.
Thank you very much, Honourable Member, for those questions. Let me start with the CEO matter, and then maybe the members can help with the other. I think that's the main question you're raising. Honourable Chair, we've stated that the board, we were aware of the original amount. In fact, that amount was the amount that was in his contract, because the CEO's security was reviewed at the time his contract was concluded. That's why the previous chair spoke to it initially, because she was very close to that process. And like we said, we, as the board, we're not there on a daily basis. So we were not aware that there's additional security detail that was brought, like the monthly security services, because in terms of materiality, those amounts were managed by the executives and the CEO. Obviously, most of them by the CFO because of the financial implications. But Chair, at no stage we were aware that there were these amounts were exceeded, because if they were, there would be a request coming back to the board asking for ratification that you're asking correctly. That would have been a correct process. So it's very clear here that the additional security details were basically not presented to us, probably intentionally, because they are aware that the board needed to approve them. So there was no way that we would have accepted that without following, because those things were contractual. That's why towards the end of our term, when the matter came up through, I think it was public protector and some whistleblowers, we were very clear. We basically included this matter for investigation in terms of the investigators that were working on this matter. But we also asked the CFO to present a report to us. We call a special meeting and we raised the issues, and she actually committed to give us the historic report in terms of when the changes happened, to what extent, and the approvals. That was the last time, and because shortly after that, then the board was dismantled. But the matter was being investigated as soon as we realized that there was something wrong with the actual amount has been exceeded beyond what the board had approved. And Chair, regarding the letter not responded to, Honorable Chair, I would like to get a date on that, because all the letters coming from this honorable committee came through the department or the board secretary. And I remember there's no letter that we never responded to, because the board secretary will draft, we will work together in drafting the response. So there wouldn't be any intention of not, and you are aware that we responded to almost all your letters. So there could have been an omission from the board secretary side, because I never received letters from your office directly. They will go through the department as well as the board secretary. But we responded to all of them. Thank you, Chair.
Chair, if maybe I can just add. The contract of the CEO is signed by the board chair. And the amount is very clear. There's a specific section that confirms what the board approved. And there is no other contract, only one contract. It talks to the amount we are talking about, 480, and with a 10% escalation. All other things, when they came to our attention, we then also, especially through the public protector's letter, we also send that to the SIU to say, this has come to our attention, we are not aware. We don't have two contracts that talk about 480 and then escalate. We don't have that. One contract was signed, and that's us. So anything happened, it's outside what we signed, but what is on record is our contract. And also, if I can mention, the 480 matter also, we applied our minds. At the time, fortunately, we had the DG from Department of Transport. He gave guidance. He even helped us to benchmark, to say what PRASA is doing, what so-and-so is doing, and that sort of thing. That helped us a great deal, because this was something we were not exposed to. And based on the historical and what the previous CEO had got, 480 at the time, with the facts presented, looked reasonable. So I don't want to bring context to even the amount itself. We did a benchmark, and we were all satisfied that it's probably the right amount. So any other amount, our board didn't approve.
No, thank you, Chair. You see, so I don't think we have a problem with the 480,000, because that was part of the contract and that was approved by the board. What we do have a problem with is that they escalated from 1.8 million to 23 million over 3 years. Now, if you were the board there, you would have seen him arrive with 8 bodyguards, a BMW that has armor plating. Did the board not at any time think that there's something not right here. Why would you wait for a whistleblower or the public protector report to take action? Did you not observe? And part of your oversight, we do oversight, okay? We go down to the areas that we're supposed to, okay? But in oversight, as a board, you meet the CEO at meetings. He arrives there with a contingent of bodyguards. You see him leave. You see all the issues that happen, not to mention the other areas like how his bodyguards are misused at his house. They must do farming. They must make fences. If we hear it and did hear it, how was it possible that you did not hear it? Being so close there and having some, you're with, you're in that environment. And this is what I don't understand, is that it takes somebody else to highlight it to you. And then you say, oh, yes, yes, it has come to our attention. This doesn't look quite right. I don't think that is the correct answer that we would be looking for, because you would need to be judging by your alertness, your qualifications. You would be alert, because you would be, this is public money. This is not money that is derived from somebody's pocket. It comes from the government. So I think that is something that I wanted to put on record, is our observation over the last few weeks. We have observed complacency in the board. I don't know, is it because the CEO is charismatic and is convincing? We heard that he terrorizes his employees. But what is it that you didn't see? Because coming back to the panel of attorneys, one logically, in one's mind, even us as laypersons, we would have realized that it is an end-to-end litigation management. I mean, it's end-to-end. It affected the whole of the legal industry. It collapsed the legal fraternity, what happened here, how it was done. And it is an absolute disaster. If you listen to the Law Society, you listen to what has happened. I mean, there are advocates that haven't been paid. Lawyers have to pay those advocates. Lawyers are closing their practices. So from an economic point of view, which is what I wrote a whole lot of notes here, but I'm not going to go through it, because I thought to myself, looking at this at the board, one would have had to look at your governance and value for money rationale. You know, you would have to look at your formal cost-benefit analysis. Definitely. You would have to look at what systematic and economic impact you would have had on the industry. I mean, that is the most important thing. What is it? You know, a whole industry it was created around the Road Accident Fund. There are bad apples. We all know that. It happens in the medical, legal, it happens all over. The point is, those are areas you could have looked at. Yes, you wanted to change firms. The new firms, out of your 45 or 48 or 43 firms, one of those firms had only been open for 2 or 3 months, we were told. You know, what was the criteria? So if you are trying to say these big companies are making a lot of money, we need to get rid of them because it's costing us too much money. But then you go and hire 43 thinking, oh no, they can just cover the gap. Logically, it does not make sense, because a whole industry was created around the Road Accident Fund. So the challenges there should have been looked at from a macro level, not just trying to make a quick win with regards to that. Yourselves, as a board, you definitely should have known that there were many default judgments. Definitely. How did the board exercise oversight over the sharp increase in default judgments against the RAF? You know, you would have had to have seen that, and you would have known that it was coming. So when you give an answer from each of those, definitely you would have had to see. One can't be giving an increase to the CEO when you have had, since 2022, from a disclaimer from the Auditor General. And it's a disclaimer. So from the day you tried to change the accounting policy, you had a disclaimer. Surely that should have rung a red flag in your minds. Something is wrong with this picture. We need to reevaluate. Maybe what we are being told should have been reassessed. Because as government, as a board, you do not have the power to actually litigate the Auditor General. I mean, in our country, I mean, we sit and think about it, that the RAF actually thinks that they're above all others to litigate the Auditor General. It actually doesn't make sense. So when the minister actually terminated your contracts, I would say it was a really good thing, because generally the governance structures in this country, there's the PFMA, straight. That is what you belong to. That is what you need to follow. And secondly, you're supposed to work with the Auditor General. She highlights many meetings we've held where people have told us, they told you, they gave you that information. Do not change the accounting standards. We heard it. But you still go and do it against all judgments and information. The organizational restructuring. What business case supported the organizational restructuring? We did hear that PwC was then given that position, that responsibility of doing that, because that is what they were employed to do, and that is what they did. However, it actually weakened your institutional capacity. It totally weakened, you know. Then, this is where I would say, from the weeks that we heard, the appointment of specialists without due process. Why I believe that the Road Accident Fund went down the tubes, to say the least, is that you had competent management there in the first place. They were replaced by headhunting other officials from PRASA, from City of Joburg, all over, who had worked with the CEO beforehand. And then, so we heard how they were headhunted. Then they came in. And then those who had held the Road Accident Fund in one piece, good officials, were basically shown the door. A sad situation to hear them speak, to look at their suffering. It is absolutely atrocious. You have an investment specialist who is then becomes involved with the actuarial side. You actually pay your actuarials off. You do no longer need actuarials, because you have a gentleman who comes in as an investment advisor. He might have had the qualifications in financial investment and management from the City of Joburg, who himself hasn't got a good track record. But you lose your actuarial, you know? And I remember making notes here, exactly what actually, maybe if you'd had your actuarial services, you know, I mean, they deal with numbers, claims, liability, how much is owed, want to quantify that amount. This is what you want to plan for the future. So it's like there's a saying that you throw out the baby with the bathwater. And I think, unfortunately, the board in the last few years threw out the baby with the bathwater. And unfortunately, so my question came back to the original one here that I put down here. As board members, how did you discharge your fiduciary duties in terms of Section 50 of the PFMA when approving policies that materially affected RAF's financial sustainability and service delivery? And thank you, Chair.
So I wanted to say, if you've got a question or two extra, please ask it because you ran
Okay.
over your time.
I haven't gone over my time.
You
That-
have.
Oh.
You're on 22 minutes now. So I would say just, if you had another question, just include it in this batch.
Okay. Let me just go back to my questions. I've been working on this for quite some time. No, Chair, I think I'm going to stop there. I think it's been a mouthful. I've actually given everything that I feel that I needed to say and needed to ask. And that is where I wanted the board to actually, it's good to do self-reflection of yourself in hindsight. In hindsight, the word is, had you known that there was this other report saying, had you known what disaster paying off the panel of attorneys would be, had you realized that going to litigate the AG was like hitting your head against a brick wall because every legal avenue had already been, So in hindsight, now you're looking from the other side. In hindsight, what would you have done differently? And what would you advise going forward? Thank you.
Chair, I will take not everything, but a part of the key question you asked. How did we exercise our fiduciary duties as a board to comply to the various prescripts, including Section 55(1)A of the PFMA? So that's the section I will specifically focus my answer on. So the board has got powers to perform certain functions. And in exercising its fiduciary duties, we were guided by a few principles. Firstly, you declare personal interest in any matter, in every meeting. And in addition, you sign the registrar in terms of if there's direct conflict. That's the first principle. The second one, exercising care, diligence, and exercising due care, skills, and diligence was part of what we were tasked to do. Thirdly, we needed to act in the best interest of RAF at whatever point because we were relying on management report, internal audit in terms of assurance, and also seeking expert advice where we were deficient in applying our minds correctly. So the duty also was that the decisions that we took based on the RAF Act, we were mostly based on consensus when we were then had deliberated matters, especially after getting expert advice as a board, we would then come to a decision and decide. Now, Section 15(3) specifically of the Road Accident Fund, which is a business judgment rule, allows us to exercise these three important principles in our decision-making process. Now, no board member specifically takes decisions and overrules everybody. We've never had that. That's the one part. But the second issue is, we are aware of case law where other entities have had issues of disagreement with the AGSA, they went to court. So it's not like this is really the first time it's happening. And we are not necessarily saying, in hindsight, maybe we should have considered things differently, but we are just saying, we were also guided by the fact that if you don't agree, you can appeal and look at case law. What has happened in that specific case that can guide you. So ultimately, we did come to a point, by the time we were dissolved, we were asked to review our decision. So it's not like we were recalcitrant. We did on the 5th of November, June, sorry, not November, June. On the 5th of June, we were asked to review the decision to go there. We actually committed to the Deputy Minister that we will do a risk assessment,
We will engage all other relevant stakeholders, experts to guide us how to go about so that we are not doing this thing recklessly or we are seen to be trading recklessly. That's the benefit of hindsight that we got. Unfortunately, whilst we were busy with that process, then the dissolution happened. So it's not like we always said our word is final. We never had such a posture. That posture was always, if you are being led, also allow yourself to be led. And we were not even adamant about that. Thank you.
Oh, sorry, Mr. Nyama.
Yeah, maybe if I may add, obviously, thanks, Honorable Neil May. I think what I always say is that we have to accept the reality of RAF. For the 7 years I've been there, I think the organization has just continuously been in crisis. And I think my observation is that your normal risk management process doesn't help. You deploy them, you have your board subcommittees, you do your risk assessment every year, you have your strategy. There's just a lot of gaps. Mine, if I was to reflect, is that if we simplify the policy, whether it's the accounting policy to say what is appropriate for government, whether it's the act to say what is appropriate to reimburse or to pay South African in the event. If we simplify these things, I think it will really narrow a lot of issues. But I think I've reflected a few times that some of the complexity is just because all these policies, these legislations are so wide, they are open for different interpretation, and people have different views, different opinions, and people find themselves in court disagreeing or agreeing. You look at SASSA, for example, it's very simple. Once you hit a certain age, your salary is below a certain level, you get 2 point whatever. There is no debate. You fill a form, UIF, same thing. For me, I think that would have been my submission, Chair, in the spirit of saying, as the committee proceed with its work, those are some of the things that the committee should look into: simplification and creating certainty around what could one get in the event of a certain incident. Thank you, Chair. But RAF, it's complex. We've called IODSA, Dr. N, I don't know if you want to add to that, to do assessment on ourselves as a board to say where are the weaknesses, what can we improve. We have the first line management. We don't rely only on first line. We have second line, which is your risk and compliance. You also have a third line, which is your internal audit. We have whistleblowing lines, we have fraud departments. We haven't actually got all these issues through our whistleblowing. I don't know whether it's a lack of confidence in the system or what, but we tried to put certain things in place that we believe that from an oversight and governance will help. But it seems like they were not enough, Chair. Thanks.
Chair, Moses reminded me of something I completely forgot. We did actually ask the Institute of Directors to come and do an independent assessment of the board and its subcommittees. Because you can't be a player and a referee. Somebody must come and see if you are carrying out your duties well. That report is available. It's independent, it's got nothing to do, but we were also checking, putting a pulse on ourselves. What is it that we are doing wrong? And the report is clear. The subcommittees were carrying out their duties. There were committee charters, there was a board charter. The decision-making process was thoroughly interrogated. And in reality, the report talks to independent evaluation of the board, if I can just mention that. I think it's an important thing because we are seen as people who are just taking reckless decisions or who are being instructed by management, and we seem not to be having an independent view. So we actually did ask IODS to come and assess us, and that report is available.
All right, no, thank you. I'm going to come to Honorable Bila now. I'm just kind of listening to this conversation. I just want to make a comment. It's not a question. I think And if after this conversation today, you've had, with the benefit of reflection, you want to make recommendations, you want to suggest recommendations to us, we will accept them. And here's why. There's got to be a way in which a board is not so easily misled. So I will really just give a few examples and just leave them with you, which we canvassed just today, right? So, for example, you were under the impression that the chief executive's, security cost was, as you had said, it wasn't happening and you didn't know until you got a whistleblowing, right? So that's one. You were under the impression that what you were stopping is the solicitation of claims, right? You otherwise wanted to expand access to people. What instead happened is that access actually was reduced. You had no idea, right? So that is the second example. The third example is this accounting policy. And as you can see in section 4 thereof, and I'll actually, Mr. Nyama, give you my reserve copy. Mora appeared to be taking a cautious approach, saying, get legal opinion, etc. And with the benefit of that now, where the matter has been to court and the road accident fund has actually not succeeded in prevailing, you go back and you think, had we been dealing with a management that was candid with us, maybe this whole thing would have never arisen. We might have taken a different approach and so on. The instances where somebody is appointed CFO, and if you recall now, just think about it. There were so many acting positions. Have you considered that the reason there were so many people in acting roles is so that you don't make an input? And therefore, it called on you as board members to say, hey, too much is happening here, and we haven't appointed these people. Some of them we don't even remember. We don't know where they came from. And yet, in terms of the RAF Act, management are not the accounting authority. We are. You understand? So I'm not going to go through the whole list. I'm just saying, part of the reason you have this frustration, we're now going through these issues. And you can see that, well, there are things you're hearing for the first time. Right? And yet you took decisions. And I agree, one of you said, I think it was Ms. Francois or you, Dr. Mabuya, trust between the board and management is critical, because you can't go and re-examine every email that was shared between management and the employees. You need management that is going to be open with you and give you truthful information so that you don't also take bad decisions and then later you get shouted at in parliament. Right? Which is the sort of thing that happens, right? So all I'm saying is that I'm just asking you to just reflect, because this road accident fund thing has got so many, it's got so much politics that for those of us who just want to work through the problems, you have to fight through mist of people thinking you're targeting someone. But I think we can agree that there are gaps. There are gaps that the committee needs to solve so that it doesn't happen again. Honorable, my mind is freezing. Honorable Pila.
Thanks, Chair, and good afternoon, everyone. Let me start by indicating to the doctor that, yes, as a board, you are like us here in the SCOPA. We are doing oversight to all departments, the state-owned entities. But when they come here and appear before SCOPA, it doesn't end there. When a municipality in the Eastern Cape come and tell this committee that there is a dam at Ntsonyeni, we don't just relax and say the dam is there, our people are getting water. But we have to go to Ntsonyeni and check if that dam is actually there. There can be a lot of reservoirs that have been erected, but no water that our communities are getting. So we have to go there and check. So it's like yourself, you don't take everything and trust everything that the management is telling you, because you will be played and make embarrassment before people or before the country of South Africa without knowing what was happening in the entity that you were given an opportunity to govern. For example, there's an issue of morar. You are hearing it for the first time here. Are you aware that when the RAF went to make an engagement with PwC, there were no documentation that was relevant to that engagement that was happening there, including the Morar Incorporated. The PwC started to hear about the Morar in this, when they come and appear before this committee. So next time when we are given a responsibility, let us do what is expected of us. I don't say you are not doing enough, but please let us do what is expected of us. It was stated in this committee that PwC was appointed to conduct an independent review of RAF's financial statements before submission to the Auditor General. Are you aware about that?
Thank you, Chair. Chair, I'm not sure at what stage, but I know that entities would get an independent service provider to review their draft financial statements before submission to the audit committee for audit purposes. But I'm not sure, I'm not aware of this particular instance. But it's a normal process that management does, and they don't need permission from the board to do that, because what they do is that they need to ensure that the draft financial statements that they submit are actually compliant and they are free from major misstatements. So it's a management process which is acceptable to ensure that their draft financials meet the reporting framework. But I don't remember this particular one.
I agree with you. Can we please differentiate between interference and intervention? Because when we intervene, we want to know how far is that process that the management came and tell us about, that there is something that we want to process. Then you have to know how far is that process. But when we talk about interference, it's when you want to be a board member and be an executive member at the very same time. I hope we are together on that one. So you have to do follow-ups when you are given information by the executive, that how far are you with with the process that you came and brief us about. Let me go straight to some of my questions, Honorable Chair. As a body that had an oversight of the RAF, would you say that you had your hand on the pulse of the organization in ensuring that everything that was being done was in line with strategy? If so, how do you explain the cancellation of the panel of attorneys and its aftermath? How do you explain the hold on direct claims and RAF on the road? How do you explain the implementation of the integrated claims management system?
Chair, let me start broadly overall. Honorable Member, I think in terms of our oversight mandate, the role of the board is to approve policies and major transactions in line with the delegated authority. And a lot of those major contracts were approved by the board based on representations and documentation brought to us by management. And I think there's also a very clear disclaimer that management, or maybe assurance, every support board documentation requesting for approval, they will put an assurance saying that they've applied within the relevant laws and legislations. They've also complied with relevant policies that are applicable within the frameworks of RAF. So we would get those assurances before we approve certain, let's say, substantial contracts, like the integrated management system and the panel of attorneys. But really, beyond that, management will have to implement. But we provided oversight and asking questions. I think you're making a very critical point, member, that we could have maybe gone beyond and actually went and checked on some of those things. I think with hindsight, I have to accept that we could have maybe uncovered some of these things. But when we asked questions and we received trusted responses that made sense at the time, we had no reasons to believe that we were being misled in certain matters. But yes, with hindsight, we could have gone the extra mile. We could have seen these things instead of seeing them now and saying, you know, we were not aware. So I just wanted to deal with it, and then maybe
Sure. Yeah, so maybe, member, thank you so much, honorable member. I think we do have the benefit of hindsight. And one of the things and painful things we've learned, remember, we appointed the CEO. So it's not like this fell from somewhere. This is the person we had put our trust in. I think it's important to also mention that. But at the same time, things could have happened that we didn't see, or whatever happened, at a point when we felt this is overstepping the mark. As a board, we did take the responsible decision. And I think, I'm not sure what next you do at a point when you realize the wheels are coming off. Let's stamp our authority. Let's make sure we stop this. So it's not like we left the train to run on its own. And when you trusted somebody, you put them in a position of authority, and then ultimately you realize things are not going the right way, and you still make the right decision and say, this is where it stops. I think that is acting responsibly.
Thank you so much. I think sometimes we have to accept and agree if things didn't go the way it was supposed to go. And then we stop to be defensive, because defense mechanism doesn't work everywhere. So we have to accept when things didn't go accordingly. What did the executive explain as the reason for 2 consecutive cyber attacks at RAF? Have you ever heard of an entire ICT management fired all at the same time before, or was RAF the first time? Did it sound normal to you? Was the firing of the entire management team at Main Lane, biggest region of the organization, not alarming to you? Thank you.
Honorable member, cybersecurity is a big issue for RAF. So one, you're right, when we then heard the extent to which we suffered the pain, we were equally shocked, but we actually wanted remedies, because it's something we should have prevented, anticipated. I'm talking in terms of management, because they were there, they should have known that when you deal with this high amount of claims, that's one of the key priorities, to manage your cybersecurity, do penetration tests, make sure you've got the right expertise online. Now, at the audit skill that was done by PwC, some of the highlights were highlighted, that we have a big gap on some of these ICT kind of skills. And then we were struck by this particular matter. The reality of the matter, we did not take it lightly as a board. At least let me put that.
The shock was not enough. We felt they had failed us because this is a key matter for any organization. As much as we want to be digitized, digitization comes with its own risks. The digital platform opens you up, and our data is very rich. So cyber people would be looking after our data. We should have done better than what we actually experienced. And the firing of the entire team, that was within the delegation of the CEO. He had his reasons that he advanced specifically to the board. There were trust issues, and it sounded like it was not even a third-party matter, it was one of the service providers who sort of initiated that. So there was a whole report. So that we didn't take, like the audit committee report applied itself. We got a full report of what is the suspicious act and how it was internally orchestrated. Something along those lines. That's just my recollection. The actual facts I don't remember. It was appalling to actually sit and listen to that meeting. That here we are, we've appointed service providers, we have staff, and there's some level of collusion of sorts that happened that led to this cybersecurity breach. So it's something we took very seriously. And I don't think, we even told them, in reality, this amounts to us wanting to fire the whole executive. That failed us, that failed us. But the reality is that you fire the whole executive, who runs RAF? I think those are the realities of what we are dealing with. The same PwC had given us a restructuring that changed us from about 15 executives, I think we went down to 8. And the matter of cybersecurity was hard to swallow. I won't sit here and lie and say, it was a complete failure. And that should not even have happened. We are a security, we are a claims management environment. It's something that should have been, everybody should have applied the mind, but that's what we had, and we had to deal with it. So when they then presented the full report of how it was orchestrated internally and that, we were sitting with this point. What do we do with this executive team? That was really what went through our minds, because they failed us as an organization. They failed the claimants. So I just want to bring the reality. In that situation, and there are many organizations who go through cybersecurity breaches. Do they fire everybody? There is always a risk mitigation strategy that you bring on board to control things. But that was one of the most painful and hurtful things, to be on the board of RAF and be told what we were told. Thank you, member.
And things start to go wrong when we start comparing ourselves with other institutions. Let us face the reality of the Road Accident Fund, where we are now. In 2019 to 2021 period, the Road Accident Fund changed its delegation of authority policy and multiple policies. Did you ever poke holes on that to ensure that these changes were working together with RAF strategy and not compromising sound corporate governance? And then let me couple it with this other question. As the board, were you working together with the CEO regarding the specialist roles that he was bringing into the organization and outsourcing of the call center? If so, can you please explain to this committee?
Thank you, Honorable Chair and Honorable Member. I'll deal with the issue of the DOA in terms of how it emerged. And I just want to make sure that I'm answering the right question. We're referring to moving from CEO's power to sign from 10 million to 30 or 40 million. Am I correct? Yeah, so I think one of the experiences we had then, especially within the operations and IT committee where we deal with tenders, there used to be quite a lot of special meetings where we were required to approve certain things above the 10 million. And I think we felt like there are too many meetings and there are too many low amounts that are coming to the committee, which eventually go to the board. I think the number of meetings spiked up. We requested the management to do benchmarking. I think it was within the transport sector as well as within the government to say that what would be the threshold for an entity with a revenue of our size from a DO point of view. And I think that exercise was done. We interrogated it, we satisfy ourselves, and then the board was comfortable to change that. Former chairs, I don't know if you want to comment on that.
Thank you, Moses. I think one of the critical considerations for the board at that time was how are we impacting the work of the RAF. It was taking the RAF quite some time to make decisions around finalizing tenders and therefore getting the work of the RAF going. So we felt that with this low amount after doing the benchmarking was that we did not want to be a hindrance to service delivery because we are holding up execution and having to wait for first committee meetings and then special board meetings. Thank you, Chair.
RAF went sometime in December period to benchmark best practices on an integrated claims processing system. I think that trip was approved by you as a board. Where is the document that came from that trip translating into the scope of work for the ICMS tender bid? Can the committee have a view of that document if it is there?
So, Honorable Chair, I'm assuming, can I just make sure I understand you? You want to know the process the board followed in recommending the integrated claims management process. Am I correct?
Yes, I am.
Okay,
You are.
thanks, Chair. I just wanted to make sure that I understand your question. So, I just want to give a context. The RAF
And sorry,
manages...
Sorry, Chair. I'm mindful of the time. Can the doctor try to shorten her responses so that my time cannot be...
All right. Chair, I just want to give a short context. I won't take long, Honorable Member. RAF manages 50 billion rand. It's one of the largest organizations in the country. You can't manage that sort of money using paper-based claims. So part of what informed us was that we needed a digitized environment to make sure that we can account for all the data, we can track, we can monitor, we can provide answers real time to drive efficiencies and to make sure that we can even start zooming into predictive analysis, allocate resources correctly. So it's not a decision we took lightly. We actually did a whole benchmarking. A proof of concept, I think Moses can expand, was even done before we rolled out to the organization. Because we were aware, changing systems is a huge project. And some of us had the benefit of having worked previously with the city of Joburg, where they introduced things like Operation Pakama, creating a one view of a customer. ICT systems might look good on paper, but when it comes to roll out, it becomes extremely complex. So, Chair, I do want to mention, it's not something we took overnight. We benchmarked, we did a proof of concept, and at a point when we were satisfied, we then started rolling it out in that way. There was a delay. We're totally unhappy with the service provider, but we cannot argue the fact that managing 50 billion rand, you must manage it on a paper-based claim system. That was not part of transformation.
Just to add, Honorable Chair and Honorable Member, if I may. Yeah, maybe to expand to Dr. N, this was also obviously informed by the strategy at that point in time. And I keep on repeating this to say that one of the 4 things that the executive authority set to us as a strategic objectives was to digitize integrated claim management system. And I think at that point in time, Chair, it made sense because a lot of entities in general globally, they were at the hype of starting to explore the data analytics, data insights, fourth industrial revolution. And when you look at how RAF operated, there was no way you're going to improve on your fraud and issues like that if you don't have a sophisticated system. But we were quite clear that locally engage with some of the private sector. I think Sasria was engaged, go see what they're doing. There was one private sector entity that was engaged. UIF, if I'm not mistaken, was engaged. And we also told them that historically we understand that RAF have failed to implement a system called FINIOS, learn, understand what has happened. Obviously systems are international, and I think the international trip was just to also go there and visit this potential service provider before you make a big decision around such a big spend. So that was really some of the input that came from the board, Chair. Thanks.
All right, no, thank you very much. So I think Honorable Bila's frustration is that she had asked about the trip. and it only got addressed like at the end. So I was listening, even sometimes because I talked to the staff on the phone, on the WhatsApp group to help us with information, but I was listening. And she asked about the trip, because I think that what she's trying to establish is whether the trip produced value for money. That's what she wants to get at. So I hear all of this local stuff. I think we've dealt with the need to digitize. I don't think the committee has a difficulty with it. But Honorable Bila says there was an overseas trip that cost a lot of money. And what she wants to know is, what's the value for money out of that trip? Am I reading you wrong, Honorable Bila? That's what I heard you to say. And the answer then becomes long,
correct,
and we don't deal with the trip.
You are correct. I was referring to the trip that was undergone by the...
Yeah. Can we assist Honorable Bila with an answer to that aspect? Were you aware of the trip? Do you know how much it cost? Did the Road Accident Fund derive value out of that trip where executives went overseas?
Chair, I don't have the actual recollection of the amount that was that, but the board was aware that we were embarking on a benchmarking trip. Some of the things had not necessarily been done before in the country, and I think we do have neighbors in the form of Botswana, Swaziland, who run fund management things that we wanted to understand, but there were also other entities in the UK and other parts of the world where we could learn. So the trip was something that was meant to be a study trip, analyze, give us best practice in terms of what would be best for RAF, and in addition also comparing with our own neighboring countries in terms of what they were doing. So the approval process, that was something we were all comfortable with. Value for money, Chair, it depends. I wouldn't say here and say we've got it or we don't have it. There are two sides to the thing. We learned new things in terms of the report that was given to us. We at least got to know what is happening in the UK, in the US, versus what's happening in Botswana and Swaziland, and what is happening in South Africa. So that's the value we got. We wouldn't have known about that. The UN always shares a report on road accident victims, on countries, on how countries must then zoom themselves into minimizing road accidents kind of things. So some of the things came with an analysis aligned to that big strategy that is driven there. So there was a good side in that. There was new knowledge, body of knowledge we didn't know anything about. Whether we implemented properly, that is just another matter, and that's where the issue of value. Maybe because we didn't implement effectively or correctly, that's where we eroded our own value. But the information is solid.
Thanks, Chair. One other thing that worries me as a person, it is that when Bukamuso was at infancy, Road Accident Fund kickstarted its Section 189 process, which human resourcing and organizational structure were you building since the system capabilities were still an unknown? What kind of strategy were you following when you started with the Section 189 process?
Thank you, Chair. Honorable Member, I think it's very important to understand what drives any automation, any system automation. It's not necessarily the organizational structure, it is the business processes, because the system supports the business processes. So what actually happened in terms of the planning, and I think that's what informed the benchmark as well, was that the specification of the system has to be developed first, the user requirements, and that really has to be informed by the documentation of the business processes, the mapping of the process in terms of what ideally the system should look like. So that is actually different from the Section 189 because that is the organizational structure. But the business process stands alone irrespective of what the structure looks like, because that is talking to how the system, the procedures of how the system works, the manual system before it's automated. So the manual system gets documented in terms of business processes mapped, and then you do a benchmark. And I think the important aspect of the benchmark was that RAF is it's a different organization. It's a social benefit fund with an element of insurance, finance institution, and a government entity. So there was no, other than the compensation fund and the URF, there were elements of benchmarking there. That's why it made sense to actually see the specifications of other international organizations that have the similar mandate and the work of the RAF, which is why then the knowledge that came back really informed how the system should work before it was developed, to avoid, because most systems, I mean, even at CF, I know I was involved at some stage, they had problems implementing the automating their system, their claims management system. So that information and benchmark was useful to actually influence the spec of what needed to be put in place.
Chair.
Last one. I have recognized your complaint, so I let you run over.
Many witnesses said that capacity was a key constraint at RAF. But here we are having a machine that was suspending core business staffers in operations. As a board, did you raise alarm bells regarding this as the board to executive committee? Except the improvement of requests not yet paid, would you say that road accident fund has improved its efficiencies and it's in a solid financial footing as the board?
Chair, thank you, Honorable Member. We didn't have data on the people that were representing us in court. One of the benefits of insourcing, we got access to data in terms of who exactly is our claimant. The insourcing of actuaries helped us to understand our actuarial liability better, plan better. The insourcing of our investigating team helped us to plan better. So we have data that is from 2023, 2024, 2024, 2025, because that's when we insourced. So leaving things outside there, outsourcing your core function, did not empower RAF at all. And it's been happening for close to 8 years. Road Accident Fund was formed around 1942. Multiple things happened. So that data was sitting elsewhere. You're managing a 50 billion entity. You don't even own your own data. Data is cash, and data is what makes organization plan better. So whether it was wrong or right, you can't outsource your main function if you are in a claims management environment. So for me, what we can share with you, the call center, this call center, is resolving 99% of our issues, this very same call center. Claimants are able to verify the status of their claims. Claimants are able to send emails, verify what documentation they have, if it is correct. And that is data we are trying to insource and make sure that the organization becomes an organization of tomorrow. You can't have your core function sitting elsewhere, and you are managing 50 billion.
50 billion. Honorable Chair, this one doesn't need a
Comment.
answer, it's a comment. But when the board was seeing that there is an issue with default judgments, they appointed CEO as COO. I don't know how they justified it, but I don't want an answer on that one. And you as a board, you are used to say Mr. Litswalo is a strong man, a strong CEO, very strict. Was he good to fight the legal fraternity or good as a turn-around strategist? It looks like Mr. Litswalo was too strong for you guys, so he ran the board and did as he pleased. I don't want an answer on that one. Thank you, Chair.
Thank you very much, Honorable Bila. So can I just, so all of your experienced board members and delegation, so the board, you remember, Mr. Nyama, we were explaining the whole thing around the upping the DOA to 30 million and so on. When the board delegates signing powers to someone, does that person inherit the delegation power so that they can then on-delegate to someone else? Do they? There's a reason why I'm asking this. So let me start with the principle. So you've delegated to me signing powers to, let's say, 5 million. Can I delegate someone else without telling you that I am no longer doing what I asked? I'm giving this to someone else to do.
Your question is very valid, and that's a policy gap. That, for me, is a policy gap. The delegation of authority is clearly defined. What are we delegating to the CEO? Where the policy gap is sitting is that if we've delegated this to you and you are unable to carry out the functions, come back to the board. Let the board apply itself in terms of who's next or capable to do this. So that specific matter highlights a policy gap. So you cannot, if work is delegated to me and I'm unable, I can't give it to Lorraine. It doesn't work like that. That's a policy gap.
All right, so the reason this is important, and I was reminded when my honorable colleagues were raising the delegation of authority issue. So the two contracts of 500 million rand each, they are clearly above the 30 million. The board approves and delegates the chief executive to sign the contract. The chief executive on both occasions is not there. He delegates it to someone else to sign. Never comes back to the board to say, I have delegated this to someone else. So can you please delegate in respect of this, because it's not a permanent thing, it's in respect of these two contracts, to say, actually, I won't be around, I'll be on leave when these are completed. Is it okay if Mr. or Miss so-and-so in the team and the board can say, it's fine, we know about it. So what all of us are sitting with are two contracts worth R1 billion that were delegated to the chief executive following approval by the board, and the chief executive delegated to someone else. I just want to know, were you made aware that the chief executive delegated, basically passed on that delegation to someone else? Because then with the one contract in particular, a lot of concerning things happened. I just wanted to just find out if you knew.
Chair, in terms of policy, that is irregular. That is irregular. There is no way of putting any other way. The quantum of delegation the board gives to the CEO is regulated. It's regulated, and we are doing it specifically for that reason. So if you then take that responsibility, issue it to somebody else outside the prescripts of your own delegation, that is irregular.
Okay, so what I'll leave you with before I come to Honorable Non-Danger is that, so you remember when Honorable Beasley was asking about the function that cost 3.9 million. So there was a staff function. It cost 3.9 million. It was at the Sentin Convention Center. I don't know if the board was invited, but it was nearly 4 million. It was 3.9 million. We then asked for information of how much was the road accident fund quoted by the entity. The road accident fund was quoted 975,000 rand by the Sentin Convention Center for everything. Everything else was extras, including executive drinks, music. I think my casa was there, and so on, right? So 2.9 million is extras. In an organization that had to dismiss service providers because there's not enough money. That's why Honorable Beasley was asking. This is why Honorable Neil May, I think it was, would be concerned about the delegation of authority. So that's one. We also pulled out a few examples of seemingly, in fact, of clearly, so the function, I mean, you can't, in this economy, after COVID, spend 4 million in one night. That's insane. Then there were concerning things. So you see at the Road Accident Fund, it was confirmed to us by Mr. Macintosh Polela, who is the head of marketing. So these are 2 marketing contracts. Mr. Polela then confirms to us that he does not check the invoices that these service providers send for whether the Road Accident Fund is paying fair value or not. The members were there. Whether the Road Accident Fund is paying fair value or not. That 500 million rand contract was supposed to run for 5 years, completing in 2027, I believe on the 18th or 28th of November or 18th of December, one of those two. The one that the chief executive was supposed to sign but didn't. I think, looking at the rate of expenditure on that contract, that all of that money is gone now. It's gone. There was under 100 million left sometime last year. And I canvassed with the chief governance officer and Mr. Polela that that contract is not going to reach, basically it's not going to reach the end, right? So let's look at the chain. And why Honorable, one of my colleagues here, I think it was Honorable Nilme, Honorable Skosana, I cannot recall, would be unhappy about saying we've performed. We've met all our targets. So let's look at the chain. 500 million rand contract, and there were other problems with it, by the way, because even the very motivation for it was mired in some questions. But that's happened at management level, so we won't bother you with it. We've asked management those questions. Then you delegate the chief executive authority to sign this contract. He does not sign it. He delegates your authority to someone else without your permission. That same contract is raided in the sense that on the 1 year, instead of spending 100 million, the Road Accident Fund spent an extra 60 million on that contract. It's a massive deviation. And Mr. Nyama, you were chairperson of the Audit and Risk Committee, of the Audit, at some point, but you were a member. Let me say you were a member, just for ease, right? You were a member of the Audit Committee, right? I'm now telling you things that we are not speculating. These are things we found out. These are facts now. We no longer speculate. We can furnish you with the information. That says, in my view, how funds are spent at the road accident fund is reckless. Certainly. Because to exceed annual expenditure by 60%, and you see all of these inflated costs. I mean, there were, the members can remember other examples where we pulled invoices and asked, but why is this costing this much? Eventually, Mr. Polela said, I never saw this invoice. I didn't even sign it. Someone in HR signed it. Someone somewhere else signed it. That's how things worked under your watch. That's why we're having this inquiry. So I'd like comment on that, because there is a whole chain, including a contract that now has run out of money 2 years ahead of schedule. 2 years. And these are the circumstances.
Chair,
Thank you, Chair.
okay,
Sorry.
so you can start, I'll come back.
Before the doctor and Chair of the Audit Committee maybe comments, I just want to talk to the overall principles of internal controls. Chair, we need to understand that when management overrides their own internal control systems and policies and delegation of authority, that is a deliberate act. And even auditors, when they start an audit, they always put a disclaimer that they cannot, the audit procedures are not designed to pick up management override, because managers are the owners of the internal controls. So if a CEO or a manager overrides their own controls, it's actually difficult even for auditors to pick up those things. And because it is an intentional process to override and also gain, I don't know if there were any gains on these issues, but also to mislead either the board, the authorities that needed to approve. Because when you exceed your signing authority or even give it to somebody else without approval by the board, that is an intentional act, and nobody can pick it up while it's happening. It can only be picked up subsequently, because, you know, it's something that management should have prevented, but they deliberately overrode their own controls. I just wanted to state that it is an act, you know, of, dishonesty.
Chair, on my side, I just want to mention we have an SCM policy, supply chain management policy, that's regulated by the PFMA and all other things that we have to regularize our environment. Part of that process involves the buyer of a service. Buyer of the service must go out of their way to benchmark, check, get market intelligence, gather data around the service they want. And once that is then done, they do the benchmark, and then they sort of scan the market and check who's capable, who's not capable of doing all that. Ultimately, once the buyer understands what service they need from the market, it must follow the prescripts of the supply chain policy. That process is governed in the main by the CFO and the bid evaluation committee, bid award committee, and ultimately things. So there are like 3 different subcommittees in terms of the prescripts of the law that must then go to appoint who is the correct service provider. Now, that is done to ensure we don't bypass processes. Now, if a team of senior executives bypasses supply chain management matters, we have given delegation with a threshold. If you do anything else outside that, that is irregular, Chair. We can't sit here and defend that, because the law prescribes that we must create a competitive environment and we must be fair to all the suppliers. So you can't necessarily choose your friends over what is best. And I think those figures talk to that. That then you choose people who you probably have an arrangement with, and then you allow them without necessarily following the prescripts of the law. As a board, what we can do is to put a supply management chain policy and give the relevant committees, ensure they are independent, and internal audit must come and check each process and give the board assurance that a fair process was followed. Chair, that is really our role of oversight. Other things will emerge, as you say, when people override internal controls. That is a different matter, completely outside our policy.
Yeah, thank you, Honorable Chair. I wanted to just add around the financial piece. Obviously, from the audit committee point of view, on a quarterly basis, you look at management accounts. And there, some of the things you consider is budget versus the actual spend. And if the gap or the deviation is above 5%, there would ordinarily be a note to explain why are those issues, even in your annual financial statement. So I would have to go back and check and get my recollection. But in terms of the overall expense, I can't remember from the board seeing overly deviation at a total level. I think sometimes at a transaction level, depending on how you report, you could see deviation. But I'll have to look at the specific case and see what were the notes, whether we found them acceptable or not. But I think just from oversight, from governance, on a quarterly basis, management account do come through the audit committee, interrogate, look at the revenue, look at the budget, actual line item, the notes and stuff like that. I just wanted to highlight that.
Let me just ask, so the deviation that you talk about, is it a sort of budget limit or budget allocation increase, or is it a transactional increase with an external service provider? What are you talking about? That would trigger a note to the audit committee. Which one, or is it both?
So remember, in general, your management account would be condensed. Some of these expenses, they will be lumped in one item. So we would ordinarily look at that, and then if it flags something, they'll have to explain that this number is high because it's driven by advertising or whatever the case might be. I don't know if I'm helpful.
Sure. I mean, we can, maybe later on talk about this. So the sequence of events on the governance side, or sort of on the management side, please switch on off the mic. So on the governance side is, so Mr. Victor Songelwa is CFO. He is asked to return to his old role. Ms. Mabusela is appointed. You don't even remember what she looks like. So also she didn't last long. Then Ms. Bernice Potgieter is appointed. Her appointment is peculiar. She was a manager reporting to Mr. Songel. She is then promoted above Mr. Songel. Now, one of the things that happens is that on a budget line of 100 million, during the course of one financial year, they exceed it by 60%. They spend an additional 60 million. And Ms. Potgieter approves it. So, the board, you are now on CFO number 3. You've had no hand in the appointment of that person. And that third person in the line, so the first person hides this document from you, together with the chief executive. I don't know how the company secretary got to know about it, but it's hidden. You don't know it. The person after that, Ms. Bernice Potgieter, among others, she's happy with the 60% deviation on an external expenditure by external service provider that is completely unmonitored. They admitted that the external service provider can buy anything from anyone, even though the contract itself, clause 18, I think it is, or 81, in the contract says the road accident fund must approve procurement of subcontracting on this, but actually that never happened as well. That was confirmed. So none of that happens. They don't know whether they're not hiring cousins and friends. They also don't monitor. And Ms. Potgieter approves a 60% deviation on budget. This is why I'm asking this question, because I am interested in whether that kind of excess on a line item would not come to the attention of, or at the very least, my expectation is the CFO would say, no, we're going to have to take 60 million from somewhere else. That's my concern, because that's now the chain of events. And that's why governance is part of this, because it has real financial implications. So I don't know if you've got a comment, but can you see CFO, you've got no hand. Some of the people don't know the issues they're dealing with. They can't ask the questions that they need to ask. They can't say no. There are no controls in place. And the 500 million rand contract at 100 million a year has deviations of up to 60 million, and all of that money is gone 2 years ahead of time. That's how difficult.
Yeah, Chair, Honorable Chair, I don't want to be defensive, but I think it's a serious concern. As the board, we approve the budget, and then the audit committee will then track how we measure against that budget on a quarterly basis. And anything that it's above the materiality level that we would have set from a deviation point of view, it gets scrutinized and questions get asked, reasons and stuff like that. I just don't have...
So I want Honorable Nondeja to come in. So you never became aware of this? So it was never brought to your attention in the audit committee that, listen, we are about to exceed just this one contract by 60 million, just for this year alone. Do you have any recollection of management bringing that to your attention, or the chief audit executive or the audit manager doing that?
Chair, honestly speaking, I don't want to lie. I don't recall.
All right, thank you. Honorable Nondeja.
Thank you, Chair. I'd like to start with the 480 of the CEO. I'm sitting here trying to figure out which is the real answer. I've got 3, if not 4 versions. It's incorporated in the contract. They didn't see it. When they picked it up, it was investigated, from which I would like to know how far did the investigation and what was the outcome. And it's not clear from the board what's their position, because the other one is saying this and the other one is saying that, and that leaves us in the middle of nowhere. So I would love to get an answer on that one, as to saying what is the real answer on this one. It shoot up with a lot of money, and one says it didn't, they didn't see it, one says they investigated, one says it's incorporated in the contract. So I would like to know which is the real story. I would like to know what's the board's view of the non-payment of outstanding court orders. What was the view of the board? Did they approve that? Because if it remains unpaid, the reason why it should be paid is to avoid further interest accumulation and punitive costs. And I would love to know, what did the board do on that one? What was the view of the board? My next one is, what's the board's justification on the litigation against the AGSA that cost over 11 million, only for the High Court and Supreme Court of Appeal to rule against RAF? What was that classified as at the end? What did you classify it as? And were there any consequence management that was implemented there? The committee heard testimony that several RAF employees were placed on extended suspension while continuing to receive salaries for years. The question I have is, what mechanism were implemented to monitor the outstanding disciplinary cases and the delays in initiating and concluding the hearings? I will pause there.
Thank you, Honourable Member. What we said around the security, around the 480,000, is that it's part of the CEO's contract for security. So we know about it. The board, these board members know about it, and the board members of that time know about it. It's included in the contract. It has a 10% escalation. We also indicated that security is a category B policy, which means it doesn't reside within the board, but within the executives, the CEO. However, because we were considering, or the issue was the security of the CEO, the matter had to come to the board for the board decision. In terms of then implementation, it then goes back to the executives. So I just want to confirm that board members at all times were aware of the 480,000. They approved it as part of the CEO's contract, and it escalates each year by 10%. Ms. Francois then dealt with the information that came to fore after that approval. Ms. Francois?
Thank you, Chair and Honorable Member. Yes, Honorable Member, I think the previous former Chair explained how the matter started, the contractual figure that was approved by the board, the 480,000 with the 10% escalation, and also confirming that that amount was never extended. There were no further extensions that were approved by the board in relation to this matter. That's why when we say that we were not aware of the extra security that was procured without informing the board or coming back to the board for approvals. And the matter surfaced at the point when the CEO was suspended. Remember that the board suspended the CEO in terms of a different matter. But when he was out on suspension, then we started getting whistleblowers letters talking about this thing happening. So when we realized that there were further allegations, we included those further allegations on the scope of the investigation that was done by the investigators that the board appointed to investigate the CEO suspension, because when you suspend, then there must be an investigation supporting whatever allegations so that the matter will go through the disciplinary process. But also the labor laws allow other matters that come through to be added in the investigation. So that's what we did to say, now there's a problem, let's allow the independent investigators to investigate this matter. But at the same time reported, I remember also reported to the AG in terms of the report that is required by the chairperson of the board and the chair of the audit committee in terms of whatever risks, emerging risks within the organization that we want the Auditor General to focus on when they're looking at their scope of audit. I raised that to the Auditor General as well. And that was around June 2025, Honorable Member. And in July, before in fact, we were removed on the eve when the board secretary was looking for a date for the board to sit to actually consider this investigation report. So the board never saw the investigation reports.
Honorable Member, I will touch on the issue of these extended suspensions that you mentioned. We did have deficiencies, Honorable Member. We didn't have a head of HR at the time. I think one of them came to the committee, testified how his contract ended, and ultimately an acting person was put there, and a process of recruiting an executive HR, I think they call corporate affairs or corporate human officer, something like that, started. That we expedited through REMCO and said it must happen. Because we then interviewed people, shortlisted people, but then the process somewhere, somehow, did not materialize to conclusion.
The board has got functions, has got a duty to act when things fall away. We actually presented this matter to the board to say we are not getting results from the REMCO process. We even recommended changing the chairman of REMCO because we felt it's not getting the required focus. This organization needs leadership in terms of, concluding the head of HR. So the reality of the matter is that there were those kind of gaps that we realized. I've already touched on how weak our ER environment was. Even the acting person didn't have, I was out of my, always angry in that meeting to say, how on earth do we overlook certain senior people with HR expertise and then bring somebody to act with no requisite skills? I think that is just one of those areas where you then say we have to conclude the recruitment of the HR process, and then we then picked up that no, part of the problem is that we are not having a strong leadership in that place, but we did intervene, we changed, we then put a different person to lead REMCO to make sure that that process happens. The issue of those 182 suspensions, that was a pain point, honorable member. It didn't only worry you, it worried us. It was a very, very hot and contentious matter. And we felt we are being failed by the delegation process, by even the people who are leading, the people at HR. So that is a failure that we cannot sit here and protect.
Chair, I don't think I'm getting the answers here. I'm being told stories that that was the failure, that was what. But my question is, what mechanism did the board felt that they were failed by management? And what mechanism did you recommend to the management to see to it that RAF doesn't pay people sitting at home for 3 to 5 years, and that those are addressed, those failures that you are citing are addressed? I'm not getting an answer to the questions that I asked. And I've asked a question about the litigation of the AG's office for over 11 million. What did you classify that at the end? Because you lost, even on the appeal and on the High Court, you lost as RAF. What was that classified as at the end, and what was done to the person responsible for that?
On the intervention, we actually introduced a promotions policy. In terms of the labor laws, you can't allow people to act for 5 years. It's wrong, it's irregular. So we then realized that we said, if somebody is already acting for 5 years, you might as well promote and make them permanent. Then there was no promotions policy. We then introduced that particular to say, these people who have been acting can be promoted because they've already shown their capability. So that's one intervention that we introduced to make sure that people stopped acting, but they take full accountability. One of the deficiencies of allowing people to act, they don't take full accountability of the responsibility. They enjoy the acting allowance, and that does not help the organization. So you either are taking the responsibility with full accountability, and you then lead us to say and indicate the change that you will bring. But if you are forever acting, it lacks accountability, that sort of thing. And it's one of the interventions we brought. We said, let's bring in a promotions policy so that these people can then be promoted and take positions rightfully. So I just wanted to close that particular loop. It's something new that we introduced.
Okay, so I think I understand Honorable Nondenja. I've stopped the clock. Honorable Nondenja's frustration. So as somebody who's been, and she prefaced by saying she's been listening to the conversation here. So when, in your view, do you think the board should intervene when management is not able to perform? Because you've made, Dr. Mabuya, this statement a few times about the fact that the road accident fund was losing cases, so therefore you're not getting the convictions. That's a problematic statement. And I'll explain why it's problematic in the context of what Honorable Nontenja is saying. Every organization has got processes. You charge people, you take disciplinary action against people for whatever reason. There is a hearing, they're either found guilty or they're not. If they then go to the CCMA and they win there, and they go on to the next stage, you can't be frustrated that you're not winning. Your frustration must be, why is it that we put charges that we can't substantiate against people? Why is it that in 5 years we can't complete an investigation and we can't take action against these people? That's the question to ask. And management can say once that our ER people are not competent. 5 years is a long time. And what Honorable Nontenja is asking is, but what did you then do? You can't throw your hands in the air for 5 years. That's what appears to have happened here. 5 years, people under suspension. 3 years under suspension. The policy says 3 months. Surely you must hold someone accountable. And I think the question is, who did you hold accountable ultimately? Is it somebody or nobody? That's the question. And I understand why she says she's not being answered. I'm not just asking you, Dr. Mabuya, you were the last one to answer. I don't want to be unfair.
Chair and honorable member, I do agree that the buck stops with the CEO on these matters, because we were raising these matters in the boardroom. He should have been the person who would have been taking the responsibility, and we should have basically asked him to actually do consequence management in terms of he needs to account or take corrective action against it, because it was his decisions that he was taking. But the problem was that he was giving us misleading information, because we were not tracking. I think the RAMCO, I remember some of the RAMCO reports. We were getting different reports, on a quarterly basis. So there was no ways of us tracking one case for 5 years and getting, because we're always getting summarized versions. But to answer your questions, you're right, the CEO should have been held to account for this. So I do accept that.
The last one, Chair, if I don't win with this one, I call it a day. I would like to know to what extent did you as the board do your oversight and approval of high-value procurement decisions relating to the panel of medical experts, panel of attorneys, Media Mix 360, and Zinge production contracts? What was the extent of your oversight as the board?
Thank you, honorable members. Through you, Chair, as I've said earlier, anything above 40 million or 30 million, it was coming to the board. And the way it will come to the board for approval, it will serve at the subcommittee in general of IT, and the reports will be interrogated, and a recommendation will be made to the board. And obviously, part of what we do is we ask internal audit to also give a view, depending on the quantum. Thanks.
Thank you. So that was your last. Okay. Thank you. Honorable Matiwane, I have not forgotten that you didn't get a chance. Unless you want to forfeit, in which case it's fine. But I must give you a chance.
Thank you, Chair. It's been a long day. And mankhawulezise manje nikhawuleni warhoqa sekulate ndithi nqanga nentsiba zayo. Chair,
Don't worry, it's not insulting anyone. It's fine.
You know, Chair, when you reading through the reports that we have, and you look at the report that we were presented yesterday of the costs that were paid to the top 20, not the entirety of the law firms that RAF has paid money into. In 5 financial years, it's 5.5 financial years, RAF has paid over 12 billion rands to 20 white law firms. And our permanent friend sitting across me, Mr. Gertnel of Gertnel Incorporated, they received over 860 million in those 5 years, which shows that there is a vested interest in him attending these RAF inquiries. He's permanently become a permanent member of the committee. Now, I want to check, Chair.
I think members get sworn in, Honorable Matiwane, but I get you.
So, by any means, Chair, that to me is by any definition, that to me, RAF was a cash cow for these law firms, however way that they might want to say it. If you look at the expenses, on the attorneys, the medical legal, the travel and accommodation, and I ask myself, wouldn't there be a pushback if these vast amounts of money are involved from the medical legal sector, from the legal sector? And I ask myself, who stands to benefit? Well, I'm asking the members, who stands, in their opinion, who stands to benefit from the regulation or the standardization of costing within the Road Accident Fund? And who stands to benefit if this system remains unchanged? And as a parting shot, Chair, there are systemic failures throughout the accountability matrix that involves the entity, which is the Road Accident Fund. It involves the Department of Transport as the overseer of Road Accident Fund. It involves the which is the executive, the minister. It involves us, Parliament, people who are tasked with amending legislation or drafting legislation to address any policy gaps that might exist that allow for a public entity like the Road Accident Fund to be bleeding billions of rands. And our focus seems to be on pickpockets or two fingers. Two finger utate 480 million. Whereas there are guys who are going away with over 12 billion rands in 5 years. And our focus is on people who are pickpocketing 480,000 rands or 480,000 rands. So I would like I would specifically ask this question to Dr. Mabuya. Who stands to benefit from a dysfunctional road accident fund? And my last question will go to Mr. Nyama. What recommendations would he give us on record, not the ones that they are going to write, on record as a parting shot? What would he say could be done better to improve the situation at RAF? Thank you.
Thank you, Honorable Member Makiwane. At some stage, before I joined the board, and when we were specifically giving influence towards policy, we clearly saw that the people who are benefiting from the system is the service providers. And it's not only one group. It's the legal people, it's the medical legal experts, it's the psychologists, and essentially this is being used as an enrichment scheme, maybe put differently. So that is real, and that's what needs to change. There is a case to mention really some of the abuse of the law and how people are milking the system. If I'm not wrong, it's Ketseleke versus RAF. This particular case, the man was a truck driver. During work, he then got involved in a car accident. His injuries go through the process of RAF, and the medical legal reports mentioned 2 injuries, that he had fractured the fourth and the fifth finger. The deformity he suffered permanently was on the small finger. And that process was then allowed. He was paid out. There was an amount that was mentioned in that particular case. It's a case that can be found, it's in public knowledge. The driver did not meet the AMA guides in terms of, him getting benefit, but he was paid because of many other reasons why the claim was actually delayed. He went back to work after 3 months. Went back to work, resumed his full duties as a truck driver. Now there are 2 systems in there. The first system is that he got injured during work. So why did it land at RAF? Because it's a compensation fund matter. You got injured at work, but RAF ended up with this matter. He works, he gets his salary, he's fine. 3 years down the line, he leaves his job for whatever reason. I don't know, but it was not related to the accident because it was fully proven. He went back to work, he drove SA, but he leaves. After leaving, he goes to his lawyer. And this is the same case that I'm talking about. When he goes to his lawyer pulls out a whole lot of medical reports. He's mentally affected. It's 3 years now, down the line. Mentally affected, can't do this. There's now a psychology report, there's a physiotherapy report, there's a hospital report, there's now a myriad of reports. They're coming back to milk RAF. So in a nutshell, the service providers are milking the system. And it's from all sorts of things. And that is really fundamentally what is the problem. We should be probably focusing on paying compensation or benefits for injured persons, and not finding loopholes where we spend our time with claims, litigating, proving this and the other. And that's really, in reality, what happened in that particular case. Somebody fully restored, but we paid, and they left work, they come back, they want to claim, and the process was encouraged by the service providers. So that's really the beneficiaries, Honorable Member.
Honorable Matiwane, I wanted recommendations too. So.
Thank you, Honorable Member. Thank you, Honorable Chair. Obviously, that's a mammoth task. But I'll just highlight 2 key things, or maybe 3 key things high level. I think my view is that you have to review the legislation. Currently, if you have a claimant, whether foreign or otherwise, that can get $500 million payout out of state, I think it's an imbalance. I think state is not meant to enrich people. I think it's meant to provide minimum benefits. And if people want more than that, they must self-insure or find alternative coverage. So I would think that the legislative review to define the benefits for different injuries and cap values on that, I think it's quite important. The funding method, whether you pay people in annuities or in installments, I think it will give government capacity to help people if you pay in installments instead of annuity, because we've seen what happens in I Blew It. And I think I'm regurgitating the foreigners issue again, that foreigners must self-insure or must find insurance locally. I think in terms of service providers as well, I think it is clear that there's an exploitation. You have to limit the amount of money that they can charge for the service that they are delivering. Whether you look at a percentage and people start pushing the quantum, or you fix it at a rent value, those are stuff that you'll have to look at it. I think the other piece that I want to call it out, I think on the accounting standard, I think there is clear confusion. Probably the RAF need to find a way to accelerate suitability of their standard, or at least the ASB need to look at it and accelerate that part. The other piece, I guess, to improve governance and stuff like that is really to find ways to standardize and enhance board members' assessment or board assessment in a very transparent way. maybe even to how the board members get appointed in a very transparent manner, so that there is no comeback that someone is not fit for purpose and all these things, but also so that in future you don't sit in situation like this. On an annual basis, you can review the performance of the board and decide whether they are performing, underperforming, and leaving them. Because sometimes we get impression that by meeting your APPs, you are actually doing well as a board, but you get a different views. So that would be my recommendation. If I go into details, we'll probably stay here until midnight, Chair. Thank you.
The part that would have taken you until midnight, you can make in writing. I'm serious though. If you can find the time to make recommendations in writing to us, please do. Or alternately, you can also look, when we send you the draft report, you can also look at the recommendations section and make further recommendations as well. So I wanted to ask if Honorable Matiwane, are you served? Because we allocate 20 minutes, then that releases other people to then ask questions. You put up your hand first and then Honorable Ment.
Chair, I just wanted to ask one question that obviously was occupying a lot of our minds, and that's to do with the contract for the call centre, which would have happened during the period of your sitting on the boards for about 500 million. And I think there's some concern around it because that was something that was actually done in-house for about, I'm told, about 20 million. And there's a concern that it didn't follow due process. Could you maybe just let us know what your experience of it was, whether you were able to, I'm sorry, I'm looking at you, but I'm actually talking to everybody, whether we can be assured that it actually followed due process, that they went out and actually asked for other quotes, so it wasn't just only one person that came through. And why it was so expensive. 500 million, I think, was put aside for the call centre. It's one of those things that's kind of been flagged as a concern. And when we asked Mr. Letswalo, he said that the Auditor General didn't have a problem, but what he didn't tell us about was that it wasn't actually the year that it didn't fall within the year of the financial statement, so that was actually still to come. But I'd just like your undertaking as a board, or as a former board, that due process was followed and that you were all comfortable that that's all completely above board. Thank you.
Okay, Chair, I'll explain process and procedure. And it's fine if I repeat, I hope, Chair.
Look, I think this is one way. The question is simple. Are you satisfied that it was above board? I think it's a yes or no question.
Yeah, Honourable Member, at that point in time, we were satisfied. It served at the Upside 2 committee. Ultimately, it served at the board. But to give you a bit of a history, to my best of my recollection, I think there was a POC for 18 months to see whether what can this thing achieve if we commit for a longer term. There were clear key performance indicators that we put in place to decide on failure or success. And I think if I recall, all those boxes was ticked. And then from a SCM point of view, to my recollection, the process was followed. I think the internal audit also looked at it. I can't remember what you call it, that test, Dr. N, property. There were a few things that were done from a governance point of view because the quantum was quite high. Thank you.
Chair, can I add, just before he comes in?
Yeah.
So due process, we believe, was followed to an extent that when it served at OPSIT, I was already a member of OPSIT. And I specifically asked, who are these people? Where do they come from? Can we get their CVs, the companies? The property was quite detailed in terms of satisfying ourselves that this is really, they're following. We were almost interfering because, the bid award committee brings a name and the amount, and we don't know who these people are. We then said, can we satisfy ourselves that there's no direct conflict of interest in awarding this particular award to them? And I think as Mr. Nyama, he was chairing then, we were satisfied that at least due and the SCM prescripts were followed. So that much I want to confirm, because we did satisfy ourselves to say it was something that was done in line with our supply chain management policy.
Sorry, Chair, one key missing information. If I recall as well, AGSA looked at that contract, the big ones. They give it a green light as well. Thank you.
All right, Honorable Mente.
No, thank you, Chair. It's also on the communication, or rather media contracts. The two companies. Earlier on, I think one member mentioned how one of those two contracts, the expenditure framework of that contract is not in line with the allocated budget of the contract. I think it was Chair who said, by now, we think that 500 million has been depleted. Now, obviously, they will come back to account for those things. But where it aches me the most is that there has been a posture that was taken at RAF. And unfortunately, also yourselves could not give us the satisfaction or comfort as to who actually took this decision of not communicating to the public on how to approach and have full access to RAF on the processes of how to go about their claims. That includes the closure of offices which are satellites in certain remote areas. Now, what aches me the most is, what are these two companies communicating? If they are not talking to that person in Qwaqwa, KwaNongoma, eCofimvaba, akho road shows, gazebos were taken, stationery, your pamphlets, posters, anything that has to do with communication to the public, which actually are sole beneficiaries of RAF, has stopped. And until today, we still don't know who took that decision. And that's my best interest again. I want to know who took that decision. Because that which Dr. Mabuya was saying, agreeing with us that the sole beneficiaries at this point are service providers, not the people. And then the RAF also is helping the situation by not attracting the victims to come and benefit. Now, when these contracts were presented to you, what was the scope? What is it that they were going to do there? What are they communicating? They are media for RAF and everything, but I failed to put a finger on the fundamental question, or rather duty, as to what is it that they do. If we can be helped there, maybe we will have some comfort. I'll add the other one when I get there.
Thank you very much, Honorable Chair and Honorable Member. The road shows was really trying to create an awareness of the services of the RAF, especially to remote areas where there were no local offices or even satellite offices. I think the road shows were basically reaching out to communities that, previously disadvantaged communities, to try and make the RAF accessible. I remember there was the medical services bus where they were helping drivers on the road with medical tests, and even assisting students in terms of crossing roads and stuff like that. It was also part of the awareness sessions to assist the people on the ground, the as well as drivers on the road. So it was a safety awareness plus also media outreach to say that this is what we do, and also you can now access, if you choose so, in terms of the law, come directly to us. We will fast track your process and also giving them the minimum requirements so that they know whatever happens, this is what the first minimum requirements that you needed to get. So it was really basically an awareness campaign to make the RAF services accessible to people who wouldn't really have easy access. And we've seen benefits, in that as well. And the community, I think it would have been also interesting if we had witnesses who were claimants really sharing their experiences, because there were times that they shared information around their experiences within RAF. The rehabilitation processes also, we were reaching out because there were programs that were ongoing in terms of rehabilitating a claimant who has been involved in a car accident. So there were a lot of benefits that came out of that. So, but what we did not foresee was the abuse really of the contracts and whoever made the decision to stop it. Who would? Because the CEO is the ultimate head of the operational RAF at the end of the day, if that decision wasn't taken by the board.
Chair, I just want to add, the board approves a budget. That's really our real oversight. We approve a budget, and within the budget, we make sure we stay within this budget to achieve certain strategic objectives. So the decision ultimately is delegated. The implementer is always the office of the CEO who does this. The money that was spent outside the delegated authority should have been reported back to the board. If there is now a huge deviation that says now we're moving from 500 million to whatever amount, that is the correct way to do things, because now we are taking a decision that impacts financially on the organization. The decision to stop RAF on the bus and all that sort of thing, it was a matter that was discussed at a strategy session at some stage. It was a matter of, can we review what works, what is impactful, and that sort of thing. That part was part of a discussion that happened. There is no resolution of the board, Honorable Mente, that says, stop doing this. The review was around, can we do an impact assessment of everything we do? What do we need to streamline to live within budget? And what else can we add to improve access of claimants into the fund? So that deviation that happened should have been reported to the board, even at the Audit and Risk Committee. And that's just what we approve a budget. And if it goes beyond, that is not supposed to be like it. It's supposed to come to us. We look at the issues. At some stage, we even at times need approval from National Treasury when things go that bad. So anything that's not brought to the board, obviously we are not aware of it, but there is a process of allowing, deviation, and up to 10%. 60% is completely irregular, completely irregular.
No, I'm glad you gave that light, because this was a bit foggy. It means, Chair, when they come for their accountability line after the annual, not strategic, but annual reports, we ought to revisit, because bulk of what is it, Media 60, bulk of what Media 60 did, or rather undertaken, was during the period when there was no communication to the people on what RAF is, how to get there, how do you get help, if you can't get to a doctor, what must you do, pamphlets, all those things. All that which Ms. Francois is painting, that picture, is a good picture, but money was spent and that picture was out of the way. So my question was exactly around What is it that was there? So you do not know, you didn't sanction it, they will have to explain to us what is it that they did. The next one is on trying to fix the problem at RAF. And it's so unfortunate that I must plead with you that when the portfolio committee on transport is doing what we are doing, you must come back. You must not say we have gone to scope. Because bulk of what we have asked you here is within the mandate of the portfolio committee in terms of operations and all of that. It's not necessarily under the financial oversight. However, we have a problem that we've identified, and Mr. Nyama has gone to town explaining some of the amendments which could assist us. But here in the immediate, in line with the example that you have given us of a truck driver, yesterday I also drew a parallel on a person who's dependent on their hands to work. Get into an accident, all the fingers gone. In reality, fingers gone. Then there's another person whose skull is open. But if you take that person to the best hospitals in South Africa, which in the main are public hospitals, by the way, they can be fixed, 100% functional. But my fingers will not come back. But at face value, that person whose skull was open is a very serious injury. And the person who lost fingers is a minor injury because your recovery is within weeks. Some of us are coming from a culture where even the fingers get cut and you recover in a day or two after that. So if you lose a finger, you don't suffer that much as compared to someone's skull that's open. But the recovery doesn't mean much if that person will come back, function optimally. If they are a singer, they will continue to sing. If they are a dancer, they will continue to dance. If they are a seamstresser, they will continue to seamstress. I will not. Because I need to hold a mic. I need to be able to do things and all of those things. Now, if you go to the biggest fans, was it DiBrolio? DiBrolio, Harnell, and all of them. They have money. They are able to assist the victim to get the best medical report, which gives you a future and the claims. But if I go to Msibi and Associates, he's got 50 clients already, not paid, and cash flow is a problem. Now, we can't get the specialists. If I go to public hospital, I must wait for months and all of that. There's prescription that I'm chasing. There's all of those things. Likelihood is that I will not get what's due to me. But that person with an open skull, he is going to get a hefty amount because they received attention from people who are resourceful. Here is where I'm going with this narrative. Can RAF, at this current juncture, in the immediate, trying to resolve all of this, can RAF capacitate itself and have in-house people that can do this fairly without having to depend on lawyers to go and argue that this amount is less, that amount is more, therefore I need higher or lower and all of that? Because the problem that creates this opportunity for the big firms to take as much money, that 12 billion in 5 years, is because RAF cannot argue on its own. It doesn't have capacity, nothing. Is it possible in the immediate? We're not going to do all these things same time, unless we get to stop the lump sum, which I agree with fully, because also paying people lump sum, they end up not knowing what to do with the money, most cases. And also, they go back to work having been paid a lump sum. But if we don't pay a lump sum, we are able to monitor. Then you go to work, we stop. So is it possible, Doctor, that we can get a component within RAF which deals with the most critical elements of deciding a claim fairly?
Thanks, Honorable Mentor. Your insight is, I really like the narrative that you've shared, and it's real, and that's a typical South African situation. If I can come to the issue of insourcing, the immediate solution is insourcing. There are serious injuries that you don't have to argue, go up and down, look for this report, and they were supposed to be finalized even by 2008. Some people still belong there, like somebody who's got paraplegia, quadriplegia. So those are some of the things that are not debatable. You suffer this in a car accident, it's a serious injury. We don't have to be sending you to 10 specialists or through the enrichment program that is sort of out there. So we can categorize what constitutes a serious injury. Medically, specialists, and by insourcing, we can manage to do that to help shorten the litigation process and medicalize the whole process in such a way that we can pay within 120 days, we can pay within certain time frames to make sure that we don't delay the delivery of service if we categorize our injuries in that way. So insourcing and categorizing is a possible short-term solution. Then there's the medium-term side of things. Now, the one example we've made is very relevant. Losing 4 fingers makes you lose, the hands account for 60% of your functionality in terms of how we measure the armor guide. The loss of feet could account for up to 40%. So the hands are critical in many ways because you can't do many things because of that limitation, and hence those issues become important. So what we can do, we can insource some of these specialities, create a strong medical unit. Now, I'm going to come back to that. We used to have that. And that's why we managed to even have a bill of medical tariffs, start introducing managed healthcare principles, and appoint case managers who must go to these facilities, check what is really happening, confirm that we are not being overbilled. So that medicalization of RAF is part of the short-term solution. So that can be done. We need to make sure it's led by the right people. And what is really an issue is issues around psychology. Children, when they're involved in car accidents, most of the time the reports are extremely exaggerated, rightfully or wrongfully. There's always a report that comes that says my child was going to be a lawyer and an actuary, and this car accident has made my child not to be able to reach their full potential. So that is really the sort of environment we are working in. And what made that strong is the narrative test. Part of our recommendation on the amendments of the RAF Amendment Act was that the narrative test as a whole must be revisited because there are big loopholes which are mostly subjective and they are not helping the cause. But if we just structured on strengthening the medical department, bringing the right specialists, and I'm talking your doctor, a psychologist, OT, also having an actuary on site, that in itself is a big intervention that could help manage the cases quicker, because a serious injury is if you get involved in a car accident and you become paraplegic, that's a serious injury. There is no doubt about that. The specialist reports, the hospital reports would confirm that. So that intervention, Honorable Member, could help. That intervention could help.
Thank you very much. We will have a strategic session with specialist. I don't know if it's allowed Chair, or we have budget. Because in order to correct what's wrong at RAF, we really need to start it from scratch. There's just no way around it. Now, thank you very much. Okay, the last one was on the list of lawyers, the hospitals that shut down because RAF didn't pay, as well as it's lawyers, it's the hospitals, and then it's a medical aid. And there's a letter which was at some point received by a minister. I think it's which medical aid is Discover. Yeah. Why were they not paid? Can you take us there? Because we need to really have a story that's full. Why are the people who are claiming today that RAF didn't pay? Sunshine said they shut down their operations because RAF never paid. I don't know whether they're dependent on RAF only as a private hospital, fully functioning private hospital. But one invoice of RAF not being paid, then they shut down. Why was there a decision not to pay if that was a decision? If that wasn't a decision, do you know why they were not paid, and what is the argument around that?
Facts well around Sunshine, but I do know before my time that there was a very strong rumor that Sunshine was an appointed service provider of RAF, so sort of like accredited service provider of RAF. Now, I don't know if that was, we asked CEO to dig into that and check where does this rumor come from, because suddenly it sounded like people were bussed around South Africa going to Sunshine. I think it's somewhere in the East Rand. So we didn't know what informed that. We have many trauma centers in this country. So what was so special about Sunshine that people needed to be passed around specifically to do that? They did do the due diligence around the whole matter around Sunshine. It then turned out that there was some relationship with some of our internal staff members, and I think some of the claims were pushed there based on I don't think there was a formal agreement, let me mention that, because it's part of the due diligence that was found. We didn't find a signed memorandum of agreement. They were supposed to be treated like any other hospital. If they treated our people, we are supposed to pay them, but there was this expectation that they were accredited based on some of the relationships they had with some of our staff members. So the fallout happened somewhere. I'm not sure exactly at which point did it happen, because there was a point of collusion that was also, we had FID, the Forensic Investigation Department. That department was extremely helpful at RAF, because anything that we couldn't answer, we would then ask them to go and investigate for us what has gone wrong, and they would then produce reports which spoke to all matters that related to fraudulent claiming, double payments, and that sort of thing. So that is my recollection of what really, and the fallout was around those kind of issues. There is no other hospital that came and complained that we are not paying them. So that's just the context around Sunshine Hospital and that sort of thing. But there are many other hospitals where our patients go, rehab, we get paid, and we don't necessarily experience the same kind of problems, kind of thing. Now, the Discovery matter was actually taken to court. In terms of the Medical Schemes Act, prescribed minimum benefits are payable by the medical aid, and there's a section, specific section that talks to all that in terms. So the issue is, when the matter was ventilated to us in court, is that when you have already taken cover, that your medical issues must be covered by medical aid. What part of the act allows you to double dip, to claim from Discovery and then claim from RAF? And that became an issue that was legal in nature. It was legal in nature. We didn't, Section 8 of the Medical Schemes Act prescribe what needs to be done, that sort of thing, but in the past practice, medical schemes were recovering funds from the road accident fund. And that became an issue to say, are we doing the right thing? We found the previous board doing it, we are just following. Is this legal? Can we test? Why are we doing what we are doing? And through that process, that whole matter was ventilated and it went to court. And I think because they were claiming, I can't remember the actual quantum, they actually lost that particular case because the merits of carrying on with what was being done was actually ventilated in court, and that's how they lost the case. So I can't remember exactly what were the specifics, but the reality of the matter, it was a practice we found. We were questioning everything because we were having issues with money. We basically were reviewing all key matters that were taking money out, and we applied ourselves. We engaged a team of lawyers because we questioned, why are we continuing to do what is this when the act in the Medical Schemes Act says this must be done? And I think that's how we went to court and that's how they lost. Moses, I don't know if you remember other specifics around that case. I can't recollect some of the specifics.
Yeah, no, thanks, Honorable Member. I think, Dr. N, you've covered it very well, but to my recollection, I think one of the fundamental thing in that High Court ruling, I think they said, the court says RAF is not an insurance company. Therefore, the principle of subrogation does not apply. So you can't go and claim from RAF. That's to my recollection. I thought it's worth mentioning. Thanks.
I'm Mbulela Chair. It looks like Enquiry resources PLS South Africa.
No,
Because
no, no, no.
If then that's the case, we have a very serious problem. If medical aids have taken money of taxpayers meant for victims of accidents, took it back to them, not reimburse the victims that which they have paid out of their premiums, that's a serious criminal offense. But it's for another day. Thank you.
I'm going to study law and become a lawyer. With all of these commissions going on, I can just be represent the people that appear there at the commission. I just want to canvass a few things with you, colleagues, which relate to access. And I'll deal with the matter of the RAF 1 form to understand the extent to which you considered the implications. So I'm just going to ask some yes or no questions just to get over the basics. Are you aware that in terms of the RAF 1 form, a claimant must have all the medical, actuarial, and other reports before the claim is registered? Are you aware of that? I suspect, I don't know to speak on your behalf, I think this is something that happens with Ms. Francois and so on. When was the RAF 1 form an issue?
2022, 23.
Anyway, anybody who's comfortable, so I'm
Yeah.
not directing any. Are you aware of
yeah,
that?
yeah.
Those are the requirements. So I'm not.
yeah.
I'm just asking if
Yes,
you're
yeah.
aware.
Chair, we are aware. I think I wanted to just mention something. If you pay a claim, you need full information.
No, we're gonna get there.
Okay.
Don't suppose where I'm going.
Okay,
I
alright.
might be going somewhere else
Alright,
entirely.
yeah,
Yeah.
okay.
So don't
Yes,
stress.
Okay.
Have you considered how much those reports cost? And let's say someone is, sorry, can you switch off the mic,
Oh,
Dr. Mabuya? Someone is really badly injured, run over by a truck, didn't die, head injuries, broken bones, possible paralysis, and so on. Have you considered how much those reports each cost? Your neurospecialists, your orthopedics, your occupational specialists, and so on. Have you considered how much they cost?
Chair, we are aware. They are not cheap reports because most of them come from specialists. So they are not cheap reports. So we are aware of the financial impact on the claimant.
So we were told that for the most severe injuries, they can be north of 100,000 rand. So, you would accept, therefore, that someone who is from a disadvantaged area, they've already had their access to a walk-in satellite center taken away, all of the education. You would be aware that it's nearly impossible for those people to access those reports. Some of them won't even know what a neuro specialist is or where to find one. Would I be wrong in saying that is generally true for those people?
That's correct. That is correct, Chair.
So when this process was undertaken, you were comfortable that notwithstanding, it should go ahead?
I think it's section 24 of the RAF Act that talks to what needs to happen. So the costs are prohibitive, that we agree to. But what is really a principal matter, and I'm going to talk to the principal matter, that section specifically mentions that we must have full information in terms of what are we paying. Do we pay everything that comes? But we must have some form of evidence of the injury that happened, and supportive documentation must also come. So that is part of following that particular section of the law. By way of example, the compensation fund does exactly the same thing.
Dr. Mabuya, don't suppose where I'm going. I am simply asking a question. Having considered what I've just put to you, you were okay to proceed and put measures in place that, by your own admission just now, would exclude people who are indigent or not so educated or from rural areas, from small towns, and so on. The board took the decision. I mean, you have to be comfortable with your decision. I don't suppose you take a decision and then still come here and say you're not comfortable with it.
Sorry, Chair, let me just add, one of the changes in the legislation was that the RAF Act has the regulations built within the Act. And that's why the Act needed to be a change so that the regulations stand out, so that it's easier to change those aspects, because the RAF 1 form comes from the regulations, but that are embedded within the legislation. So there was one expectation that eventually the RAF amendment bill would be enacted into law to allow for the separation, so those matters could be dealt with easily by management.
You do accept, and we'll come to the legislation. I'm ready for that conversation. You would, so as we speak now, none of these changes have taken place. You are aware that an unknown and untold number of people simply don't even get their claims registered because the Road Accident Fund refuses to register a claim when not all the reports are submitted. Let me give you an example of the difference practically. When the Road Accident Fund was still assisting people in outlying areas, they would at least get an undertaking letter, which undertaking letter allows them to access medical treatment in the meantime. While all the rest of the nyaga is getting sorted out, damages, etc., at least if you're so broken up, you can go to a medical facility and get treatment. You are aware of that, right? So that does not happen any longer. You have to bring everything before they even register it. That's the decision that you've taken. You know that. Okay. So we agree that a decision that excludes so many people was then taken. Are you aware that of the Busuku judgment? It's very common in Road Accident Fund, in the legal department, claims handlers, claims administrators, they all know about it. Mr. Busuku was from where I come from. The matter started in the Mthatha High Court. It went all the way to the Constitutional Court. Mr. Busuku won. Are you aware of the case? It is so important to the thinking of the board, of any board, because of what the Constitutional Court says. So you are aware of it, right? So, okay. So Dr. Mabuya is aware of it. So the Road Accident Fund then, I think, does somewhat the right thing, although Constitutional Court judgments are in and of themselves, you know, final. They approached Advocate Ishmael Semenya, SC, for advice delivered in February 2022. Did management ever share that legal advice with you? That counsel's advice with the board? Because it's important, I'm holding it in my hand. It's very comprehensive, it's 16 pages long. Okay, I will ask that my colleagues favor you with it, but let me read from what it says. And and Advocate Semenya is literally, in lawyer terms, he's shouting at management. I mean, read some of, so the judgment says the RAF 1 form does not call for detailed information. It is not intended of itself to enable the fund to assess the quantum of the plaintiff's claim. It seeks to enable it to investigate the impact of the injuries sustained. So it triggers an investigation. It's not supposed to be at the end of the investigation. You understand, right? On the first page of the medical report section of the form, it seeks particulars of any emergency transport, etc., etc. So that's the old RAF 1 form. But the court goes further to say the relevant section of the legislation, which has never been amended, does not call for full and final information at the first instance. Right, there must be further investigation. The Road Accident Fund says, no, we want to be able to make a final decision with all the documentation that you've submitted. Right. So, Advocate Semenya says, don't do this. He says in paragraph 21 that the fund issued a directive dated 8 March 2021 with effect from 1 April 2021, which prescribed requirements over and above those stipulated in section 24 of the Act and Regulation 7.1. The fund is not entitled to such additional requirements for the lodging of a claim. It has no power to do so by way of a management directive. By the same token, the fund also has no right to refuse to accept delivery of claim forms. It is not surprising that on 15 June 2021, an interim order was granted in the Pretoria High Court, which interdicted the fund from enforcing the directive dated 8 March 2021. He goes on. He then says, which is the most important paragraph, in the absence of legislative amendment, section 245 of the Act is the only mechanism in the RAF Act that the fund can utilize to object to the validity of the RAF 1 claim, failing which the claim is deemed to be valid as according to the SCA judgment. Non-compliant claims to which the fund has not objected in terms of section 24 subsection 5 are enforceable. So anyway, so this gets shared with management. The reason paragraph 24 of this legal advice is important is that it dispenses with RAF 1 form. It goes to the interpretation of the Act itself. Subsequent to this legal advice, when did RAF 1 form come into effect? Right. Subsequent to this legal advice, which you as the board are not furnished with, they do exactly what Advocate Ishmael Semenya says they must not do in paragraph 24. So what I want to ask you, did you as the board, or were you presented with another legal opinion which contradicted what Advocate Ishmael Semenya says in interpretation of the decision of the Constitutional Court then? Because I want to understand the basis upon which the board decided that it is comfortable with excluding so many people from being able to lodge a claim. Just being able to lodge, not being entitled to money, just being able to lodge.
Chair, we have a subcommittee of the board, the REGAL,
which has got the legal minds of the board sitting on that particular committee. So the board did not specifically deliberate over that particular matter, but those kind of matters get deliberated at the regal. The Busuku matter, one of the key issues is that the RAF Form 1 was not filled, and essentially, and that was really an issue at the point in time. When we say the form must be filled, we are talking also the date of the injury. We are not necessarily talking medical reports. I think I want to correct that. We are talking
You're
date of
not
injury.
correcting me. Can I interrupt you, please? You're actually not correcting me. You're saying something I didn't. You're correcting something I didn't say. I am well aware. So part of what the Road Accident Fund management do when they come here, they apply a smart diversionary tactic, which is to say, you can't not have ID numbers and that kind of thing. You will have noticed, I never mentioned ID numbers here.
Okay, all right.
I mean, I didn't. I also, for the benefit, because I've read the Busuku judgment over 20 times, one of the things and the principle that the court entrenches is that the medical reports that whose results you claim are not filled in on the form are attached to the damn thing. That's what the court says, excuse my language. They say the medical reports are attached. So to the extent that you need the information, you can't say it's not on the form, it's in an attachment, and therefore I'm going to reject it, which actually is what the Road Accident Fund had done, which is unconscionable. They were given the info. So I get what you are saying, right, Dr. Mabuya? And forgive me for being so passionate, because people get carried in blankets to law firm offices to be able to lodge a claim. And they're not able to. So I'm not arguing with ID numbers and addresses. Assume I accept all of that. I raise the issue of somebody from Stony Drift in the Wild Coast having to find a neuro specialist and an actuary and so on for 140,000 rand. When the court has said, don't do that thing. That's my difficulty. And senior counsel has said, don't do it. So my specific question for all of you, were you given another, so this we now know was hidden from you. One more thing your trusted management hid from you. But let me be generous and say they found another legal opinion. Are you aware of it? It's yes or no. Are you aware of another legal opinion which contradicts what Advocate Ishmael Semenya SC says here?
Chair, from my side, I'm not aware.
I'm also not aware, Chair.
Not aware, Chair.
Okay. So, your management secures legal advice. They don't like what the legal advice is saying. And I did ask, and I need to ask this question for the record. When last was the Road Accident Fund Act amended? Was it amended since 2021?
No.
Okay, so let me go back to paragraph 24.
The last amendment, Chair, was 2008.
Okay, great. So let me go back to paragraph 24 to be clear. So the advocate says, unless there is an amendment to the Act, you can't increase the requirements of this form. So I'm not blaming you, I'm just saying this document here, which I'm happy to give it to you, was never given to you. And management that acts in good faith discloses such things to the board. This was not declared, and further actions were taken. So let me ask, the LPWIC litigated this matter, right? The same matter, and they won. The SCA is due to rule this quarter on the same matter. So the Road Accident Fund has lost several times on this matter. So the courts have vindicated Advocate Ishmael Semenya each time. Right? So let me ask you this. Why is it that you don't, of your own, commission legal advice as the board? Why wouldn't you do that? I'm asking seriously.
Chair, there is nothing stopping us from doing that. In actual fact, it is the correct thing to do. And we did that. That particular case was not presented to us. I just know about it because I do go through a few cases to learn one or two things in terms of tactic. But there is nothing stopping the board from sorting independent legal advice. So at least there is no prohibition that stops us.
You simply didn't. There was nothing prohibiting you from getting legal advice, which would have assisted you minimize the impact on thousands, tens of thousands of accident victims, and you did not think to seek legal advice. Did any of the lawyers on the board suggest that you get legal advice?
From where I'm sitting, Chair, I'm not aware. As I said, those kind of matters serve at Regal and then they come to board. It never came to board, so it was never tabled. And none of the 43 companies that we have as a corporate panel suggested that we look at this particular matter.
Okay, I want to point to a pattern. So can we go together to section 4 of the Moral report, section 4 of the Moral report on that accounting policy issue, because I want to point something out and then come back to the extent to which you applied or didn't apply yourselves in your fiduciary responsibilities, right? So I will go again. So section 4 says, based on the analysis above this, but they say further legal opinion should be obtained to distinguish between an insurance contract and social benefit. So they ask for legal advice. The Road Accident Fund never actually asked for counsel's advice on that matter. The board doesn't. It litigates. As Xhosa, we say you litigate ngenqindi, which means you just go with your fist.
Chair, but this is the report that was never presented to us.
I am aware. So all I'm saying is that there are matters that have a profound impact on the mandate, on the ability of the Road Accident Fund, or the way it delivers on its mandate. Consistently, the board never asked for legal advice, even if nobody has said so. That's the pattern that emerges.
Chair, we had legal skills on the board, and we had a legal committee that looked at cases. So I think that particular case specifically, possibly it didn't even serve at Regal. The only reason I know about it is because I read medical legal cases. So really, at the end of the day, we have legal expertise on the board. We have a committee that looks at them. And if that didn't happen, we agree, it never served at the board.
It's not about the matter serving on the board. If there is so profound a matter with serious legal implications, the board should ask for counsel's advice. Consistently, the boards never asked for counsel's advice. And I'm concerned about that. Because it says to me, I think it was Honorable Skosana, and I hope I am not abusing his name, that it would appear that whatever management said, you would take it at face value and run with it, because on several occasions you have said this was hidden from us, we were misled, etc., etc. And I ask myself, why do you accept everything you are told? You are not supposed to be friends with management, right? So that's what you've created. Your management hid critical information from the board. You collectively, including colleagues that are not here, never sought legal advice, but you were prepared to litigate. On the AG matter, you sought legal advice, but you didn't seek legal advice, but you were prepared to litigate. In fact, the meeting at which the discussion on, we've got the minutes, the members have got the minutes, the discussion around the accounting policy. Mr. Malachi was in the meeting. He dropped off, it was on Teams, he dropped off at 12:35. I've read the minutes carefully. At no point in those meetings are his views ever captured or discussed, or he is asked to say anything. I can ask my assistant to give you those minutes as well. But you are prepared to litigate. What I want to know is, why are you prepared to litigate on no legal advice? Why would you be prepared to do that? It's an honest question. Why would you be prepared to litigate with no legal advice, with no counsel's advice, on matters that go all the way to the Constitutional Court?
Chair, with your permission, Mr. Malaji came to the board. We've requested his legal advice on the AXA matter several times. And we'll get the reports and we'll go through the reports, and then sometimes he will come, we will ask him to make himself available, then we'll ask questions. But many a times he'll present the reports and then we will ask questions. So it probably only got one set of minutes, but we've asked him several times, even when we were in between the court judgments, we will ask him to actually give us an impact in terms of withdrawing, from court. And he will give us an opinion, and then it will come to the board. Sometimes he'll be available, other times he will not be available. But we have asked for his legal advice a number of times in respect to this matter.
So for matters, Ms. Francois, that go to the High Court, Supreme Court of Appeal, it's actually really routine to ask for counsel's advice, not just your attorney, who is concerned about the client being unhappy with them and not retaining them next time. That's why that gets done. Mr. Malach or Malachi Incorporated does a whole lot of other work for the Road Accident Fund, and therefore is constrained because they are sort of an insider, right? So I've given to you, the members have this, because I want us to walk through the impact of some of the decisions that you've taken, because a lot of noise gets made about the billions that get paid to attorneys. So we're going to walk through it together. Right, so what you've got in front of you is, and this just covers some of the years. On my screen, I've got more. This is just for illustrative purposes, and we walked through this yesterday with the Legal Practice Council. So you remember those big amounts. Ms. Francois and Dr. Mabuya, you were here, and I think Mr. Nyama, you came to the meeting early last year or year before last. You remember the big law firms that we were told are looting the RAF? You remember the looting? So we're going to go through it together. Those are all the looting amounts. So I also have asked the Road Accident Fund to provide us with the number of cases. It's just not on this printout, but there's basically the cases, for instance, for the first firm of attorneys, DiBrolio Attorneys, about 2,600. So let's just talk about some of the amounts now, right? So in this case, with this first law firm, which is DiBrolio, there are 2,607 claims, thereabouts, 2,607 or 2,627. So these amounts, it was explained to us, have all been through the court. The claimants have won, and the court has awarded costs against the Road Accident Fund or to the claimant, right, via the attorney, right. Then these go through the taxing master, which means the attorneys make a submission to the taxing master to say, these are the things we are claiming for out of this case. And the taxing master says, okay, in the Road Accident Fund, the taxing master doesn't accept everything, they reject some. And then the taxing master says, okay, pay X amount of money. So all of these are approved by the taxing master. And just for attorneys in 2020, 21, 24 million effectively. 21, 22, there was COVID. It was 1.1 million. 2022, 23, 82 million just for attorneys. Advocates are also coining it. 12 million in 2020-21, a whopping 43 million in 2022-2023. Then you see the actuaries. In 2022-2023, is 12 million. Can you see that? Okay, those 2,600, some of those people, let's say, I mean, I can't remember what the number was for that number. That 12 million, according to your RAF 1 form, the claimants should have forked out of their own pockets. Yes, they've got to, because you must refuse to take their their form if it doesn't have an actuarial report. The medical legals, even more expensive, 87 million in 2022, 2023. Then there's travel and accommodation, sheriff and rate costs, and so on, right? And the totals are staggering. In that year, 2022-23, 229 million just to one law firm. Now, what then happens with these is that the lawyer takes their 25%, there's some other process that takes place, the rest is given to the claimant. Now, this is just the claimant's cost. The road accident fund is busy litigating at the same time, so this amount is actually possibly double. Because the road accident fund also has an attorney, road accident fund also has a correspondent attorney, it's got counsel, it has actuaries, it needs assessors, etc. Can you see that? Do you see how the legal costs climbed? Can you see? Were you ever presented with this at all as a board, or did you ever ask for it? To say, this is how we are leaking money to just one law firm in 1 year, 229 million, just one law firm in 1 year. No, if you are not, I mean, it's fine. You are not, right? You know what, by the way, this report never existed until I asked for it. That's what board members are supposed to do. I'm not even there. I knew to ask for this breakdown. Why didn't you guys ask for it?
I do remember the head of governance presenting a whole breakdown, but before then, these kind of reports, it might not be in this particular format around legal costs. They also served at offset, because that's part of that annual procurement plan to get a sense of who are we paying. I mean, at some stage, I remember we had the top 10 high claiming legal firms that we then had to unpack. Even at the strategy session, that was also presented. It was not necessarily in this particular format, but at least that we did engage. We wanted to have a sense ourselves. Who are we paying? Who's milking the system?
How was the cause of these payments explained to you? Because you know what you did? The one thing that the Road Accident Fund did in this period, it had no one representing it in court. The partner flow of attorneys wasn't there anymore. It was taking up to 8 months to hire a person into the internal legal team. Then they also didn't have a right to appear before the High Court. You remember all of those problems, right? So in this time, when the matter appears in court, there will be a default judgment because the Road Accident Fund doesn't have somebody there. Then next time it would apply for a rescission. But now the Road Accident Fund is litigating an extra step it wouldn't have. And then the court eventually, when the Road Accident Fund loses eventually, the court then says, you must pay the cost. This is how we get here. So when your former chief executive was appearing on every platform that would even look at him to say this money is being stolen, why didn't you ask him for a detailed presentation as to how these things were occurring?
Chair, we did ask for this information, like Dr. Mabuya was saying. It came at a different form, but the commitment was that they started, and I remember he used to talk about this first firm, the Proclear, and that we had to find out what were the root causes why they were being paid so much money. So there was a process in dealing with these specific cases. And we wanted to get answers and for them to be dealt with. But we didn't, it wasn't.
Did you get answers?
No, we didn't get all the answers.
We didn't get all the answers. Let me bring something.
Can I ask, before you bring something else, what Mr. Litswalo was saying in public about this being theft, is that what he told you in your board meetings? Because this is a serious amount of money for somebody not to be sitting in jail. Mr. Nell is sitting over there. If this was theft, I would expect the Hawks to have placed him under investigation. And you know what? I actually was diligent enough to ask for a list of law firms that are under investigation for theft and fraud and all of those things. You know what? Mr. Tibrolio is not on the list. But Mr. Litswalo was going around the country saying this is theft. So I want to know, what explanation were you given? Was it consistent with what he was saying in public?
I won't comment on what he was saying in public. I will comment on what was presented at the strategy session.
I do beg you, Dr. Mabuya, to comment on what he was saying in public, because you are a member of the board. The whole country is aflame with law firms that are stealing money from the road accident fund. You can't not be interested in that. I won't allow you to not comment. Please comment. When he was saying this is looting, did you ask him, did you report this to Brooklyn Police Station or Hatfield?
Chair, I didn't ask that question. Let me be upfront with that. But what I was aware of.
Sorry, Ms. Francois, did you ask him?
No, Chair, we didn't.
Ms. Msibi, did you ask him?
No, Chair, can I just, if you don't mind? Yeah.
So we'll come there. I just want Mr. Nyama to just answer on me on this, because the public is justified in being angry. Because when someone says X billion has been looted, people just want to tear off their shirts. I would. So you as a board members, you listening to these podcasts and interviews, you don't ask why charges haven't been laid. It's not a special board meeting that gets called to deal with one law firm walking away in 1 year, stolen 229 million. The next law firm, 172 million. The next one, 153 million. The next one, 138 million. Why wouldn't you ask?
Chair, I have already confirmed I didn't ask. So
I'm on the next phase. Why weren't you moved to ask?
Yes. So what really happened when the RAP's bill was thrown out and it didn't serve to be taken forward? One of the key things in the strategy session we asked, who was behind that? Why did it happen the way it happened? And that's how the list of these legal firms came to our attention, because it was in that context to understand what is happening. How come?
What were you told specifically? So when you asked how come, what does that have to do with these law firms?
Yes. So the law firms were presented to us specifically, Chair, to highlight why the bill wouldn't survive, because there's a direct conflict of interest in introducing this kind of bills. The list of the forms, Tibrolio is not the first time I'm hearing about it, but I'm even told on the day when the RAP's bill was being, he was actually there specifically. So there are these kind of things that we were informed on the board to say, this is the list, the top 10, and that's where the top 10 story came in. The top 10 legal firms that are claiming from the fund. The words that were used, it was not looting specific, it was that are claiming. And the point is that whatever regime of or change of legislation that's coming, they're going to throw it out because they are the biggest beneficiaries in the system. The ecosystem is there to feed them. That's real.
Okay, so I've got the explanation now. But we had a string of witnesses here. Mr. Phillips from the Road Accident Fund, Ms. Mampe Kumalo. I asked each of them about this. I've printed this thing numerous times. The members must be tired of me now. I've printed this thing numerous times. I've asked each of them, including yesterday I asked the LPC. These are court approved by the clerk of the court, the office of the clerk of the court. Following litigation, the claimant's lawyers submit this to court and say, we've won a case, we've been awarded costs by the judge. This is what we want to claim for. And the court says yes. So you were told that the only explanation you were given, and I'm going to fall over if you accepted it, the only explanation given is that this is some kind of scheme involving the court. Because if that's the accusation and you believed it, I am writing to Chief Justice Maya tomorrow. And you need to substantiate that allegation. So these are court approved. Everybody said so. Mr. Phillips has said so. Ms. Mampe Kumalo has said so. Mr. Tia yesterday from the Legal Practice Council said so. The Law Society said so. These are court approved because the Road Accident Fund lost cases. In many instances, it had no lawyer there to represent them because they were fired and nobody was hired to replace them. Each has a workload of 4,000 cases. You as a board accepted that explanation.
So, Chair, can I just say something? Part of my reason in terms of believing some of these, and it was basically we're given a case, and unfortunately, I did not prepare in terms of the cases that were given. And I remember a specific one around the Broglio attorneys, where the judge actually asked that the judgment be brought to the attention of the board, of the minister, and the minister as well, because what had happened is that, and I can't remember if it was also a hand, but it was a minor injury that by the time it got to court, the quantum had been inflated in terms of what had happened, and the judge indicated, I'll have to remember the particular case, because we were given that particular case as an example of how the lawyers fleece RAF, and in particular De Broglio. And that was one of the cases. Now I'm saying the judge actually took particular exception to how this case was conducted and therefore wanted it to be brought to the minister in terms of how the RAF was operating, but then also wanted to review the work of De Broglio around that particular case. I will have to find the case to bring it to you. So in terms of...
So what did you discuss McRobert Incorporated? McRobert Incorporated appears on the penultimate page. So let us just say on the basis of one judgment involving one case out of 2,600 cases, right? You took a decision that you're not going to ask any further questions. You're going to tar all of the judgments with the same brush to say they are fraudulent. But
no.
that is De Broglio. So I've chosen a law firm at random, McRobert Incorporated. They get 36 million the 1 year, 44 million the other, 50 million the other year. All cases they've won.
No, it wasn't only De Broglio. I just remember that particular case. There were certain cases that were made aware of, and some of them were predating our time in terms of how the system is fleeced. I remember one was a Museneke judgment in terms of what should happen in the RAF. So I'm just saying there were certain cases that were put in front of the board that demonstrated in terms of the fleecing of the RAF. Yes, it was not all in terms of these particular law firms that are present in this document. But I'm just saying we were given over time and not in one instance, different cases demonstrating.
Fraud, right?
Yes.
But you nonetheless don't ask about criminal charges. This is where I am confused. Mr. Nya.
Yeah, thank you, Chair. Thank you, Honorable Chair. I'm just trying to understand this document so that we can assist you.
I'm very happy to explain, yes.
Yeah. Let's take De Broglio as an example.
Yes.
Obviously, there are financial years there, I'm assuming, the
Yes.
columns, and there are products, there are categories.
Yes.
Are we saying that total at the bottom for each of this year, is this for default judgment and how many
No,
cases?
it's not default judgment. So let me explain the picture that has now emerged, right? The Road Accident Fund loses the capacity to defend its cases. One. Secondly, and the members have got the document, it also gets rid of 32 internal lawyers. You remember, Ms. Francois, I asked for the information and you guys sent it early on before we decided to do an inquiry. I can find it. So 32 internal lawyers are suspended, fired. Some of them have mental health issues. Some have since written to this committee. So the Road Accident Fund does not have internal capacity or law firm capacity. It's been hollowed. Right. Mr. Phillips, who heads up the internal litigation unit, is hired long after the decision to not have a panel of attorneys is taken. So the Road Accident Fund is a sitting duck at that time. So several things happen. There are default judgments. Then what the Road Accident Fund does is to apply for a rescission of the default judgment, because now they want to contest it. But now you've been to court how many times? Twice. So on the date of the default judgment, the Road Accident Fund was not there. The claimant had an attorney, had prepared, had advocates and everybody. They get there, there's no one from the Road Accident Fund, right? Default judgment is awarded. Then the Road Accident Fund gets the court order. They decide, we want to fight this thing. They run back to court. Now, this is a process that ordinarily wouldn't happen. They apply for a rescission. The judge grants the rescission, but makes a cost order against the Road Accident Fund because you were not here last time. We are now hearing this matter again. Now you go on to hearing number 3. In fact, I have a judgment here, and I've read it in committee, where the court says the Road Accident Fund in the one case applied for a rescission. Then the matter was set down for it to be heard. The lawyer from the Road Accident Fund rocks up there, and you know what the lawyer says? I don't have instructions, Judge. I will abide. The judge says, what exactly are you going to abide by? We're waiting for you to start making the case. Now, case dismissed. Another cost order against the Road Accident Fund, right? So what happens is, where the cost order would have been, let us say, 115,000 rand for one claim, it ends up being 450,000, because now the Road Accident Fund is going to court multiple times. No internal lawyers, very few internal lawyers, no head of legal, because you haven't had a head of legal for years and years, and then no panel of attorneys. This is how this happens, Mr. Nya. Right? So do you understand now how we get here?
Yeah, thanks for the clarity, Honorable Chair. I think the way you're explaining it, it does highlight the issues of inefficiencies. That's why I wanted to understand whether all of them are default judgments or not.
Default judgments. But you see, what I'm concerned about is your inability to ask the kind of questions I'm asking when you are working with the Road Accident Fund all the time, and I'm not. I'm not. I've got many other things to do here in Parliament. You guys are seized with the business of the Road Accident Fund. There are stories and stories in the papers about all of this here. You are sitting here today. You are only helped by my explanation of what's going on, because we have no clue. This is, and I'm sorry to use that word, because you were given a conspiracy theory and you accepted it. Do you realize that you are possibly hearing this explanation for the first time, but you were board members? This list is different to the list of law firms that are actually have been investigated for inappropriate claims. It's not the same list. These guys are not on that list. That is why I get so worked up about this matter, because the guys who are under investigation and have been referred to the LPC are not spoken about in public ever. And I don't understand that.
Chair, if I can mention the list, the other list, not this particular list. There was an issue of duplicate payments. That issue, when we picked it up, we as RAF, or the management of RAF, actually referred that We firstly tried to recover the funds through the management team. We also referred those attorneys to the LPC, and they also ended up on the list of the SIU. So it's something that was brought to our attention.
Yeah, Dr. Mabuya,
And that's a
we
completely
can canvass that after this. I just want to make a conclusion. Under your watch, the Road Accident Fund loses, let me, in fact, Mr. Nyama, let me give you a further explanation. So you remember that RAF 1 form that I was canvassing with you. So one of the things that happens additionally is that the Road Accident Fund refuses to accept a claim. Do you know what some claimants do? Who do you go to if you're not happy? You go to a lawyer, right? Of course. So, then more legal costs to force a Road Accident Fund to comply with court precedent and accept the claim. So you then get interlocutory applications. That is how we get to these numbers. So what's clear to me is that you never interrogated what was of so much public interest. You never did. We're doing it for the first time with you here, and you were board members. With headlines. You see, you should have been able to ask the kind of questions I'm asking, but you never did. I've asked for referrals to police station. These guys are not there. You didn't ask. So, when earlier I said we need to deal with systemic issues at the Road Accident Fund, I was talking about this because conspiracy theories, this theory of witchcraft, that someone here in Takata is not going to work. We're not going to help us solve the problem. That's what you were told and you accepted it. So let us then talk about your overall performance as the board. So from your own words, you had information hidden from you. You had fanciful explanations given to you. There were times when you needed to ask for legal advice and you didn't ask for legal advice at all. Do you still insist that you want to say you performed? Would you insist? Honestly, I don't know any of you personally. I'm not fighting with you. But this committee is seized with protecting public funds, and I don't like it that claimants get by the way, on top of this, the claimants still get the claim, ne? And the damages on top of this. So that 1 billion that you think, there's then the claims themselves, and then there's the Road Accident Fund's own legal costs. So, in the result, the Road Accident Fund used to finalize 250,000 claims plus with 43 billion. It now does under 80,000 with the same amount of money. Would you say that that kind of number, that kind of ratio works? Because to me it doesn't. These numbers should be tiny. We can't have money going to claimants for costs and attorneys and so on.
Honorable Chair, if I may. Chair, I don't want to be defensive, but I think Honorable Beasley raised the same issue. Again, I've referred to page 33 of the annual report 2023-2020. I just want to understand the connect between we used to service 200 and something thousand claims versus the 80,000.
Yes, so what has happened, and we can go to the latest annual report and the one from before together. So what has happened is that when the Road Accident Fund is not in court, to tell claimant Ibrahim, to tell the court that claimant Ibrahim, his or her claim of 8 million is preposterous. They're not entitled to that kind of money. They're entitled to 800,000, and these are the calculations we've done them. But when the road accident fund is not there, claimant X gets an unjustifiable amount of money and costs on top of it. That's the connection.
Yeah, so my apology, Chair, but allow me maybe to just get clarity, because I've tried to look at this number. I was trying to pay attention, obviously, around this. When I look at that productivity table, if we look at LOE, in 2018, the number of claimants we paid for loss of earnings, it was 17,787. In 2024, we've paid 19,484. So that number is stable. That's where bulk of the money goes in terms of the claimants. Again, when I look at the general damage, we used to pay 19,705. In 2024, we pay 22,391. That's the second biggest one.
You're looking at the wrong metric. So we examine legal costs, right? So we're all concerned with legal costs. The average value, the average legal cost per claim has gone up over time. So you'll recall the number I used was the road accident fund used to finalize X number of cases, right? Some of them rejected, obviously. It doesn't mean they're all paid, right? The road accident fund pays too much for legal costs. It does pay too much. These numbers are insane. Some of the reason, or a significant part of the reason, is that the road accident fund has no one to speak for it in court. That's what happens, and therefore it has to ask for a postponement, etc., until the matter is settled. So you end up with 8 court dates instead of 2. Then the legal cost per claim in that sense then goes up. That's why we are here.
Your Honorable Chair, I don't disagree with that analogy. I accept it. All I was trying to get to is that from an oversight point of view, the issue of default judgment, it was ranging between 3 to 5%. It felt not material, not to say that it's not important. But it wasn't alarming, but we still raised the issue with management to say we don't like this. How do we manage this? They gave an answer, and unfortunately that answer drove the legal cost up. But I'm reflecting from an oversight point of view, and I don't want to be naive or ignorant. From a materiality point of view, it doesn't sound too alarming for that number to range between 3 to 5% of the number of claims.
So it is 230 million in 1 year for legal costs to one law firm and its advocates and medical legal experts. Does that alarm you? Just one law firm. In 5 years, R1 billion.
Honorable Chair, it alarms me, but in a different way. It alarms me in the sense that on average, for someone to access or for a claim to be processed within RAF for whatever loss costs there were there, on average is close to 100,000 just to put a claim. So for me, that's my alarm, and I don't want to give the excuse, but I'm saying that why is this gap from a legislation point of view? I accept that there are contributions where management created inefficiencies, but I'm saying that the driver of that cost, we cannot attribute all of it to that inefficiency. I think because of the nature of the claim, you need an actuary, you can't run away with.
I get that, Mr. Nyama. All I'm saying is, when a matter, instead of 2 court dates, takes 5, that's a problem the board should interrogate. Because even if this was not ordinarily presented to you, the moment it made it to TV, it should trigger the board to now dig into this. You understand? What's clear is that the board never did. which is why we're only ventilating it here now. That's all I'm saying. Unless, and I don't think this is what you are saying, that, look, these numbers might appear alarming, but actually in the bigger scheme of things, they're not a big deal. If we use a materiality test, I don't think that's what you are saying. Right? So, all I'm saying is that the board didn't then deal with these matters, even though they were in the public domain. And I just want to say that please reflect on these matters. The delegation that gets passed on and you don't know, everybody acting and you have no say in the appointment of executives and they're acting for 3 years, vacancies unfilled for years, and there's an acting person when the board is supposed to appoint a permanent person and you don't. All of these things you did not know, a litany of things you did not know. I am in Parliament. I receive an annual report as an MP. I start digging into that annual report and all of us end up here. It can't be that I'm able to ask these questions and the members are able to ask these questions and we're doing this part-time. And you guys were doing it full-time. We will have to draw our own conclusions as the committee. The final thing I just want us to deal with, because I do think it speaks to rights, and I just want to give you an opportunity to comment on the conclusion. So this is what occurs under your watch. People who were able to walk into a road accident fund area, the road accident fund facility, even if it's a small one, have that taken away from them. The critical education they need through radio and everywhere else in order to be able to know how to find the rough and where is taken away. The process of lodging a claim is made more expensive. Which means access has been limited. That's one. The second thing is you have a management that basically keeps board oversight away by hiding information from you. And we've gone through several instances. That's number 2. Number 3, there is an instance where, lots of instances where there are lots of acting positions and you guys have no idea who these people are. And that situation persists for years. And you don't put a stop to it. I'd like each of you to comment on that, because again, the vacancies, the reason they become an issue is that we saw them in the annual report. And they were screaming red flags. So this is what has happened. Limited access, claimants and law firms getting big sums of money, no head of legal in a litigious environment for so long. To this day, there still isn't. No lawyer heading up the legal department. Ms. Mampe Kumalo is not a lawyer. She has got an MPA in HR. This all happens under your watch. And I'd like final comments from you.
Thank you, Chair. I'll start. I'd like to state that oversight, I think maybe let me start by correcting that we were there working full-time. I think we just need to correct the narrative that we did not work there full-time. I mean, we also, an oversight, our responsibility, it does not necessarily mean that we're there all the time. But some of these questions that were raised, we did not get the answers. In fact, we did not have investigation capacity as the board, because as a board we get, I've stated this earlier on, assurances from different assurance providers, which we did not get. I mean, if you look at the past annual reports, these matters were not raised by the AG. These matters were not raised by internal audit. Now that we're looking at it from an investigative perspective, then you get to drill down to information that would have been dealt with by auditors, for example. And they gave us different assurances in terms of what was going on at the time. So I think it's very important then to highlight that we've discharged our fiduciary duties to the best of our abilities and made sure that the best interest of the RAF was took priority. And that we were not conflicted in the RAF matters. So it's very important that everything we did, and also trusting management in good faith, because there was no reasons for us to say, when management presents certain information to us, to doubt them and then ask for investigations. Where there was clear information, we did, and I think we've answered that question very clear, that we did not just accept anything. We did probe. We asked for additional information, we asked for legal opinions, and we went through all of those to discharge our fiduciary duties. The acting positions, I think it's just that one lady, and to be honest, Chair, we were not there throughout the whole time. Our board started in 2019, and that CFO, I don't think she worked for longer than 6 months in our first year of office. That's why we don't remember her. But we remembered all the acting positions. When we raised these matters of executive vacancies to the CEO, and we understood as well the rough environment. The rough environment, it was difficult to attract people in those positions. I mean, there were a number of times that one position, for example, the chief claims position, it was advertised several times. Benchmarking was done, and the one time we didn't find any qualifying incumbents. The second time around, I think the person was found, but then they did not accept the offer. Then it went back to the process again. So RAF, in terms of its nature.
So what about the head of legal? I mean, South Africa is flush with lawyers.
Now, I'm coming
You're
there.
coming
Chair.
there.
I'm coming there.
Okay.
So, but what we've asked in terms of risk management, we always ask, are the people that are acting, do they have sufficient knowledge and experience to actually cover these positions and produce and execute what was needed from them? For example, the head of legal department, there were advocates within the department that were acting in that position, then basically taking care of the legal requirements in terms of them executing their duties. The head of corporate governance was not a lawyer. I think Ms. Mampe was, yeah, she wasn't head of legal. She was head of corporate governance, and she had governance experience. So I think that needed to be done. But other positions as well.
Sorry, Ms. Francois, I do want us to canvass this legal issue because you're glossing over it.
Yeah.
You were in the meeting.
Yes, I'm coming back to the legal head. But I think the bottom line was that the acting person was a lawyer and experienced. I think she was an advocate. I think we're confusing the head of legal.
No, I'm not confused. So let me show you that I'm not confused.
No, that's fine.
Let me show you that I'm not confused, and I insist on showing you that I'm not confused, because then we're going to ventilate this issue properly. If you recall, I asked that we get sent the people that were the two senior lawyers, the people that were said to be senior lawyers. I asked the question, if they are so good, why aren't you appointing them? Do you recall that conversation? Yes. So it doesn't help you to tell me there were people there. The reality is that there was no incumbent in the role, right? So if the chief governance officer is not a lawyer, the board is going to make sure there is a solid lawyer helping that chief governance officer, and you failed to do so. You failed to appoint a person in that role. It's the truth, because to this day, there's still no permanent person in that role. You can't say you solved the problem when you never appointed anybody.
Chair, from my side, the report you shared with us, it's part of the big challenges that we faced as a board. But I do want to map up an ecosystem of the Road Accident Fund. We were operating in an organization where there was always underfunding in terms of the fuel levy remained at 218 cents for 5 years. We were discharged with an opportunity to try and minimize costs and avoid day zero, which was a quick issue, which was a very important thing. On the annual report of 2024-2025, the year we were dissolved, we increased, the revenue itself increased from 48 billion to 50.1. So I'm just saying that report is one of the key parts of the ecosystem. The holistic view, one of our issues is that we were operating in this underfunded mandate. We tried our best as a board to expand the footprint of claimants to get access to the board. And I take your point on the RAF 1 form. But what is important, there are interventions, including the contact center, the digital platforms, the in-service points that we did not completely close, at least as a board. We never said this must close. So that's part of that access that we are talking about. There are other issues that also form part of that ecosystem. Total claims paid. The annual report is audited by the Auditor General. It talks for itself in terms of how much was paid, and over the last 5 years, payment was 215 billion. So let's not, I hear you, you are uplifting one part of the, this is a complete ecosystem. Compensation to employees, there is a figure that is fully audited. It's not necessarily a figure that one cannot necessarily underestimate. So I'm saying the issue around where the money went and where we didn't necessarily become strong in the oversight should be viewed in terms of the full ecosystem, because there's issues around cost to income ratio that we were ceased to deal with them. There's an issue around claims requested, not yet paid, that we had to take care of. So I would say this point is valid, and I'm not saying it's wrong. But there is an ecosystem that in terms of where we're working, where now we are being put in a light that we neglected our duties completely. What about the rest of the ecosystem? The second thing I want to come to is vacancies. RAF is a difficult environment to employ anybody. And by way of example, the dissolution happened in June or July last year. The interim board appointed Victor Songelwa. He didn't last. He resigned. Currently, we have the previous head of internal communication acting as a CEO. That was internal audit is a very important function in organization. Independence is critical. And I'm wondering, with the vacancies being filled of the CEO, is he going to be allowed to go back to being an independent auditor? Because at some stage, he's going to audit his own work as an acting CEO. The executives were depleted. So we are seeing that same pattern continuing. It's a difficult environment. Professionals don't want their names, basically smeared all over the newspaper. We are battling to get to work for this. Even on the board, people don't come running to say, I want to work. This is a board full of bad reputation. So honestly, to sit and view us as people who never cared, I don't think it's fair on us, Chair. I don't think it's fair on us.
So Dr. Mabuya, I acknowledge what you're saying. And I have first used stronger language about the unsustainability of the Road Accident Fund. It's underfunded, and the mandate is a delusion. It's a complete delusion, and Parliament has failed. I accept that. I put to all of you specific instances, and when I put specific instances to all of you, I'm not saying you achieve nothing. I am saying what we know, because these are very critical matters. I think we can all agree that access to government services is important. The principle of expanding that access rather than limiting it is something we all accept. What has happened during your time is that even the means to access knowledge were taken away. I'm not saying you did it, but it happened. We discussed it this morning, that it went against what you had approved. But it happened. We can't run away from it. I'm not sure what you want me to do. We agreed this morning that the board took one decision, something else was done. The board never knew about it after. We know that. So we agreed. You said these documents, Mora and so on, were never shown to you. I didn't blame you for not being given information. So I don't want you to get me wrong, but the reality is there are also instances where there were issues, because when you fight against the Auditor General, the members here have used the term and said the Auditor General is the first wife of the Committee of Parliament. You ask Auditor General first. So if I am going to take on the Auditor General, I want senior counsel's advice. What's clear is that the board never asked for it and it never received. You had your own attorneys. It's different to senior counsel. And in that matter, the Road Accident Fund has lost each time. So all I'm saying is that we can't deny these things. And so I can't sit here and say access to the Road Accident Fund has improved. I think we all agree it hasn't. Outlets have been closed, not spending so much on education anymore, and you need up over 100,000 sometimes just to register a claim. We agreed earlier. So Dr. Mabuya, please don't get me wrong, I'm not saying the environment is not difficult, but we can't ignore these matters. And I wanted you to address the committee on those specific matters, because they speak to our conclusion. But if you want to talk about other things, it's up to you. I would much rather capture your views on these specific matters on which we are going to conclude.
Yeah. Chair, I think I've just, specifically I wanted to highlight the issue of board vacancies, the acting positions. For me, I've got the benefit of hindsight on is that we need to strengthen the policy, the resourcing policy around the fact that if you've been appointed to do a certain position and we give you delegation that comes with a budget, we then need to close the gap that in the event you are unable to carry out that delegation, you can't transfer that to somebody else. I think that's really what I'm bringing in terms of some of the big gaps that I'm seeing. So it's a policy matter that we need to go back and reflect on, and we hope the people who are there are identifying, because that is really where those huge expenditures, especially around the CFO, just deviating from 500 million to 60 happened because we never tightened the governance around the policy that this is not a transfer. It's the same thing with the ticket we got to come to Parliament. It clearly stated, this is for Mabuya-Moloele. It's not transfer. You can't claim cash. That's clear. You can't do. So those are the things that I'm learning to say in terms of the policy, big gaps, and we have to tighten that part. Secondly, the other lesson, it's the act itself. The act has got inherent risks. We won't be able to eliminate everything in one go or in one sitting. We have proposed what needs to change because we have full benefit of hindsight of where the loopholes are sitting and where the abuse is sitting on the service provider side. That's really where the gaps are sitting, and we need to do something to strengthen that. I'm not sure, Chair, if the RAPSA bill is an answer, but I am inclined to agree that if we define the benefits in terms of we can only pay so much, annuity-based, there are exclusions that we put up front, that could start addressing some of the long-term sustainability matters. Thirdly, how we appoint board members, Chair, is an important issue. In reality, the ministry needs to relook at its whole process. We had board members who were first-time board members on the board. I don't think that's acceptable. You end up having an issue of forever being a developmental board, and we have contentious issues that we need to deal with.
So the appointment of board members is a key matter that the department needs to look at, and even Parliament in your oversight. Maybe we should go the route of the SABC, where people come and present themselves, we test them and check exactly what are they made of, because part of weakening governance is appointing a first-time board member to a board like the Road Accident Fund. That's a weakness in the system. Fourthly, we are not even thinking about what is happening in South Africa. Currently, I read a report, I think it's NAMSA, the people who do cars, automotive industry. They are saying 73% of South Africans are pivoting towards EV cars or maybe Chinese-made cars. That talks to us, Road Accident Fund. Our revenue comes from the fuel levy. If people are pivoting into EV, what is going to happen? I mentioned a figure of about 50 billion. That's going to be eroded. And we learned that through COVID. Our revenue was completely eroded. We are not even sitting thinking, what are other alternative sources of revenue to sustain the Road Accident Fund? There's an issue of what are the alternatives. That is an important discussion that takes us forward to say, if this slows us down, that is really how we must then think about alternative revenue sources. That's also important. Fourthly, the people we appoint as senior executives, those are normally taken based on the degrees or the experiences they have. But what is becoming important in an environment like the Road Accident Fund, when we interview senior executives, it's important to check for the strategic fit, cultural fit, because you could be good wherever you come from, but you lack people skills. You are not necessarily a good fit for the Road Accident Fund. So there are things that we are basically going to also, when you send your report, we will recommend to help you move forward. But there's a lot. And fourthly, when you dissolve the whole board, good governance doesn't support that. Not everybody on the board should have been dissolved. 50% or 40% of board members should have been retained for institutional knowledge. Right now, we have an empty executive team. We have a new board. They are forced to be operational because they don't know most of the things. So that is a ministerial decision. So we have to think about those things deeply because emotional decisions erode value in what was built. Another point, Chair, and I will pause after this. We are humans. We can only do so much based on the trust that we had. It is clear from this presentation that some of that trust was eroded. And as such, not everything came on board. We worked on the basis of good faith, and we basically did that in the powers that we have. The reality is, people are people. There are things that were hidden from us, and it's a reality. And we now know all these things. They've been ventilated in the open. And from that, we then need to reflect in terms of sometimes having huge qualifications versus your character or your ethical conduct are two different things. Your character emerges when things are down, when you then want to know how come we are where we are. And I use that example when we had the cybersecurity attack. Where I was sitting as a board member, I wanted to fire everybody because that is something we should have anticipated. We are dealing with claimants. Claims are in an environment where you need to protect everything. And here we are being told a story that there was collusion, there was that, there was that. So for me, those are the things I think when you send your report, I want to strengthen and say we need to change this whole act and make sure it becomes people's friendly. And things that, the forms that don't support access to the claimant or us, we must do away with, and we can't fight the courts. The courts have pronounced on a lot of things, and I think the reality is we can't be fighting for the sake of fighting. We need to be responsible citizens.
Thank you. We'll get the transcript and just do a copy and paste, Dr. Mabuya. But thank you very much. Thank you very much for those recommendations. It also gives us some points to raise with the minister and deputy minister when they're here next week, because the issue of leadership decapitation is a concern, because you had people taking decisions, you had a whole group of people, including a board, and then poof, they're gone. You always have to be careful how you transition change that's just one of the things that you've. The other issue that I'm very happy you've raised is we've raised also in committee is that the Road Accident Fund is a 50 billion rand organization with many complexities, with technology, with legal issues, with customer service issues, etc. Multiple channels, it's national. You can't have somebody who's new on the board or was on the board of my local football team. They must start somewhere else, and then eventually you are good enough or strong enough to be on the Road Accident Fund board. So I'm not just saying this. The insights that you've given to us are really valuable. And if you do think of something before we give you the draft report, please send it. And that applies to all of you. Please do that, because we all have, as I say, with hindsight, you get 20/20 vision. Yes, and that's where I'm sitting. I wasn't in the smoke. Yeah, so I do appreciate that.
Thank you, Chairperson, and thanks, Dr. Nomonde, for those pointers. I actually agree with that. But I think I'm just trying to look at your last comment in terms of us now and reflecting. Obviously, I will just touch on the three that you raised. Obviously, as we indicated in the morning, limiting access was never part of our agenda, whichever way we look at it, and that's why we are passionate about it, and in terms of giving reasons why we took certain decisions. In actual fact, we always said, how do we increase the footprint of the RAF beyond? We're not comfortable with just the regional offices, because we understood that people, not everybody has access to mainland, for example, let's say in the Pretoria region, in terms of getting to mainland. So I'm just saying it was never our intention. Retrospect, our decision did not achieve what we wanted to achieve. So I think we can agree to that. Yes, information was hidden from the board, and we can look at it in different ways. And I think we've given the reasons, but clearly information was hidden from the board. Acting positions, we can go up and down in terms of what we did at RAMCO, at the board, because I also sat in RAMCO, and I remember those discussions around the acting positions, around the vacancies, around the suspensions, etc., in terms of why we have such high numbers. But the fact remains that we had those. So for me, I think it is how, and in terms of now going forward and reflecting, how would we exercise oversight differently, but still not stepping on the operational issues, and because we're always trying to balance the two, that even though we exercise oversight, we may get operation information, we do not want to get into operations, because we would not be able to understand all the complexities sometimes of the decision. So I think that now is one of the things that we'll have to reflect on and make recommendations around in terms of a board in this complex environment. As we've said, it's a 50 billion rand industry with complex issues. And I think that's part of the thing. We're juggling all these complex issues, and how do we bring some of them to the attention of the minister, for example, the EVRs and etc., those kind of issues that are coming in the future that are not being looked at now. So I think we'll have to do some introspection around that particular issue with my colleagues in terms of how would we have, in retrospect, how could we have exercised oversight without stepping into operations, but in a complex manner, and become more effective. Thank you.
No, thank you. And I really am not saying declare yourselves guilty, but sometimes it's out of a robust exchange that all of us kind of begin to appreciate some of what we deliver. So please, to the extent that there are gaps, and again, it's not you individually, boards are bodies, and we talking about this in that collective sense, and recommendations for the minister, recommendations for the portfolio committee on transport, recommendations for SCOPA, recommendations in terms of policy within the road accident fund, right across the issues that we've been traversing. We'd be grateful if we could get those. Mr. Nyama, I'll give the final one to you.
Thanks for the opportunity once more, Chair. I think all the points that you've made, they are valid. I maintain the view that no one is perfect. We can always learn from the past and do better in the future. And I hope that those that are in charge at the moment, they can learn from some of the things that we could have done better, and they do better. Having said that, Chair, I reflected this painfully around RAF. I remember the very first risk assessment that we did. I think there were around 9 risks, top risks. All of them, they were severe, I think severe and high. There was nothing medium and nothing green. So that's what you were dealing with at that point in time. So you can imagine juggling 10 balls is different to having to juggle 2 balls. We've done our best, Chair, to our best ability where we could. What I was encouraged by being part of the board is that we always acted in good faith. And perhaps sometimes we're too obsessed about the claimants and then some of the stuff in trying to impress the claimant, they fall off along the way. Strategically, we had a strategy in place as the board. Did we do an annual risk assessment? We've done annual risk assessment. Did we have subcommittees to help with monitoring and all sorts of things? Those things were in place. Did we do self-assessment using independent person, IOD, SA? Yes, those things we have done. When we inherited the place, if I recall very well, Chair, there was only one executive permanent, the COO. The CEO was not permanent. So all I'm trying to say, Chair, is that it's a multiple crisis. I think what I've learned is the risk management processes, they won't be adequate to get RAF to function very well. But thank you for the opportunity, Chair. We have learned quite a lot today, and we will do our best to try and do a write-up to your committee. Thank you.
No, thank you very much. I just want to say to all of you, so South Africa struggles with getting good people to serve on public institutions. So I do want to say, notwithstanding the tense exchanges we've had during the course of the day, I don't take lightly people who nonetheless choose to go and get involved in a public service institution, especially as professionals. And I think too often that's taken for granted and underappreciated, let me say that, gets underappreciated. I think differences of opinion about decisions and so on, it's in that tension between parliament and institutions and so on that things begin to crystallize. So I just want to say to all of you that I get passionate, and this is for me personally, I get passionate sometimes, but it doesn't diminish the appreciation that I have for having stepped forward, basically, to say this is a difficult place, it's in crisis and so on. My health would be better served by me just sitting at home and not taking this thing up, but nonetheless, you do step forward. I do want to say that we appreciate that just out of these exchanges, even other people who can see, I think they're also learning, we are learning. Dealing with COVID is something that we've now forget, but at the time, everything was on Teams. You can't see each other. You're scared of getting sick. There are big decisions to be made. Family members are dying, etc. So I honestly do appreciate that, and I do want us in our report to take those kind of things in context, right? Because it might seem easy later on, but it was difficult. So I want to just state my appreciation to all of you, spending an entire day here and part of the evening with us. I do hope you get some good rest and that your flight is not too early tomorrow. that you can head home. Honorable members, will you get offended if we adjourn? Honorable member usually wants to go on until about 11. So please don't put up your hand. You're fine, we can cut. Okay, sorry. Honorable Atkinson, please, 30 seconds.
Yeah, just want to make one final comment. Apparently, the Supreme Court of Appeal is making a judgment on the discovery case on the 16th of February. So it's going to settle Honourable Mente, who is very concerned that discovery might have...
We can have a watch party at your...
Exactly. She's very concerned that discovery might have committed a terrible crime. So we'll hear on the 16th anyway.
Okay, no, thank you very much. Honourable members, thank you very much. I thought we'd leave earlier, but we didn't. My apologies. Thank you. Tomorrow, so we are traveling tomorrow. I'm just going to make sure I don't want people looking at me funny tomorrow. So I will make sure that everything is in place. So I'm not going to sleep just yet. Thank you very much. And thank you once again, chairpersons and Mr. Nyama. Thank you.